Good morning, everybody. Happy Monday morning. So here's the deal. We will be on the move today. I have everything set up to go on for the trial. I'm going to get it on the screen now. Ashley is on her way to get me. So we will do what aggravates me is a lot of these channels, law and crime. Here we go. Let me make this bigger and get rid of this top chat crap over here. We want to get this at the biggest it can be. Yeah, blah, blah. Notify me. The problem is sometimes they change the... Okay, but where's the thing to make it bigger? What's happening here? That's the problem that done pisses me off is... Like, what's happening? Why isn't it... Let me see if that same thing is happening over here. No, I can make this bigger. See, that's the problem, right? On Law and Crime right now, this is what they do. They set this up, right? And then I'm going to have to take this one down and go with Court TV. Good morning, Kim. Good morning, everybody. For some odd reason, Law and Crime puts two out. They put this live coverage thing out, and then they change it when it's actually live. And obviously I need it live before, I need it on the screen before I add myself as it's like another person on here. So we're going to have to go with Court TV today. All right, let me get it up here. I have both screens going here, so excuse me if I'm looking over here for a minute. All right, so this is at its biggest right now. I need to unmute this. We're at full volume on that. Yeah, you can. Like I can here on Court TV, but I can't on the Law and Crime one because the Law and Crime, what they do is they have it there, and then when they actually go live, you have to go to a different page. It's weird. I don't know why they do that. I honestly don't. You can. It's just strange. I can right here on Court TV, but I can't on the Law and Crime one. So I don't know. I prefer Law and Crime, but if this is what's going to, I mean, I have Law and Crime up here on the side here in case when I'm gone, I can have my husband move it if need be. So we'll see. We shall see. I'm not sure why it's doing what it's doing. So I'm just gonna keep it up here just in case. All right. We have ARCCA today, guys. That's going to be real interesting for damn sure. Like that is something that I can't wait to watch because I already know that it's going to be explosive. We know that we're going to get quite a bit of information out of what's going on with them. I want to know if they brought any of this evidence that they were ordered to bring with them, right? Shut your camera off. Yeah, I'm gonna shut the camera off and I'm gonna mute it. So I'm gonna add myself on my phone. So yeah, he doesn't come in here anyway. He's in the living room or bedroom or kitchen and come here anyway. This is like a playroom / streaming room. It's like two separate areas. Like I do my crafts over here. My daughter plays in this area. So there's nothing in here for him. But I am going to mute and stop the camera so that I can add myself here. Otherwise, you would just hear echoes anyway of like, you know, maybe a TV in my house or whatever. So I do. Thank you, Jesse. I do. Drinking my water. Trying to be healthy. You know what I mean? I haven't had coffee yet. That's a no-no in the morning. Not having coffee yet. But I figure I will grab it while I'm out. It gets made better anyway. You know? It should be, Lou. Very interesting. I can't friggin' wait. Like, yeah, see, that's just them, like, pandering to what they think they want to hear, to be honest. Like, there's a very real possibility she could exclude them. Will she? Probably not. Is there a possibility she could? Yes, there is. And if anybody is saying that there isn't, they would be lying. Like, you know what I'm saying? But I do think that Judge Canoni is kind of sick and tired of the bullshit. Let's be honest here. She's kind of sick and tired of the BS. And I do think that she will do something. What that is going to be? Yeah, exactly. No sticky sticker on top of my coffee. Can't stand that shit. Well, that's the thing. If they show up with no information, no emails, no nothing, it's going to be very, very shady. And the judge is no idiot. Okay. So what she does then is going to be interesting to see. I agree with you, Lou. I think she should probably grab some backbone, but I also think that, like I said, she's probably sick of this crap at this point. And I do not doubt her putting a lot of really like stringent circumstances on them being able to say or do anything, you know? They're not going to be able to say they're independent. That's for damn sure. Like that. I agree with you, Kim. I do think that she should have been sick and tired a long time ago as well. I would have been. Morning, Ellen, my friend. Long time no talk. I stuck to Ellen this morning. But I do think that they would be sick and tired of it a long time ago if I was the judge. That's for damn sure. It doesn't seem like she's always sick and tired of this. I would be. Law and Crime Network is live. Okay, so we can switch to Law and Crime. Perfect. Wonderful. Fantastical. Let's do that. I like that one better anyway, to be honest. We get Karen Cam. I like the Karen Cam. Now I can make it big. Interesting. I'm going to get this one off the screen. And I'm put Law and Crime up. Morning, Daniel. Share screen. Law and Crime. Here we go. Make sure I unmute this. Oh, it is unmuted. So let's remember this, okay? While this is on and I'm not here, I will not be able to mute this. So if they all of a sudden put their audio on, we have no choice but to listen to it. You know? I know, right? I love the Karen Cam. I am using both screens. Yeah, I have this one here and this one here. So right now I have the Law and Crime stuff on this one, and I have you guys on the chat in StreamYard on this one. So I got the best of both worlds going on here. I can see what I'm doing. Maybe, maybe not. I mean, it wasn't filed in this case. And so it's, I mean, maybe, possibly, you know, it's a very real possibility. Oh, no, I am. I'm bringing myself mobile, Jesse, because I have to run into my doctor's office and grab my medication that was sent there. So I have to go there. So it takes like a half an hour to get there. And Ashley's bringing me. So I have to add myself to my StreamYard on my phone. And so I have to share the screen here before I leave because you can't share a screen on the phone. I can only share myself. So you guys will still have me. I'll just be mobile. I have my headphones just in case the audio on the phone isn't working well and we need the headphones. But you guys will still fully be able to hear all of this that's going on because my computer will be running at home with all of this on it. Oh my God, you have no idea. I appreciate you, Kimosabi. It is so much easier with two screens. So much easier. And now that you taught me how to click and drag what I want on this screen, now I know what I'm doing. Yeah, I'm going to stop and get coffee on the way home too. But you guys will have me the entire time. Don't you worry. Don't you worry. Plus, when I go into the doctor's just to grab the stuff, they'll be doing testimony anyway. So it'll be like I'm going in, getting what I need, and coming back out while testimony is still happening. So you guys won't even miss me for a few minutes, you know? I have mods. That's what I got mods for. She should get an orange outfit. Justice is coming out. That's absolutely right. Justice is always slow, but well, they only wake up and see the facts when, like, you know, they actually listen. I do find that a lot more people are listening nowadays. How many? I'm in the United States, but the UK, I think, is, what are you guys, 6 hours? Is it 6 hours? It's 8:41 a.m. here. It's a state police on his bike. I think it's either that or Dedham. I think it's, well, maybe it's Dedham. It's got to be Dedham, right? Dedham PD. Dedham PD does an amazing job, by the way. Everybody should give a round of applause for Dedham. They were really great the first time. They were very nice. They were, you know, they weren't assholes. Like, and sometimes they have to be because nobody listens to what they're supposed to be freaking doing. But they were great. They were really helpful. They made sure nobody followed us back to the cars, which was nice. So we appreciated them. Karma is a beautiful thing. Such a beautiful thing. Such a beautiful thing. Also, before I leave, I'm not gonna be able to publish it while I'm gone because I don't think I can do it from my phone. Maybe I can, maybe I can't, but let's all remember that, the channel only survives on donations from my viewers, and we don't have monetization yet. We're still waiting on YouTube on that, so if you can donate to the channel, it's very helpful. You can also hit the like button, the subscribe button. You can share the video. That also helps the algorithm and people find us. Oh, the rock. Yeah, the rock that wasn't there. Yeah, it's not gonna cause a mistrial. People are so stupid. The rock that they think is gonna cause a mistrial that isn't. Oh, Hank Brennan. Everybody give a round of applause for Hank. Hank. There he goes. Look at his folders, bro. Look at that folder in his hand. That thing is freaking stacked. Oh, I don't know. This is a good question. I don't know. What happened? McLaughlin. That was her name. McLaughlin. Right? Did the rock fall off the dog? Did it? I don't know, but if he is, he's trolling them. Here comes the defense team, and they're all defeated glory. In their defeated glory. Alessi looking lost. Karen goes up the like, she can't go up the stairs like everyone else. She's gotta go up the ramp.
It's different.
Yeah, exactly. Slime team. They're gonna have a lot of answering to do today, guys. A lot of answering to do. Right? No, no FKR security detail there, Bubs? Because she can't possibly walk upstairs like a normal person. Why would you need to do that? Today's going to be quite interesting, folks.
Somebody get in your way. I kind of lost
The state troopers out there with the Dedham PD. They sort of cut their audio, but not quite. I can still hear a little bit of it. I can still hear him. Good question, Brooklyn. I don't know. Apparently, she can't walk upstairs like a normal human being. I do think something happened, but I honestly think it's AJ's wife who's like, you better distance yourself, sir, before you come out home to all your shit outside. Morning, Jezebel. It is the weirdest stuff I've ever seen. Why would you? They cut their feed. Why would you be on a computer? Oh, Fanny, y'all. Snaps for Fanny the fan. I would have flipped out if I was his wife, to be fair. That's different. Yeah, the guy's like, that's different. Like, yeah, Karen avoided them because she knows she can't keep her mouth shut long enough to not say something that they could use as a clip in this trial. Yep, exactly. You said it just as I was saying it. You popped it up. Like, oh, she shouldn't be confident. I wouldn't be if I was her. Like, questions will be asked, especially about ARCCA, and she don't want to answer those. I guarantee you they avoid the media today like the plague, especially if it goes as the way I am thinking it's going to go for them. Not going to be very good. Not very good, not very good. Right? Cue documentary. Like, cue all interviews that she's done at this point, you know? Sad state of affairs, if you ask me. Sad state of affairs. I should add myself to my screen now before Ashley gets here. Hold on. Let me mute myself for a second so you don't get the echo. Let's hope. Oh, damn it. It's going to be muting. Hold on. I got to shut this one off. That should do it. Oh. I heard something. They put the audio, then they cut the audio. Shadow banned? Shadow banned. I would hope not. Oh, does YouTube keep holding your comments? Is that what's happening? Fucking YouTube, dude. They better not. That's really obnoxious when they do that because I have no idea how to like undo it. Karen is going to be dealing with, yeah. I've noticed that as well. Victoria George being MIA. Right? That's weird. But again, StreamYard does that to me when I try to write the F word. It won't let me. It won't let me say fucking, so it will hold my comment. To be fair. Yes. It's me. Does it to me too on my own show. Imagine that. Like, can't help it sometimes, okay? It's not my fault. Like, it's not my fault. It holds even the host's comments sometimes. Sometimes I have to write it out 3 times and spell it out. It's kind of obnoxious. We can see things on the screen, but there's no audio. I hope the judge does limit Alessi's time, because if she doesn't, he's going to go on and on and on, and the jury is going to completely lose him. Ooh, no. Definitely be careful. Definitely don't want that. Yeah, I mean, they do it to me too, guys. It even happens to me when I'm trying to type to you, when there's like stuff going on the screen and I'm muted. I'll have to write it like 4 or 5 times. Sometimes I just give up because the big red letters pop up that tell me that they won't accept my comment. YouTube won't accept my comment. Like, screw you, YouTube. It's my show. I'll write whatever the hell I want. How about that? How about them freaking apples? Oh, no. Don't worry me. Now I'm going to worry. Now I'm expecting a text message if anything happens. Ma'am. If you have to get in a tub and put a mattress over your head, I'm expecting a text. I had a friend who lived in the Midwest, and literally all summer long, she'd be calling me from like the bathtub. She's like, yep, so I'm in the bathtub again for this tornado thing. And you could hear the sirens going up. And I'm like, my God, we don't have those here. So it's really strange to like hear it. You know what I'm saying? But you would hear the sirens all going off for tornado warnings. And she'd just be like, yep, so I'm back in my basement or in my tub again. Like, that's obnoxious. That's so obnoxious. Yeah, see, I can't. I wouldn't be able to do tornadoes. But then again, I guess people who live in like Hurricane Alley probably are used to dealing with those as well. You know? Yeah. Right? That lady's got some serious issues, huh? Ashley's going to be here any minute, guys. Probably 3 minutes away. So in 3 minutes, I'm going to mute myself from this screen. I'm going to put myself on this screen. And you guys are going to come with me. I remember that. And then I remember being like, thank God I'm not in friggin' Western Mass, you know? Like, yeah, South Carolina. I have a friend that lives in North Carolina. I have family that are in Florida. Ashley's here. All right. I'm adding myself to the screen. I'm muting myself here. Can you guys hear me now? Oop, I'm going to mute. Okay, we on a field trip now, y'all. So I want to make sure you guys can hear me, though.
I don't hear nothing.
Why is... Oh, you want to know why?
Nope.
Because it's just... Yeah, it's just me. It's disconnecting from my house. Sorry, guys. Disconnecting from my house Wi-Fi to the regular Wi-Fi on my phone is what it's doing. So it was buffering on my end. My bad. Okay. So this is going to be quite interesting today to see what happens. Court should be starting any second, but as we know, sometimes Bev is, late to the show. But as soon as she starts talking, I have the volume jacked all the way up. So, I mean, it's as high as it goes. Sometimes it's still hard to hear if they're not near the microphones in court, but, I mean, it should be fine. So, he knows the computer's running at home. If we have any technical difficulties, he is at home to try to fix it for us, although he is not a tech person.
You are with me. There's definitely technical difficulty.
True that. True that. We're just beautiful disasters over here, guys. It's fine. Like, I you to turning my camera on because all you'll see is like the
The shit in the back of my car. Tell the truth.
There's nothing back there. There's nothing back there.
Oh, good. I threw out the dog's poop. I'm good.
No, the sun. Like while we're driving, all you guys would see is like as you can see, all you're gonna see is like the sun coming in through my face, and so that's not gonna be helpful.
Brianna, I love distracted driving.
I'm not driving.
I can't believe they let so many people out this early in the morning.
Ugh, morning people time. Where is the judge? Like, come on, Kanoni. What are we doing here? Like, we want to hear what's going on. I also want to hear if Hank's going to say anything about this alleged, ridiculous, nonsensical, completely fabricated nonsense that the turd boy didn't even believe himself. Whoa, whoa, whoa. People do not know how to drive.
I'm sorry. I'll learn to get a license sooner or later.
Not you. Everyone else. People really don't know how. It's like morning, and maybe that's what it is. People are rushing to work, but Jesus Christ.
Hey, don't pick on them if they're Russian.
Jessie said her eyes are barely open. I get you. I'm getting like notifications from people that like all of the FKR people are starting to go live now 5 minutes before it's about to start. Like, aren't you guys just peaches, huh? Like, this is the time of day usually y'all get off my road. I say road. Just get off my road, sir. Like, why is this little thing is in the way of my comments, and it's really starting to agitate my life. I can't move it. Wow, that's stupid, StreamYard. You guys need to fix that. This stupid share your referral link. This thing is in the way of the first comment that pops up until it goes above. ARCCA Fraud Daddies, that's a good one. That is a good one. Ooh, I can move comments onto the screen from here. I'm learning. You guys are learning with me, because we're mobile.
Hey there, Karen Reed trial watchers. You know what a lot of the trials we cover remind me of? That the world is unfortunately very unpredictable. And I'll tell you what, having a great lawyer matters so much. That is where a great partner and sponsor, Morgan & Morgan, comes in. This is a firm with over 1,000 attorneys. You know why? Because they win a lot. In the past few months, Morgan & Morgan secured a $9.3 million verdict for a car crash victim in Florida, a $5.6 million verdict for another car accident victim in Atlanta, and not to mention $1.8
By the way,
million
this
in
is not an
Kentucky
ad.
after insurance offered.
Guys, I can't skip it because I don't know that. I have free. I have premium.
Isn't worth millions of
This
dollars.
isn't an ad. This
Why
is
not
something
sign
that Law and
up?
Crime actually put on their own screen right now.
Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. That's it. It can all be done on your phone. So if you're injured, you can easily start a claim at forthepeople.com/LC Live by clicking the link below or scanning the QR code on screen.
Yeah, guys, that's not an ad. It's something Law and Crime put on their screen. I have premium, thanks to Ashley. So I have premium. There are no ads. So that is something that Law and Crime decided to insert here on their screen like a-holes. And I'm not even sure they can do that considering people do pay for ad-free premium, which, you know what I mean? Like that's, I mean,
They advertise all they want.
I mean, I guess, but like when you pay for ad-free, that's the whole point. But yeah, they pop that on their screen. There's no ads. I can't skip it because it's not an actual ad from YouTube. I pay for premium, or I have premium. Ashley has it, so she gifted me the premium, so I don't have to deal with ads. There's
Yeah,
no
seeing them in the poorhouse, that's the best donation I can give.
Hey, it's the most awesome one because I don't have to worry about ads, and neither does anybody else. ARCCA Fraud Daddy. That's my best favorite comment of today so far.
What is it?
ARCCA Fraud Daddies. It's quite accessible information. All I can see is stuff on the screen. There's nothing. They're not talking. We can look at the little closed captions, but we don't. They haven't turned on their full audio yet, so we have no effing idea what the hell is going on. And we're still looking at the fan, so there's that. Premium, yeah. Just 800 clicks, yeah, pretty much. Yeah, that's me. That's me. I don't understand what in the actual. Good morning, Suzanne. Right? They said you better not back over me, or they'll come for you. Don't care and read me, Ashley.
I won't tell you, but there ain't no promises against anything.
Obviously, that's a joke. You got 5 notifications? Interesting. Let's see. It's 8:59, so, I mean, come on, Canoni, let's get the show on the road here. Oh, like 5 different channels went live? I see what you're saying. I get like 10 every time I'm already live, which is like, cool. Most of them are like, you know, the conspirators, which is so ridiculous to me at this point that anybody still believes that. I have, you know, it's interesting to me because of all the stuff that's going to happen today, they decided to do ARCCA in the afternoon. At least that's what they told us. 9:15? She said 9:15. Is she for realsies? Oh, so obnoxious. Like, she never starts at 9. Court starts at 9, then she wants to leave at 3:45. Ooh, we're done for the day at 3:45. Take a 40-minute lunch, turns into an hour lunch. Like, I mean, the amount of time that has been wasted in this trial is a little ridiculous, to be honest, especially when you know the thing is going to be. It was 9 weeks last time, and that was with a whole lot of half days and days off. So let's hope that that's not the case this time, you know? She is always late. It's obnoxious. Obnoxious. Right? Get your Sudoku out. Rick said get your Sudoku out. So ridiculous. It's like, let's go, lady. We want to get to the end of the day where ARCCA has to start explaining themselves. You know? That's what we want. We want to get to the end of the day where ARCCA has to bring their information in, or do they say that they don't have it? And if they don't have it, what's their explanation to not having it? And if they do have it, do they only bring things that don't matter and are inconsequential on purpose? Because I'm dying to know. Like, oh, poor Tom Tom. Maybe he's just not in it anymore. You know, he's not feeling it. He's not feeling it. Morning, Arlene. He's not. Maybe he's not feel like conspiracizing today. Or maybe they're doing their morning conspiracizing finger push-ups. Who knows? Who freaking knows? It's a very real possibility. I am wearing my Justice for John Oakey sweatshirt because when I go out in public, I'm like, I'm wearing this. Now, I will tell you guys that being out in public with this, I do get looks from FKR people. They either scoff, they scoff, or they give like a ugh look. You know what I'm saying? Like, the fact that you could ugh
on a sweatshirt that says "Justice for John O'Keefe" just shows what kind of human you are as a human being. Okay, it's just sad. It's just sad. But I do like getting a rise out of them. I do. But I also get to see some of you. I get to run into some of you when I'm out in public, and it's always fun to see one of you. Usually it's, hey, I was just watching you, or hey, I just saw you live, or it's always nice to meet one of you guys, that's for sure. Meltdowns? He loves meltdown. Resting yuck face. Resting biatch face. I don't know. It's a very real possibility, TV2. I'm not really sure who's going to be today. I thought they said something about one of the experts, but I'm not sure. Maybe that was Tuesday or Wednesday.
Good morning, TV2.
Ashley says, good morning. Told over how he let PM talk to Dina, then he deserves it. Well, who knows, you know? Who freaking knows? The way those people treat each other is just, God forbid you disagree with one thing, then you're like the devil, you know? Then you are the devil. And that's just a sad thing. Nobody's ever going to agree 100% on everything. Common sense. Like, that doesn't mean you need to be nasty to people. That's like what should be the red flag that, like, that's a cult. You know what I'm saying? Like, oh, Court TV said Jen McCabe a minute ago? Interesting. Jen McCabe as a witness today? Morning, Tracy. As a witness today. Yeah.
I thought you said has a witness.
No, is as a witness today. It'd be interesting if we had Jen today. That'd be a good thing to watch for sure. I'm definitely more interested to hear what ARCCA has to say for themselves after this debacle. The judge has clearly already found that they lied to the court, and so yeah, and the Commonwealth's going to have a fucking field day on a voir dire with them. And I literally can't wait for Hank to have that field day in that voir dire. So I am literally dying to see if they go, oh, well, ARCCA couldn't get here, or oh, their plane was delayed, or some other crap excuse on why they couldn't be here. You know? Oh yeah, that's true. If Jen is there, that means no sewer turtle. To be fair. To be fair. So that is a bonus. That is a freaking bonus. A very big bonus. I would love that. The faces are amazing because he doesn't even pay attention if he's there. It's like, bro, why do you have a press pass? Like, what's the point? Like, I thought about getting one, and then I was like, you know what? I'm only going to be able to make it out there maybe a couple days at best throughout the trial.
I take every day of the week.
I know, but then I got to get home, and then I got to leave early. So I'd have to leave early to get back, you know, to my house. So, because I got kids to get off the bus. So it's like, meh. I figured, screw it. I'll get a press pass after this so that upcoming trials I can go to. Yes, that's one that I am going to go to with a press pass. You guys are going to love that one. That means that the pool camera has to give me footage if I request the pool camera's footage. So, you're missed in chat, Jesse said. Yeah, but she gets to see it right here in real life. I don't know the lineup. I don't. I guess Court TV is saying Jen McCabe, but that could take half of the day. The reporter for Court TV is at the courthouse is the one who mentioned Jen McCabe to Julie Grant for tape. Possibly. Okay. That makes sense. That's true. CP who has a pee up his ass saying Sue is going to... Dude, Sue is a joke. I don't know why anyone listens to... And then she has the thing next to her name that says commentary. Then why do you work for a news station? I think, like, it's just a cop-out, really. It's a cop-out to be wrong and then say, well, I only give commentary so I can be wrong. Like, come on, man. Do better. Do fucking better. Realistically, do better. Like, it's a cop-out, in my opinion. Like...
Cops are out where?
Where? Everywhere in front of the courthouse. Everywhere.
Can I walk up to one of the cops and the officers and ask him, you know, what's going on today? What's going on today?
I know, right? That guy was not very smart. Like, not very smart. Especially since the cop, like, recognized him and was like, hey, buddy, you've been here since, like, day one. I don't know if he was picked for the week. That's a good point, too. He would have had to been picked for the pool. So, it's a good point. That's a good point. Girl, my coffee, I haven't even gotten coffee yet. I gotta go to the doctor's first, but then I'll get coffee and let it kick in. Let it kick in after that.
I share, but it's not very good.
Nope, it's not. I don't do I like my Mary Lou's coffee. If I can have it, I want it. I want it. Plus, I feel nice to bring hubby home a one on his day off. So, let's see. 9:07. We're still looking at least 8 minutes here before we get any sort of anything in that courtroom. I don't understand why they can never start on time. It's kind of obnoxious. Although, maybe they're like sidebarring this BS conspiracy of Hank and Lally that never happened. Because it's easily provable as a lie. That person is in a lot of trouble. And I hope that they make an example out of her and charge her with all the things that they can charge her with, because you signed an affidavit brought to the court knowing you made it up. Hey, Scorpio. Like, that's just sad. Like, that's just utterly sad. Like, I don't know what would, I mean, I get what would possess someone clearly who had warrants to try to get those warrants cleared. Because if you're, claim you're a witness to something, they can do away with the warrants. So that's a very real possibility. That is what happened. Yeah.
My hand up.
Yep.
All right. They know they can get away with it because that's exactly what Aiden did to me, and he got away with it.
Yeah. Well, he's also been helped with warrants and such as well. So that's the thing, right? So it's not like out of the realm of possibility that they talked to, whatever DA or whoever was prosecuting the cases and said, listen, this person is a cooperating witness. We're going to need you to remove those warrants for them to testify. The warrants were removed. And then obviously the office then is going to find out ultimately that they were lied to, and they're not going to like that. They are not going to like that. Thomas had many issues. Well, yeah, he like throws himself on the ground and goes, assault, assault! Like, that's not assault, sir. And then he kicked JLR's, LR, whatever his name is. JLR. And he kicked him a couple times. Like, and JLR could have had him arrested for assault. He didn't, because it isn't worth it. It's pointless, right? Like, but you're throwing yourself on the ground. You're talking about assault every 5 seconds. Anybody even bumps into you. No one wants to be around you. It's not shocking. Like, gee, I wonder why. Yeah, sworn statements that are provable lies are becoming a whole thing. They are. That's the irony. That's exactly the irony, Bree. It's the people claiming the Commonwealth is lying that keep doing it. It's amazing to me. Like, oh no, don't spill your coffee, Jezebel, you got to make sure you dab. Don't try to blot. Dab. Believe you me, I haven't had coffee yet, so I'm still in my cranky phase. Still in my cranky morning phase.
I can't believe we looked at this many people out this early.
I know. For realsies. And people who don't know how to drive at the same time. Yes, okay, JLR. That's what I thought. He was here last trial, but like Tom kicked him, and I'm like, okay, that's assault. Like, from the guy that falls over when anybody's like bumps into him in a crowd, like assault. Like, bro, that's not assault, sir. You're wasting the court's time, and it's sleazy. Like, it's just sleazy. Like, I don't agree with anything like that. There's no reason. Like, but we're about to find out. We about to find out about finding out about whether Hank's going to address any of this, whether he's just going to be like, F this, because it's easily provable, so I don't need to address. Like, they're not going to get it. It's that simple. Like, that's a no-go for them, so I don't know why anybody is claiming that. I know, I love that one. God damn it. He needs some serious mental health help. Also, let's just point out that he made a whole rant the other day, okay, that was posted on X about how he didn't believe what this person was saying, and how plenty of people have called his lawyers and wasted his time on things that were not true, that were conspiracies. What the hell did you expect, sir? You've been pushing a conspiracy for 3 effing years. Did you push people into that goddamn rabbit hole, and you figured they weren't going to come to your lawyers with shit that didn't matter? Idiot. Like, come on, man. It's common sense. Like, common sense. No, I muted myself for a second because the music will give me a copyright strike. YouTube is very finicky about music. When you can play it on TikTok, you can't play it on YouTube. They give you the copyright strikes. But if I am going in and out, it is because we are moving.
Which is also funny because you can use any song on TikTok,
Yeah,
no copyright.
I know, because you're using it. That's why it's. If it's on the radio, you should be able to play it. It's not shouldn't be a problem. Like, but then again, it's YouTube being just ridiculous, is what it is. Like,
Tell them to check out my YouTube channel after our project is done. They'll see all the videos.
true that. I am excited to see Hank's approach today. And yeah, Carrie Roberts misunderstood a question. That's not perjury. Like, I'm really like getting sick and tired of like Law 2 telling people that she committed perjury when they know damn well that perjury has to be knowingly and willingly. Like, it's not perjury. It never was. She misunderstood a question and the context that Lally was asking the word here. The way he asked the question, if you go back and read the question that he specifically asked, in the grand jury, it wasn't like, if you read it, that like you would understand that, like, the way he posed it. And also remember, grand juries allow you to do hearsay. Oh, what's coming? I'm muting.
All persons have any business before the Honorable Beverly Kenobi, Justice of the Norfolk Superior Court, before the County of Norfolk. Join near, give your attendance, and shall be heard. Let's say the Commonwealth of Massachusetts. This court is now open. You may be seated.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning.
I do have to ask you those same three questions. Were you all, four actually, I guess, were you all able to follow the instructions and refrain from discussing this case with anyone since we were last here on Friday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left on Friday? And were you all careful? Everyone said no or shook their heads. Were you all careful with your social media this weekend?
Yes.
Thank you very much. All right, Mr. Brennan.
Good morning, Your Honor.
Good morning.
Commonwealth will call Ian Whiffen.
Okay. All right, just come on up.
No, it's not muted. They just don't have audio right now. For whatever reason. I don't know if they're at sidebar or whatever, but there's no audio right now, guys. That has nothing to do with me. That is strictly on the court and law and crime at the moment. So we just have to wait. Well, while we're on a sidebar, if y'all want to do me a favor, hit the like button, subscribe button. If you can donate to the channel, it's always super duper helpful. We very much appreciate it. We only survive from donations from our viewers. And court days are actually very slow for the channel.
Please face our clerk and raise your right hand. You swear to affirm that the evidence you give to the court and jury in the case down here should be the truth, the whole truth, and nothing but the truth.
I do.
Good morning, sir.
Good morning.
May I, Your Honor?
Yes, please.
Good morning, sir.
Good morning.
Would you kindly introduce yourself to the jury?
Yes, my name is Ian Whiffin. I'm a digital forensics examiner and decoding product manager for Cellbrite.
You just mentioned Cellbrite. Is that where you work?
It is, yes.
And you're a forensic examiner.
I am.
Can you tell us a little bit about Cellbrite, where you work?
Yes, Cellbrite provides digital forensic solutions to customers globally for access and decoding of digital artifacts from devices.
Where would you find a digital system? Is that resigned to a phone, or is it all systems?
Typically, Cellbrite focuses on phones or iPads, but we do have some additional devices that we can also integrate: computers, vehicles, things like that.
So simply, what is Cellbrite?
Cellbrite is a digital intelligence company.
Do they use a certain type of software? Do they brand a certain type of software?
Yeah, we create our own software to access devices and to decode the data that we pull from devices.
So essentially, does that software help you look into the data on a phone and analyze it?
It does, yes.
What is the role of a digital forensic analyst?
Typically, the analyst would take the data that's been extracted from a device such as a cell phone, process that in software such as a physical analyzer that Cellbrite create, and use that information to filter, to search, and to create a report for the investigator that would allow them to see what happened on the device at the time being investigated.
How long have you been involved in analyzing data, sir?
I started my career in digital forensics in 2013.
Can you take us back to the beginning of your career and tell us a little bit about how you became involved in learning about analyzing data?
Certainly. I spent 5 years as a frontline police officer in the UK during the 2000s. In 2009, immigrated to Canada and continued policing frontline officer in Calgary before joining the digital forensics team in 2013. Pursued several qualifications related to digital forensics and just continued in that role until 2019, 2020, when I left the police agency and began working for Cellbrite.
While you were working at the police agency and began your career analyzing data, were there special classes that you took?
There were. In order to be a forensics examiner in Canada, you have to take a 3-week foundational course in Ottawa, basically covering the basics of digital forensics. And then from there, other courses are available that would focus on things like cell phones, would focus on how to get data from different types of devices. And then there's industry qualifications that can be sought as well, where you can focus on particular types of device or particular types of data.
Does software in this field continually change?
It does. Every time an update is released to an application or to an operating system, there's the opportunity for the foundation of that software to change. And from a forensics point of view, you have to re-understand what has changed, make sure you understand what is now happening on that device, and provide that information to the users.
As you've progressed through the field, do you continue to take classes?
I've not taken a class now since I actually joined Cellbrite and did the basic foundational courses that Cellbrite offer. But prior to that, I was doing courses across the industry.
Do you teach courses?
I do teach webinars. I don't teach any actual courses, although some of my research and some of my tools are taught to examiners in many of the industry standard qualifications which users seek.
Do you ever write papers about the subject that are published?
I do. So I have a blog where I publish my research. Sometimes some of those become papers which get peer reviewed and distributed in more academic channels.
So when one of your papers is peer reviewed, can you tell us what that means?
Yeah, essentially, other forensics examiners would read over the paper that I've written, do their own testing, compare their testing and research to what I've conducted, and make sure that what I've said is consistent with their findings. And presuming that what they find is the same as what I found, then they would agree that it's a valid document and it gets shared.
Take us now to Cellbrite. When you began working at Cellbrite, what did you do?
When I started there, I was considered the senior digital intelligence analyst. My role was to help the developers of the software understand the role of a digital forensics examiner, what an examiner needs from the tool, what an examiner wants to do with the tool, and how they want to use it. And then since then, I've progressed to the decoding product manager, where I can manage the backlog of software applications that we support, decide how we should support those applications, and how that information should look to the users.
Do you do research?
I do still do research, yes. It's not my primary function within Cellbrite, but it's something that I've continued to do throughout my career.
Have you ever done any programming?
Yes, again, I'm not an official programmer with Cellbrite, but I do program as well. And I have several tools which I've written myself for the last few years, since around 2015. Tools that I wrote to do the things that the vendor tools didn't do, and to offer examiners things that the vendor tools didn't offer. And I continue to maintain those tools as a learning opportunity for myself, and also because other examiners can make use of these same features.
Mr. Whiffen, have you ever testified in courts regarding forensic examination of data?
I have, yes.
And can you share a little bit about that?
I've been qualified as an expert in Canada, Australia, the UK, in total around 20 times.
I want you to take us now to the Cellbrite software. We talked a little bit about it. I don't want to go into too much detail, but can you help us explain how software works like Cellbrite software?
Yes, so fundamentally, when we've got data from a device, it's a series of files, a series of databases, property lists, all manner of different structured data. The software that we create knows where these files exist, knows how to read these files and what the data inside them means, and provides a clear view for the user to view that data. As an example, if you were to look at the SMS database on a device, all you would see is a long list of messages that don't really have an easy way to interpret or to read them. Our software takes that information, converts it into a conversational view, so that as a user, you can read the data. You can see who sent what message, what time it was sent. We can do decoding and decryption of various different types of security to give the user as much information as possible.
Is there other software available in addition to Cellbrite?
There's multiple vendor supplied tools and multiple tools available that are maintained by users in the community, like myself.
Does a forensic examiner, should they rely simply on the software program, or is there more to do other than the program itself?
The software program is great at finding the data and displaying the data, but I always maintain it's the role of the examiner to actually understand what that data means and provide context and validation for what that data means, making sure that the end user of the report, whether that's the investigator, a judge, or a jury, can understand what that data actually means, rather than just taking it at face value from the software.
Does the software create a report that you can look at that manages or arranges some of the data that you can see?
It does. It just creates a list of all of the results that the examiner wants to include in the report.
So the software can produce a report, but the examiner goes beyond the report and looks into the data itself?
The examiner can and should go beyond what the program provides.
Let's turn now to your involvement in this case. Can you share with us when you first became aware of the data in this case and how that came about?
Yes, it was actually one of the public relations managers at Cellbrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp and requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
And when Richard Green reached out to your company, what specifically was the question or issue?
He reached out to the tech support team, asking basically, there's a timestamp that doesn't make sense. I need to understand what this timestamp means.
What is a timestamp?
Essentially, it is the time which is attributed to an artifact. So it should intentionally be when something happened on that device, we would show a timestamp associated to it.
Can you tell us what an artifact is?
An artifact would be any piece of data that we pull from that device. So it could be a text message, it could be a location point, it could be a photograph.
So if I had photographs on my phone, would each photograph be considered an artifact?
It would, yes.
Would the date and time I took the photograph be considered an artifact?
I'd consider that a property of the artifact.
And if I had a phone call or a text message, those would be considered artifacts?
Yes.
When I look at my phone and I see a call log or a name, does that tell me all the information about that call?
When you look on the phone itself?
Yes.
No, there's usually a lot more information in the background of the phone that's available to the forensics examiner, which the user wouldn't necessarily see on the device.
And so when you're looking at an artifact, a phone call, a text message, whatever it may be, and you see it on a report, if you want to know more detail, where it came from, when it was developed, when it started, is that what a forensic examiner would do, to look into the data to try to identify that other information?
Yes, you can see what other information is available. You can see if there's any information that's been deleted that can be recovered. And you can validate the information that's there and make sure that the timestamps are being interpreted correctly and that they mean what you think they mean.
You told us you got a call from a consumer or a forensic examiner, Richard Green, about a timestamp. What type of timestamp? For what type of artifact was this timestamp?
It was related to an internet query.
And so there was an internet query on a phone that had a timestamp, and this gentleman, Mr. Green, had a question about it.
He did. He wanted to know how accurate the timestamp was in relation to when the internet query was made.
Did you look into the question, the query that was made?
In response to Richard Green at that time, I didn't. I wasn't aware that Richard Green had made this request until several months later. But it was an almost identical question that had been asked by the troopers here. And that's the question that I was able to look into and to answer.
And can you share with us, what was the issue? What was the question that you were actually looking into?
The question was related to a timestamp of 2:27:40 a.m. And an internet query that appeared to have occurred at that time. There was no other information on the device that suggested that that internet query had occurred at that time. So we wanted to know how relevant is that timestamp to when the query happened. So I was able to take test devices, recreate test data to find out exactly what this timestamp meant, and discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance to when the actual web query had been made.
And so after you looked into the issue and came to a determination or opinion, did you reach back out to Mr. Green?
Eventually, yes, I did. After I provided information to the troopers, I wrote a blog that covered this information because there was another examiner in Europe who had a very similar question, and I realized that this is a relatively common point of confusion. And then eventually I reached out to Richard Green, offering to speak to him about this issue and clear up any confusion, but never received a response.
So to summarize, there was an inquiry about a phone that made a Google or a internet search. And the question is, what time was that search made?
Correct.
And relative to that inquiry, there was a timestamp on some of the data that said 2:27 a.m.
Correct.
Sustained.
So at some point, did you have an opportunity to forensically examine a telephone that was attributed to a person by the name of Jennifer McCabe?
I did have the opportunity to look at the data that was extracted from that device. I never saw the device itself.
And putting that aside for a second, secondly, were you asked to look at any other phone to examine data in this case, aside from the phone attributed to Jennifer McCabe?
Yes, I was also sent the extraction of data from John O'Keefe's phone.
Did you look through the data and analyze some of the data in John O'Keefe's phone?
I did, yes.
So I want to walk through both your analysis of Jennifer McCabe's phone, but also of John O'Keefe's phone. So if we can first start with Ms. McCabe's phone.
Yes.
Did you actually receive her phone?
I didn't know. It was just a download of the extraction.
So how does that work?
The examiners here had done the extraction of the device, resulted in a large zip file, which is a container containing all of the files extracted from the phone. They uploaded it to Cellbright's secure portal, where I was able to download it and verify what the data was in the extraction.
When you received the download of the extraction for Jennifer McCabe's phone, was it similar process for John O'Keefe's phone?
With John O'Keefe's phone, I actually received the data on a USB thumb drive through the mail.
And before we begin, can you summarize briefly the issue, what you were looking for, and what the scope was as far as Jennifer McCabe's phone?
For Jennifer McCabe's phone, it was related to the internet search that occurred, or that allegedly occurred at 2:27:40.
Okay. And as part of your effort and analysis, did you put together a PowerPoint that would help educate us on how timestamp works and what happened in this case regarding a search?
I did, yes.
And have you seen that PowerPoint recently?
I did, yes.
May I approach, Your Honor?
Yes.
Thank you.
I'm handing you a binder that you take a look in. Do you know or do you recognize what's in that binder?
Yes, this is the PowerPoint presentation I created related to Jen's phone.
And with that presentation, do you have it downloaded on your computer?
I do, yes.
I'd like to introduce this as the next exhibit, please.
No objection, Your Honor.
All right, thank you.
You know, with the court's permission, I'd ask Mr. Whiffen to be able to use his computer to walk us through the PowerPoint and explain it to the jury.
No objection, Your Honor.
Yes, thank you, Mr. Whiffen.
Okay.
Here we begin, Your Honor.
Yes.
Mr. Whiffen, if you would walk us through and explain the PowerPoint and explain this issue to the jury, what the question was and how you resolved it.
Of course. Okay. The query revolved around a database called browserstate.db. Browserstate stores information about Safari internet browser and about the tabs that the user has either had open or has open. Fundamentally, in this presentation, I wanted to include information from iOS 14 and earlier. iOS 14 is not the version of iOS that was on Jen McCabe's phone, but iOS 14 has an easier way to understand how this database works. And then I can move on to iOS 15, which was the device or was the version installed on Jen McCabe's phone. And hopefully by that point, it will be clearer how this information is being populated on the device.
Could you tell us what iOS means?
iOS is Apple's proprietary operating system available on iPhones.
Thank you.
Fundamentally, the browserstate.db tabs table is shown, hopefully I can show this on here, in the top here. The real database has many more fields, but these are the fields which are important for the demonstration to just see the row ID, the timestamp that's recorded, the URL or the web address, and the title of the page. And the example at the side there, you can see there's the browser is open, but there is no tab actually in focus at this time.
Can I take us just a little bit back so we can put this in context?
Yes.
When you are doing internet searches on your phone and you hit Safari or Google or whatever search engine you're going to use, does it create a tab?
It doesn't create a tab just by opening the application, but there may be tabs already open in the background when you start the application, and then you can tell it to create further tabs.
So if I have a phone, can I have a number of different tabs on my phone at the same time if I search for different things throughout the day?
Correct. You can have hundreds of tabs open.
Do tabs stay open forever, or can you close them?
They stay open until you close them.
So if you look at your phone and you have a number of different tabs, and say, for example, I start with one tab, I'm looking for the local football score. Can I reuse that same tab for some other search, or do I have to use a new tab to start a new search?
You could use that tab for as long as you wanted, or create a new tab to do additional searches while maintaining the original tab in its current state.
And so what you're trying to demonstrate to the jury is identifying a time on one of these tabs where a particular search was made.
Objection, Your Honor.
Sustained as to form.
Could you explain this demonstration as it relates to tabs on these internet searches? What are we actually trying to learn?
So as I showed, there's a field in this table called timestamp. It's actually called last viewed timestamp. And I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated, and how it's relevant or irrelevant to a case.
So if I have one or many tabs open on my phone, each tab will have its own timestamp?
Correct.
And the URL, that's whatever I look up, what I search on the search engine?
Objection, Your Honor.
I'll allow that. Is that what's looked at?
That's great. The URL is the address of the page that's being viewed.
So if I have a tab open and I use it continuously, 3, 4, 5, 10 times, will the time stamp change?
No, it will not.
And is that what you're explaining to us now?
Correct. That's part of the demonstration and presentation.
I'm sorry to interrupt.
Okay. So in this instance, at 10 a.m., which is shown in the top of the device there, we can see I visit firstpage.com as an example website. At that time, a row is created in the database that shows row ID 1 with the timestamp 10 a.m. when the page was opened. The URL and the title are relevant to the page that was visited, so firstpage.com. A minute later, excuse me, I now use the same tab to visit secondpage.com. What actually happens in the database at this point in time is the first record is updated with new information. So we continue to see row ID 1. We continue to see the timestamp that the tab was opened at 10 a.m. And we now see the URL and the title that are related to the secondpage.com website. So I've shown it here. The first one is red to show that's no longer a live record. It's been replaced by the new record that's underneath it in black. A minute later again, I can visit thirdpage.com. And at that point, the record's updated a further time. So we still see that it's row ID 1 because no new rows are being created. We're just simply updating the existing rows. So we still have row ID 1. We still have 10 a.m. as the timestamp, and we have the URL and the title that show thirdpage.com instead.
Mr. Whiffen, so in the URL column, there are 3 different searches?
Yes, this is 3 different pages that have been visited within the same tab.
And in the data, it has 3 timestamps, but they're all the same.
Correct.
Okay, thank you.
This database is not monitoring web navigation events. It's purely monitoring the tab events. So when the tab's brought into focus or when the tab's created is the only timestamp that's relevant here.
Thank you.
From a non-forensic point of view, if I was looking at this database in a regular database viewing tool, all I would see is the black record at the bottom. I wouldn't see the other two records because they've been essentially overwritten by the third record. If I was to use a forensic tool, though, then I would see all of these records because the forensic tool is designed to find the older versions of these records that have been replaced. So again, from a forensic point of view, I would see all of these records, I would see all the different URLs, and I would see the same timestamp and the same row ID for all of them. This fundamentally changed in iOS 15, and I've tested this on multiple versions of iOS 15, 16, 17, and 18, including iOS 15.2.1, which is the same version of iOS installed on Jen McCabe's phone. In this case, the data is not written to the database immediately. So I've tried to show here that we have some in-memory variables, so essentially a short-term memory that the device knows exist, but aren't written to the database yet, so they're not written long-term. So in this case, if at 10 a.m. I go to firstpage.com, we see that the in-memory variable for timestamp, URL, and title are updated to show a 10 a.m. timestamp and the firstpage.com information. But you can see at the bottom, I still have the browser state tabs table, and nothing has been written to that database at this time.
So can I ask you a question about this browser state DB? What does that mean? What does that tell us?
The browser state.db is just the name of the database that Apple are using to monitor the tab activity on the device.
Will a cell phone have a number of different databases it will send information to, or is it all one database?
There are hundreds or thousands of databases, depending what applications are installed on the device. Each database typically targets a different application or a different feature.
Can information, like information from a URL or a Google search or a Safari search, can it leave data on different databases, or does it always go to one database?
It can leave on different databases, for sure.
Thank you.
So again, to continue this example, if I now go to secondpage.com a minute later, we can see that now the in-memory variable is updated. So the timestamp still remains 10 a.m., the same as it did previously on iOS 14, but the URL and the title are updated to reflect the current web page that's being viewed. Again, nothing has been written to the browser state database. I can go to thirdpage.com. Again, we see the in-memory variables for the URL and the title are updated, but the timestamp still remains the time that this tab was brought into focus or created, not the time that the navigational event occurred. Still, nothing's been written to the browser state database. And it's not until you actually close the tab that the information gets removed from the in-memory variables and written into the database. And at that point, the information written to the database is whatever was in the in-memory variable. So right now, all we have is a single record in the database that shows the 10 a.m. timestamp. That's when the tab was opened. And we have the thirdpage.com URL and title information, which is the most recent web page visited in that tab. It wouldn't matter whether I was looking at this data using a regular database tool or a forensic database tool. The only record that I will see is this particular record. There may be multiple versions of this record, but still would only show me this timestamp and this URL information because this is the only information that was ever committed to the database. Okay, moving on from that, there was multiple databases or multiple data sources on Jen McCabe's phone that could be used to see what actually happened on the device at this time of day that was of interest. So the analysis I did looked at the browser state database that we've just described, the history database, which is what is tracking the navigational events. So every time you visit a website and the website fully loads, it gets written to the history database to say this URL was visited at this time. And that's the information that as a user you can see. When you look at the internet history in your device, it will list all of the web pages that have been visited. com.apple mobile safari.plist is a property list file, so essentially a list of values and information, keys and values that would describe various settings on the device typically, but it also stores information such as the last searches that were conducted using the Safari search feature. And then finally here we've got knowledgec.db, which is a massive database at the heart of iOS that stores lots of types of information. It can tell you what web page was actually on the screen at any given time. It can tell you when the backlight came on, when the backlight went off, when the device was locked or unlocked, the battery level, lots of different types of information, but useful here for the web pages that were being viewed. So using the combination of all those sources, I could see that at 2:27:29 a.m., Safari was opened from the application library on the device. At 2:27:29 a.m., when Safari opened, there was already numerous tabs open in the background. The browser would show in the foreground whatever browser tab was opened when Safari was previously minimized. In this case, we can see, looking at knowledgec.db, that the web page that was being viewed was related to Hockomock Sports, Friday's schedule scoreboard. At around 2:27:30, that tab would have been closed. Now, we don't actually have a time the tab was closed, but based on other activity, this timestamp can be inferred. But essentially, when this tab was closed, a record is created in the browser state database that shows the timestamp 1:59:44 a.m. That would have been the tab at the time the tab took focus, and then the Hockomock Sports Friday schedule scoreboard URL. At 2:27:31, there was a browser switch occurred, and the last visited timestamp that's held in memory would have taken the time that this occurred, so 2:27:31. This URL was PayPal. There was no navigational event listed in history, so this wasn't a page that was visited from a bookmark or from typing in a URL. It was whatever was currently shown in that tab when the tab was brought into focus. And we know that this exact URL was last visited at 7:40 a.m. on the 28th of January. This is evidenced in browser state and in knowledgec. Around a second later, that tab gets closed, and that record gets written to the database with a time of 2:27:31, because that's the time the tab was brought back into focus. It gets written with the URL and the title information related to PayPal. At 2:27:33, another tab is brought into focus from the background. This one related to Eastern Bank. Again, the last visited timestamp would be updated because this tab has now been brought into focus, causing the timestamp to change. We know that this particular website was visited at 8:02 on the 27th of January, and there's no new navigational events at this time. So we know it's just brought into focus and visible on screen according to knowledgec and browser state databases. That tab gets closed and it gets written to the database. This again is going to show, and I've just noticed there's a typo on here and the timestamp at the top is showing incorrectly. But essentially it's closed at around this time, and the Eastern Bank URL is written to the browser state database with the 2:27:33 timestamp. At 2:27:35, we see that there's a YouTube video shown on screen related to It's Raining Men. This shows in knowledgec. There's no new navigational event for it, but there's also no timestamp in the browser state database at this point. This is because this page is actually, or this tab is brought back into focus a second time. And when it gets brought into focus the second time, the timestamp that's attributed to it overwrites the timestamp that would have been written at this point. Sounds convoluted, but essentially, if you imagine that the in-memory timestamp here would have said 2:27:35, but then there's another tab that's brought into focus related to Hockomock Sports at 2:27:36.
Mr. Whiffen, can I ask you a couple questions?
Yes.
This timestamp 2:27:36, does that indicate the time when this tab was actually opened?
Yes. The time that the tab was brought into focus or opened.
What does it mean brought in?
If you imagine you could have 5 or 6 or however many tabs in the background, you select one of those tabs to view, it makes it full screen, that would be considered in focus, and that would cause the timestamp to be updated.
So if someone had an open tab that had a timestamp, and then they put it in the background to look at a different tab, but then went back to an earlier tab and opened it, would it create a new timestamp?
It would update the timestamp.
If somebody had an open tab and they didn't put it in the background, but they used other functions or shut off the phone, and when they came back, that tab was still open, would that create a new timestamp?
As long as Safari doesn't close, then the timestamp will remain the same. So if I just minimize Safari, put it into the background and start to do other things on my phone, the timestamp won't get updated. If I completely close Safari or turn the phone off, when Safari reloads, then that tab does get a new timestamp when it opens up again.
Thank you.
Okay. So at 2:27:36, we've got Hockomock Sports, Gallery Shoots, Canton Girls, Basketball to important win at Mansfield, is the page that is visible on screen. Again, we know that there's no navigational event at this time, so the page is not being loaded as a result of a bookmark or typing the URL in. It's just showing what was on screen previously, and we know that this page was previously viewed at 22:55 on the 27th of January. This tab gets closed and gets written into the database as well, and we see it's written with the timestamp 2:27:36 when the tab was brought into focus. And then we go back to the YouTube video tab. So at this point, the timestamp that had been written there gets overwritten again with 2:27:38, and it shows the YouTube video is the active page that's on the screen. At around 2:27:39, that tab gets closed and the record is written to the database showing a timestamp of 2:27:38 when the tab took focus, and the YouTube video URL. Then we move to 2:27:40, which was the time of interest, and we see that a browser switch occurs, causing the last visited timestamp to take on the time of 2:27:40. This is the tab that was ultimately used to search Hoss Long to Die in Cold, which is the query that started all of the confusion. At this point in time, there is no navigational events recorded anywhere. All we see is that the web page that was brought into view is ozonebasketball.com/teams. This web page was last visited at 14 minutes after midnight on the 26th of January. We know that this is on screen because it tells us that in Knowledge C, and we know that the time is 2:27:40 based on Knowledge C timestamps and based on the browser state database timestamp. At 2:27:42, there is a web navigation event. Whether this is loaded from a bookmark or whether it's typed in, I can't say, but a web navigation event occurs using the same tab that's just been loaded. And now the user is loading the web page hockomocksports.com/standings. This is logged in the history database that shows what web page is visited when. And it also shows in the Knowledge C database to show what web page is on screen at this time.
Mr. Whiffen, in the slide before 2:27:40, you mentioned that was the tab in question.
Yes.
Do the following pages that you show us in the PowerPoint follow that one specific tab?
Yes.
Thank you.
So at 2:27:47, there's another web navigation event as the web page hockomocksports.com/schedules is loaded. Again, this is evidenced in the history database to show that a navigation event occurred and completed, and in Knowledge C to show that this is the web page that was viewable on screen. At 2:27:53, there's a further web navigation event, where we're now viewing now loading the page hockenmocksports.com/schedules/girls hockey. Again, this is evidenced in the history database and the knowledge C database to show what page loaded and what page was visible on screen. At 2:27:58, there's a further navigational event for girls hockey Franklin 21-22. Again, this is logged as a navigational event in the history database and shown on screen according to the knowledge C database.
So I understand these are all subsequent searches on the same open tab.
Correct.
Your Honor.
Are these
Sustained as to form.
Are these all subsequent searches on the same single open tab?
There is no tab switch event listed. We see the tab switch event occur at 2:27:40, and then we see lots of navigational events occur.
Thank you.
At 2:28:06, Safari is minimized, so it's removed from focus so that something else could be viewed, or the phone is locked.
Is removed from focus different than closing?
Correct. If you remove it from focus, it's essentially going into the background, but it's still open. It's in its current state, just in the background, versus if you close it completely and have to reload it later on. So in this particular state, the timestamp doesn't get changed. The timestamp remains 2:27:40 as it was earlier. Safari is then not used again until 6:23:37, when it's opened from the background using the icon in the app library. At this point, when it loads up, the same page that was open when Safari was minimized is shown. So we still see hockenmocksports.com/schedules/girls hockey/Franklin/2021-2022. There's no navigational event at this point, so we know that it wasn't completely reloaded. It's just showing what was on screen previously, and it's evidenced in the knowledge C database. At 6:23:49, there's a cache file created. The cache file is related to how long to digest food. Now, these particular cache files show up as suggestions in Safari. So as you're typing in a query or a word or a URL, for example, Safari tries to take that information and make suggestions based on what it thinks you might be searching for. So if, for example, you were to type in how long to die with the word spelled just DI, Safari can mistake that for how long to digest food, and it could present this information. And up until about 12 months ago, this is the information that was provided by Safari. If you were to do this search, if you were to type in how long to DI, you would get the result that's shown at the top of this screen with an image of somebody eating a plate of food. And this is the image that was cached onto Jen McCabe's phone at 6:23:49.
What does cache mean?
Essentially, downloaded now for use later. It will download it, it will save it in case it's required again. If it is, it doesn't need to download it, it's already there. If it's not required again, eventually it will be deleted.
So is it stored information from prior events that's available in case the device thinks you're looking for it?
Yes, so at this point in time, at 6:23:49, when it downloaded it, that's the first time that it's downloaded this image, and it stores it. If an hour later, for example, I did the same search a second time, it wouldn't need to re-download the image because it's already got it in cache. So this, the creation time of this image shows that this is the first time that this cache file was downloaded. A few seconds later, at 6:23:51, the blue button at the bottom of the keyboard is used to submit a search for the term how long tid I in Kikdi, CIKD. This creates a specific URL in Safari, which is shown on screen here. So google.com/search how long tid I in Kikdi, IE UTF-8, OE UTF-8. Client Safari is the important part of this string that tells us that it's a query that's made using Safari. This is different to if I visited Google, for example, and just typed in the search text box in Google, it wouldn't necessarily have this same structure of the URL. So we know that this is the query created by submitting a search using the search bar here and pressing the blue button at the bottom. We know that that search was conducted at 6:23:51 according to the information in mobile-safari.plist. And Knowledge C also shows that this page was visible. Importantly, there is no history record made that shows that the navigation actually occurred to this website. Several reasons why that might happen. One could be if the device was in private browsing mode. However, it can't have been in private browsing mode because if it was, we wouldn't have the search recorded in the mobile Safari plist either. So we know it wasn't in private browsing. It could have been deleted at some point after the fact. That would leave a gap in the numbering. Every time a record is written, it would be consistent numbers 1, 2, 3, 4, 5, 6. And to delete a number would leave a gap there. So you would see 1, 2, 4, 5, and that number will pretty much never be reused. So if you don't see a gap, then you can be confident that nothing was deleted, and there are no gaps on this device. The third reason, and the one that I believe is the reason why it wasn't recorded in the database, is that the page never completely loaded. If I go to a web page and cancel the navigation prior to it completing the load, it will never get written to the history database. At 6:24:18, there's a second search submitted using the same method, so still using the Safari search bar, this time searching for host long to die in cold. This is evidenced in the mobile Safari.plist. Again, there is no record made in the history database that to me suggests that the page never successfully loaded. At 6:24:24, Safari is minimized again. It gets reopened at 10:33:33 a.m., again loaded from the app library and brought into focus. And at that point, the previous page is shown to the user. That previous page is related to the search host long to die in cold. This is evidence in Knowledge C to show that this is the page that's visible on screen, but there is still no history event that shows that the page completely loaded. And at around that time, so around 10:33:34, that tab would have been closed, resulting in the record being written to the browser state database with the timestamp 2:27:40, when that tab was originally brought into focus several hours earlier, but it shows the most recent URL information, which is the Google search for host long to die in the cold. It doesn't have any of the other URL information that was visited during that time period. It doesn't have the previous Google search for how long to die in the Kikti, because all it records is the most recent URL that's visited alongside the original time that the tab took focus. Importantly here, there is no title information. The title information is included within the page itself. So if you do a Google search, the title of the page that showed up would show Google search, and then it would show the query that you typed in to search for. The fact that this doesn't have a title also suggests that the page never loaded. So again, it kind of ties back to the fact that it's not written in the history database. We have no title. It's both indicative that the page never successfully loaded.
Mr. Whiffen, when a tab is ultimately closed, does the URL always have the last search, or could it show an earlier search?
It will always be whatever URL is visible in the tab at the time.
Thank you.
To overview again the data sources used here, com.apple mobile safari.plist is known to be a reliable location to get search timestamps from. We know that it's good to show the time that a search was conducted and what search was conducted. It doesn't record if the device is in private browsing mode. The only time it shows how long to die in the Kikti is at 6:23:51, and the only time it shows host long to die in the cold is at 6:24:18. There's no other mentions of either of these searches anywhere else in this file. The history database again, is known to be a good source of data for visited web pages and timestamps for the pages that completely loaded. Again, in this case, neither of these searches or neither of these URLs was in the history database, but there are no missing records, which indicates that nothing was deleted. And again, the only reason that I can come up with for why that is the case is that the page didn't load. There must be an entry within this database to allow the user to delete it. Obviously, if the page doesn't load, it doesn't get written to the history. As a user, you can't see the item in your internet history list, so you can't delete it. And then knowledge C, which shows the page that's on the screen when the browser is in use. Again, we know that this is a good timestamp, and we see the only times that web pages related to these web searches were open is at 6:23 and at 10:33. There were multiple deleted records in the browser state database. It wasn't just the record for How Long to Die in the Cold.
When you say there's multiple deleted records, can you go into a database and see what URL searches have been deleted from the actual item?
Yes, so from a forensic examiner point of view and using forensic software, I can look at the database and see the records that have been deleted and recovered. There does become a time when you're unable to recover any more records and they're now just purely deleted and unable to get back. But at this point, I was able to recover a good number of records. And these were the 5 that I thought it was important to focus on for here. You can see that 3 of them occur at 2:27. So at 2:27:36, 2:27:38, 2:27:40. And these are the web pages that we've just seen in the presentation. So Hockamock Sports, the YouTube video, How Long to Die in the Cold. And then 2 additional pages for cantonma.org and Ozone Basketball. The way that we're able to recover these records forensically is because of how databases work. What I've tried to display here is that when you first create a record, in this case, creating record 4025, a new page is created in the database. A page is simply a block of binary data that's organized in a way that can be understood by the database as a page of data, much like it would be a ledger with a list of records. So it creates frame 181 with page 2752 and the record 4025. What is a little bit different from if you were doing this manually is when you want to add a new record, or when you want to delete a record, or when you want to update a record, it has to create an entirely new page or an entirely new version of that page. So in this case, we see that frame 194 is also page 2752. It duplicates the record 4025 and adds the record 4026. From the database's point of view at this time, frame 181 is now dead, like it won't be used for anything. And a regular database tool would only refer to the most recent version of that page, so frame 194. Forensically, I can look back at all of these different versions of the page and I can start to see differences. Not so important in this case when all that's happening is that you're adding information, but when you start to delete or edit records, being able to go backwards and see these previous pages, you can see the records that have been changed or deleted. So as we're moving along all of these pages, each of these refer to a time when a new record was added. Every time a new record is added, a new frame is created, it duplicates the page from before, and it adds the new record. I've highlighted record 4028 in green across these 3 frames because this is the How Long to Die in Cold record that is of interest. Moving forward again, we continue to see records being added, but particularly here at frame 430, record 4029 is deleted. 4029, if I go back a few slides, we can see 4029 is the cantonma.org Families Index webpage. As far as I know, no relevance to anything related to this case. It just so happens this is the first record deleted from the browser state database. We don't have information that tells us at what time the record's deleted, but we're able to infer what time that record was deleted based on other records in this frame. So for example, we know that at the time that record 4029 was deleted, record 4031 already existed. Record 4031 has a timestamp of 6:29 on the 31st of January. Therefore, we can summarize that record 4029 had to be deleted at some point after 6:29 on the 31st of January. We see again record 4030 is deleted on frame 468. Again, we can look at what record was the most recently created on that frame at the point that that record was deleted. And that gives us information that suggests record 4030 had to have been deleted at some point after 8:35 on the 31st of January. We can continue to go along and continue to see that records being added, edited, and deleted, but the record of interest 4028 still exists even on frame 650. And in fact, it doesn't get deleted until frame 732. By the time the record related to Hoss Long Died in the Cold is deleted, record 4037 already exists. Record 4037 was created after 2207 on the 31st of January. Therefore, we know that the Hoss Long to Die in the Cold record was deleted at some point after 10 p.m. on the 31st of January. Taking all of those deleted records, those 5 deleted records, and the earliest time that they could have possibly been deleted, we see a spread throughout the 31st of January. Like a few quite early on at 6:29 and 8:35, a couple at 9:20, 9:40, and then finally the one that we're interested in at 22:07. For the user to cause these to be deleted, if you wanted to do it selectively and delete one at a time, the record has to be available in the history database. As I said earlier, it wasn't ever in the history database because there'd be a gap. So this record could not have been deleted by the user selectively. That leaves options of deleting everything from the history, but if everything was deleted, we would have none of this information, and we do. And it also leaves the option of deleting everything from what's considered today and everything that's considered today and yesterday. And again, if either of those options were the case, we'd have much less information than what we have, and we wouldn't see this staggering of timestamps that we see here where the information was deleted. Ultimately, I wasn't able to say what caused these deletions at these particular times, but I'm confident that it wasn't as the result of user interaction. That's something that was brought on purpose.
Mr. Weston, I have a couple questions about your analysis and your opinions.
Yes.
You showed us a tab that was opened at 2:27:40, and it had something to do with Hawkmock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 2:27:40 tab open for Hawkmock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long or how's long to die in cold?
I believe it was, yes.
Does your opinion, is it based on your analysis of reports generated by software like Celebrite?
Objection, Your Honor.
Sustained as to form.
Was your opinion limited to analysis of reports generated by companies like Celebrite or Axiom?
It wasn't, no. I went into the data, looked at the various different databases, different files that were in use, tested it across many different devices, to make sure that my understanding and analysis of it was correct.
In addition to your opinion that the two searches at 623 and 624 occurred at that time, as opposed to 22740, did you also, when analyzing the data, come to an opinion whether or not either of those searches actually connected and produced results?
If either of those searches had connected, the information would have been written into the history database. The fact that it wasn't in the history database strongly suggests it never completely loaded. And the fact that there is no title information on the browser state tab as well also suggests it never loaded.
And finally, those attempted searches at 623, 624, you mentioned that information at some point was deleted from the phone?
The only records that were deleted were the browser state database records. Yeah, they were deleted from the device.
Do you have an opinion to a reasonable degree of scientific certainty whether or not that information was removed as a natural application of the phone, or was it because somebody took the phone and actually deleted it by hand?
So again, I don't believe it's possible, given the situation and the information that's available, that it would have been possible for the user to delete it. I believe it was more than likely a system event that caused that, but I've not been able to replicate that system event.
I want to take you back to your first opinion, where you opine that the how's long to die in the search occurred at 623 and 624, not at 22740.
Yes.
And so, in looking at the data, coming to that opinion, what caused the confusion with the software where it could be misunderstood the time those searches were actually made?
Objection, Your Honor.
I'm going to allow it.
The way that forensic software typically works, certainly the way that Physical Analyzer works, is we design models for the data. So we know that an SMS application, for example, will always have a message body. It will always have a sender, a receiver, a time, that kind of thing. We always know that a web visit will have a URL, a title, and a visited timestamp. In this particular case, in the database, the timestamp is called last visited timestamp, which is indicative, you would think, of the time that the web page was visited. So when that information was being modeled within the software, the timestamp that was within the database was used, and it was called last visited timestamp. Since the investigation that I did into this case, I requested that the forensic research team at Cellbrite revisit this data and confirm if there's confusion around it. Were my findings correct ultimately? There are times that that information can be correct. If, for example, you create a brand new tab, visit a website, and then close the tab immediately, then that timestamp would be indicative of the time that the URL was visited. But if you were to create a tab, use it for 3 hours, and then close it, the timestamp would not be indicative. Also, if you were to bring an old tab into focus that you'd used several days earlier and then close that tab, again, you're going to get bad timestamp information. So ultimately, from Cellbrite's point of view, we removed the timestamp from that data to avoid confusion in the future.
You shared with us that the URL for the 623 and 624 attempted searches ultimately was removed from the device.
Yes.
Would it be fair or accurate to say there were over 4,000 deleted files from the phone, or there was 4,000 deletions from the phone?
There were many.
Sustained.
Okay.
As to form.
Would it be accurate to say that the only deletion from that phone was that 623, 624 search?
No, there were thousands of records deleted ultimately for various reasons that I can follow.
That would be an inaccurate assertion?
To say that that's the only record that was deleted is inaccurate, yes.
Okay, thank you. I'm now going to turn to a second phone that you looked at.
Okay.
You told us that you looked at 2 phones. The second one was a phone that was, or is attributed to John O'Keefe.
Correct.
When you looked at the phone for John O'Keefe, were you looking at things different than we looked at on the phone attributed to Jen McCabe?
I wasn't as interested in internet data. I was more interested in location and health and anything else that could be useful.
Before we show any presentation, I want to get a little understanding of what you looked for and what you found. Were you looking for what's called location data?
I was, yes.
Was there a period of time that was important that you were looking for relative to location data?
Typically after midnight and before 6 a.m.
Is that on January 29, 2022?
It is, yes, sorry.
How does a phone, like an iPhone, store location data?
Multiple ways that it can be stored. Primarily, there's a database called cache.sqlite. And every time an application requests location data from the device, a feature called location services on iOS tries to calculate the device's location using a combination of technologies, GPS, Wi-Fi, cell tower, and Bluetooth. Calculates the device's location and stores that into the database as a latitude, longitude, altitude, timestamp, accuracy radius, information like that.
Are there different types of location data that are captured and stored on a device like an iPhone?
Can you define different types, please?
I'm sorry?
If you could define what you mean by different types.
The different sources of data that are generated that then captured on an iPhone.
Yeah, so the application can specify how accurate it wants the data to be. So for example, if you're using a navigational application, you'd want high accuracy data. So the application would request high accuracy data from location services. Location services would then try to use GPS primarily to get location information. Versus if you were using a weather app, for example, where you don't really need to know precise information, you just need to know the approximate town maybe that the user's at. So a weather application would ask for low accuracy information, and the device may be able to calculate the location based on cell tower information, for example. Both can be stored in the database with the accuracy information that's available.
Would a application that is devoted to navigation in your programming experience typically have stronger data, location data information than a more general application like a weather app?
Yes, for sure. And Apple actually specify in their documentation, when they specify the various different accuracy levels, they have one for navigational purposes for map applications.
How do you define accuracy level from the different data that's being stored in a phone?
How do you mean, sorry?
Is there high level, middle, low?
Yes, the information is typically provided with a range of meters. So you'll have a latitude, longitude coordinate and a number of meters that you have to draw around that locational point. And the device is somewhere within that circle. It could be as accurate as 2 or 5 meters. It could be as inaccurate as several miles, depending on the technology that was used to get the data.
Are you familiar with an application called Waze?
I am, yes.
Tell us what Waze is.
Waze is a navigational tool, so you can plot a route and it will try to direct you the best way, avoiding toll roads, avoiding accidents, that kind of thing.
What is the level of accuracy in location information that is generated by using Waze?
That would be the highest level of accuracy. So it would aim to get GPS quality information of around 5 meter accurate.
So why doesn't a programmer in every application just use the highest level location data for every application?
Getting GPS data is not always possible. If you're in a building, in a basement, for example, you may not get that. But also, it can be expensive to the device in terms of processing power, in terms of battery requirements. So if it can find location information cheaper by using the Wi-Fi networks, for example, then it would prefer to do that. So just a lot less resource intensive than using GPS all the time.
In order to capture the highest level of location data, the most accurate in an application such as Waze, if somebody's using Waze and then turns it off, does it still continue to capture that highest level of accuracy?
Typically not. It may do for a short time as it's still kind of working through a backlog. But fundamentally, if there's no application open that's trying to use location services, then the location information that's being requested and recorded is far more sporadic. It's typically background applications that may be requiring location data.
When you analyzed John O'Keefe's phone, in addition to the location data, did you also look into data known as health care data?
Yes.
And could you tell the jury how that works?
Yeah, so pretty much all iPhones for the last 10 years or so have Apple Health included. It monitors activity on the device, such as steps taken using various sensors inside the device, looking for motion which appears to be walking. It monitors altitude, so it knows whether you've gone up a flight of stairs, for example. It uses that information in concert with the steps taken, so it knows the difference between going in an elevator versus walking a flight of stairs. And all that kind of information is available to you as a user to essentially see how far you walked each day and to monitor your own health.
When you look at healthcare data, you said it interprets it in different terms. One you used was steps. If I have an iPhone and I'm walking and it registers steps, can it tell what direction I went in?
No, it's purely just looking for motion of the gyroscopes, which appears to match the pattern that it expects of somebody who's walking. It doesn't know whether you're in a straight line, walking in zigzag circles, just number of steps.
What if I had my iPhone and I was moving the iPhone, but my feet weren't moving? Would it register?
It could register some, but typically it's relatively good at picking the difference between actually walking or throwing the phone around or shaking it.
The healthcare data, does it store with date and time?
So there's two locations that health data is stored. Primarily a database called healthdb_secure, and that aggregates the information into periods of time. So you may have a 10-minute period where it says 100 steps were taken. Now, it could be that the 100 steps were taken in the first 2 minutes, and then virtually nothing was done for 8 minutes there. But there's another database called Cache Encrypted C, which is more granular. It's where the information is written originally prior to it being aggregated and moved into the bigger health database.
You also mentioned that the healthcare data has a term known as steps.
Yeah.
If the movement registers as steps, would that necessarily mean that a person was walking up or down steps?
Sorry, we're talking about steps taken or flights climbed?
I'm sorry, flights climbed.
A flight climbed, according to Apple, is essentially an incline of 3 meters over 16 steps taken. So it wouldn't really matter whether it was walking up a flight of stairs, walking up a steep inclined hill, on an escalator, something like that. If there is movement that appears to be walking and an incline of 3 meters, then that would be considered a flight climb event.
Is there any other ways that the phone could register flights climbed, but the person's not actually walking up or down stairs?
So I did test this a few months ago, driving in my vehicle. I was able to, if I just put a phone on my dock as I'm driving around, nothing was recorded. But I found that if I was actually holding the phone while driving at the same time, then the natural suspension of the vehicle plus the movement of my arm would be considered enough to be steps. And if that motion happened while I was driving up a hill, it would also result in a flight climb event. And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up the same hill multiple times.
In your studies, what elevation change would have to be present if you were in a car with a phone, and it would register healthcare data as steps. Is there a certain level of elevation that would trigger that?
Again, it's just a 3-meter incline is required.
Did you say 3 meter?
3 meter.
The healthcare data, in addition to being able to give a range of time of movement and defining generally terms, whether it's steps or stairs, is there any other information about healthcare data that is important in your analysis of this case?
Sorry, can you just repeat that, please? I'm
Sure.
Trying to think.
The healthcare data you shared tells us there's movement.
Yes.
And it may come in the term steps. You also shared that the healthcare data can show elevation. That can come in the term flights.
Yes.
Is there any other information about the healthcare data you looked at? Did you look at it across a wide range in this case?
No, it was just the steps and the flight climb that I was interested in.
What is the time period you looked at the healthcare data for in this case?
Between midnight and 6 a.m. or 6:30 a.m.
That's midnight on January 29,
29th.
2022 till about 6 a.m.?
Yes.
And before we get to any presentations, did you see movement on that phone relative to healthcare data at different points through the night?
I did, yes.
And did you identify those different times in your report?
I did.
You created a PowerPoint for Mr. O'Keefe's phone. Are those time points and movements, are they indicated in the PowerPoint as well?
They are, yes.
So you had, with Mr. O'Keefe's phone, you looked at location data, you looked at healthcare data. Is there any other data you found important in your analysis to try to track the movements or non-movements of the phone of John O'Keefe on January 29, 2022?
Yes, I've also looked at battery temperature information and at a feature called Doppler, which is monitoring for Face ID.
Tell us a little bit about the battery temperature. Is it the battery temperature of the phone or part of the phone?
There's a battery temperature sensor built inside the phone within the battery, and it's essentially always checking for battery overheats or battery cooldowns to the point where performance will be affected and the device needs to power off to save itself being damaged. So that temperature information isn't recording ambient temperature. It's not interested in the temperature in the room, for example. It's purely interested in the battery temperature. But it is affected by ambient temperature. And I, again, did lots of testing by putting the phone into controlled temperature environments, so inside a freezer for a set amount of time, to monitor how the battery temperature would decrease over time, given the environment it was in. Bringing it back into a warm environment and testing how long it takes to increase. Putting the device outside. I live in Calgary, where it's pretty cold in winter. So putting it outside, it was like 40 Fahrenheit, I think it calculates to. And the temperature of the environment had a big impact on the battery temperature that was recorded by the device.
Were you able to track the changes in battery temperature for Mr. O'Keefe's cell phone over the course of the evening from after 12 on January 29, 2022 through after 7, 8 in the morning?
Yes, there wasn't a massive number of records, but there were records that I've included in my report.
In addition to those three areas, when a person uses an iPhone and presses the buttons, or they hold it and they try to open it by recognizing their face, what is that process called?
The Face ID would be the process for the unlocking, and then the locking, pressing the button on the side would lock the device.
When an iPhone is being used, does it act or operate differently when it's out in the open or if it's in your pocket or under something?
Yes, so this is the Doppler function that I found within a feature called Unified Logs. Essentially, whenever the device receives a phone call or when you pick up the device, an iPhone X or above is trying to find a face to use to unlock the device. If the camera is blocked a record is made to say that it's within a pocket state. So if my phone's in my pocket, when somebody calls me, it tries to look for a face, it immediately recognizes that the camera's blocked, and it records pocket state. As soon as I take the phone out of my pocket or unblock the camera, it records a pocket state cleared event. So we know when the camera was covered up versus when it was uncovered, if at the time it was receiving a phone call or was being picked up.
Does an iPhone always record whether or not the camera was blocked or hidden or covered at the time a call comes in?
No. For example, if the device is already unlocked, then it won't make a recording to say that it was within a pocket state or a pocket state cleared. And if the device isn't blocked at all, so if I have the device on a desk in front of me, for example, and a call comes in, there'll be no record that says that it's in a pocket state or a pocket state cleared. It will only record a pocket state event if the camera's blocked, and it will only record a pocket state cleared event if the camera was blocked and now isn't.
So if I have my iPhone and I put it inside my jacket in the darkness and I get 30 calls, would all of those calls result in a reading of pocket state?
They'd all result in multiple readings of pocket state. The pocket state check is conducted more than once a second. I can't remember the exact number, but it's very frequent. And an average phone call from the start of the ring to when the device essentially hangs up, somewhere in the region of 500 checks. So if you had 10 phone calls, then you'll have 5,000 checks made that would all report pocket state.
Did you analyze John O'Keefe's phone on the evening, early morning hours through the next morning on January 29, 2022, in an attempt to identify where he was, what he was doing, and whether his phone was inside or outside?
That was my goal, yes.
And did you engage in that analysis, sir?
I did.
And in your efforts, did you write a report?
I did.
Did you write multiple reports on these separate issues?
I did.
And those reports are provided to everybody?
Yes.
In addition to the reports that you generated from your study, did you present or did you prepare a PowerPoint?
I did.
Does the PowerPoint outline some of those points?
It does.
At the end of the PowerPoint, do you go through a timeline accumulating many of these pieces of evidence together that show them in a chronological sequence?
I do.
And does that help capture the movement or non-movement of John O'Keefe's phone through that night?
I believe it does.
Your Honor, may I approach?
Yes.
I'm showing you a binder, sir. Could you look at it? Let me know if you recognize it.
Yes, this is the presentation that I created regarding John's phone.
And does it include some of the subject areas we just spoke about?
It does.
I'd move to introduce this as an exhibit, please.
No objection, Your Honor.
Thank you.
39.
Thank you. With the court's permission, Mr. Whiffen, referring to Exhibit 39, I'd like you to walk us through John O'Keefe's phone on the evening of January 29th,
Okay.
2022.
Yes.
Thank you. So I start the presentation with location data. As I mentioned earlier, this comes from the cache.sqlite database, which is considered the most reliable location or the most reliable file for location data on an iOS device. Stores information whenever location information is requested. That could be through user interaction with the device using something like Waze. It could be background activity, just depending on what applications the user has opened, what settings the user has chosen. It's constantly trying to find its location and recording it in this database, partly for the purposes of identifying frequent locations. At 12 minutes and 5 seconds after midnight, the device shows multiple location points at Washington Street around Forge Pond. What I've tried to show here, there's a kind of a gold dot in the middle which would show the actual latitude, longitude information. And then the circle around it is what's considered the accuracy radius. The smaller the accuracy radius, obviously the more accurate the information is believed to be according to the device. But ultimately, if the device is anywhere within that circle, then iOS would consider it correct. It considers it an accurate record.
Mr. Whiffen, why are there multiple circles of location data for one point where Mr. O'Keefe's cell phone was?
So this wasn't a single point in time. This was multiple records at around 12 minutes and 5 seconds. No application was actually in use at this time requesting location information, but the device, for whatever reason, recorded multiple records with various degrees of accuracy. Typically, you would see accuracy start quite low and get better over time, which you may have seen on your own device when you open up the map application, and it may show your device close to where you are, but not perfectly where you are, and then wait a few seconds, and that information gets refined. Essentially, this is the same thing.
So low accuracy would be a wider circle, and higher accuracy would be a smaller circle?
Correct.
At this point, Mr. O'Keefe is not utilizing Waze on his phone,
Correct.
but location data is still being stored randomly on the phone from multiple different sources?
It is, yeah. Depends on the device itself.
In the top left-hand corner, it says 12:05. That's the time that this snapshot?
Yes.
Okay. And
in
then
this
below
case, approximate.
And below it's obviously the date?
Yes.
Okay, could you take us ahead, please?
Okay. There were multiple records between that last time and what's shown on screen now at 19 minutes and 33 seconds. But all of the records were sporadic and low accuracy with values of 1,000 meters or more. But around this time, around 19 minutes and 33 seconds after midnight, is when Waze was actually brought on screen. Waze starts to ask for high accuracy data, so we see the accuracy immediately start to improve. So again, we see relatively low accuracy data to begin, and then over the next few seconds, it begins to refine itself until it gets down to a 5-meter accuracy records as the device continues up here. We'll highlight that there's a cluster of records here as the device came to either a slow or a stop. Momentarily, multiple records were created, and then the device continued driving up Denham Street.
Mr. Whiffen, below the time, 12:19:33, in the date, talks about the average accuracy.
Yes.
And that's in meters?
That's in meters. So again, the records that are shown at the bottom here are around 55 meters. The records shown at the top are around 5 meters.
Is it typical in Waze that once it locks in, the range is around 5 meters?
Typically, yes. That would be the goal.
You also mentioned the average speed. Where do you learn the speed from? Where does that data come from?
The database, the cache SQLite database also calculates the average speed between two data points, and also the bearing or the direction of travel between those 2 points. So the average speed that's shown here on the left is approximately the average of all of the records that are shown on this map at the time. And each of these map points has a directional arrow that points in the direction that the database recorded the device was traveling in.
When you look at this information generated because of the usage of Waze, and you can see both the accuracy and the speed, with the Waze information at its most accurate, can you actually tell whether the vehicle is moving or whether it stops?
Yeah, based on the speed and the location and the timestamps, you can determine whether the device is moving or stopped.
Thank you.
Also important to, I think, point out here, in terms of knowing how reliable this location information is, I typically look at something along the lines of, does the location think it's accurate? In this case, 5 meters, so yes. Does it make sense? Like, it's on the road, it's on the correct side of the road. So again, it kind of makes sense. It fits the pattern of the road. The cadence and the speed are, what you would expect for this road. Like traveling at 20 to 30 miles an hour up here seems quite reasonable So all of these factors taken together increase my confidence that this would be reliable location data. Moving to the next slide, between 20 minutes and 19 seconds and 21 minutes and 58 seconds after midnight, the device starts on the left side, on the right side at Dedham Street, drives up and turns left onto Maplecroft Road. Again, we see that all of these location points match the pattern of the road layout. They all have a consistent cadence, a consistent speed, traveling at between 10 and 20 miles an hour. And we see a cluster of records here, which is around a stop sign. So again, it indicates how reliable the data is because the location, the location data that's recorded recognize the vehicle slow, come to a stop, and then continue after the stop sign.
Is Maplecroft Road in Canton?
Yes. At the end of Maplecroft Road, the device turned left onto Oakdale Road and continued heading down there. Between the hours of 21 minutes and 59 seconds and 22 minutes and 53 seconds, the device continues down Oakdale Road. Again, all of these location points show with 5-meter accuracy. They show a consistent cadence, consistent pattern to the road. And again, we see a cluster where we see the device come to a slower stop for a stop sign. The device ultimately turns right onto Cedar Crest Avenue, I believe, and continue down there between 22 minutes and 54 seconds and 23 minutes and 57 seconds. Again, as I've said before, all of these points, 5-meter accurate, they all conform to the road. The cadence is good. And again, we see a cluster on approach to a stop sign. The device shows that it overshot Fairview Road and continued turning up Cedar Crest, but came to a stop somewhere between 50 and 51. And at 23 minutes and 58 seconds, the device appears to have turned around, so potentially a 3-point turn, in order to head back down Cedar Crest Road and turn right onto Fairview Road. Again, accuracy 5 meters, good cadence, good conformity to the road. All appears to be reliable and make sense, traveling at an average of 20 miles an hour.
And that road coming down at the bottom of the screen where John O'Keefe's phone travels, that's Fairview Road?
This is Fairview Road here, yes. The next few slides replay that same data, but instead of showing multiple points on one graph or on one map, it's going to show one location point per slide. So at 24 minutes and 20 seconds, we see the device is already on Fairview Road. Accuracy of 5 meters, traveling at 14.8 meters and heading south. 24 minutes and 21 seconds is now at 16.2 meters, but it's still highly accurate information. 24 minutes and 22 seconds, traveling at 18.3 miles an hour. 24 minutes and 23 seconds, traveling at 16.9. 24 minutes and 24 seconds after midnight, traveling at 16.9. 24 minutes and 25 seconds, traveling at 16.6. 24 minutes and 26 seconds, traveling at 17. 24 minutes, 27 seconds, traveling at 15.9 miles an hour. And at 24 minutes and 28 seconds, traveling at 14.5 miles an hour, at which point it's approximately outside number 34, around the driveway area. 24 minutes and 29 seconds, traveling at 12.1 miles an hour. 24 minutes and 30 seconds, traveling at 11.5. 24 minutes and 31 seconds, traveling at 10.4. 24 minutes and 32 seconds, traveling at 8.9. 24 minutes and 33 seconds, traveling at 7. 24 minutes, 34 seconds, traveling at 5.2. And 24 minutes and 35 seconds, traveling at 3.5. 24 minutes and 36 seconds, traveling at 3.2. miles an hour. And at 24 minutes and 37 seconds, traveling at 1.4 miles an hour. Finally, the device comes to a complete stop at 24 minutes and 38 seconds. I'll say from the testing that I've done related to the speed, it may not be 100% accurate, but it's a very good indicator of the speed in general. So if it says it was traveling at 10 miles an hour, it would have been traveling at somewhere between 9.5 and 10.5 on average.
Mr. Whiffen, you just showed us the travel of Mr. O'Keefe's cell phone around 12:24 to 12:24:38 on January 29, 2022, and you said at 12:24:38 it came to a complete stop.
Yes.
Before that complete stop, was the car continuously moving at some speed?
Yes, this is the first record that shows 0 miles per hour or 0 meters per second. Prior to this, there was always a record that showed some level of speed.
If you look at number 34 on that chalk, if you can highlight it, please. Okay. If the driveway were at the right side, the top side of the house.
Yes.
Does your studies indicate that the vehicle, or at least the phone, traveled past the driveway before it stopped?
Objection, Your Honor.
Ask it non-leading, please.
Did this car or the phone that was in the car ever stop at the driveway of that address?
No, according to the location and the speed data from the device, by the time it was approximately the driveway, the phone reports it was still traveling at around 15.9 miles an hour.
Have you ever seen a photograph of that address?
I have.
You have or have not?
I have.
You have. And in that address, do you see on the far left corner of that address, the yard, there's a flagpole?
Yes.
Where this car stopped, so this phone stopped at 12:24:33, how close is the phone to that flagpole?
I believe very close.
And do you ever see the car or the phone stop anywhere near that driveway?
No.
Please continue.
Between 24 minutes and 39 seconds and 25 minutes and 8 seconds, there were a cluster of more records, all showing 5-meter accuracy, but no movement. Although the center point does move around a little bit, you could interpret this as movement, but because all of the radiuses or radii overlap, there's also a good chance that there's no movement that actually occurred here. This is just the device as it's trying to refine its location. At 25 minutes and 30 seconds, we see a relatively significant change where the accuracy drops to 34 meters. We do see a course or a bearing that shows that the device reported it was heading west. But again, this accuracy radius includes the previous locations anyway. So it's difficult to differentiate between actual movement based on this location data or just on the fact that the accuracy reduced, the center point shifted because of that accuracy change, and therefore a bearing was attributed to it when it shouldn't have been.
If I could ask you some questions about the chalk on that indicates 25 minutes, 30 seconds, so 12:25:30. The circles become larger.
Correct.
Is Waze still being used, or has Waze been stopped?
No, Waze has been closed at this point for about 40 or 50 seconds.
For how long, sir?
About 40 or 50 seconds.
This location data, or this circle, the perimeter, that's not coming from the Waze application anymore?
No, the location data never came from the Waze application. Waze was requesting location data. iOS is responding to that request, and as part of that response would write the information to its database. Waze itself records very little location data.
So when you look at that circle based on location data alone, could the phone be anywhere within that circle?
Correct.
There is a bullet pinpoint center of that circle?
Yes.
That center of the circle doesn't necessarily mean that the phone is at that exact location, does it?
It doesn't, no. The center point is purely an indication of where you need to draw the center in order to draw the radius. If we didn't have a center point, how would you know where to draw this circle?
And so the phone could be anywhere in that circle, close to 34, inside 34, 32.
Objection, Your Honor.
Ask it non-leading, please.
Could the phone be anywhere in that circle?
It could.
Could it be at the center point?
It could.
Could it be still in the car?
It could.
Continue, please.
Between 25 minutes and 31 seconds and 25 minutes and 36 seconds, there's an additional cluster of location data, ranging between 61-meter accuracy and 17-meter accuracy. All of them roughly centered on the same point, approximately, and all of the accuracy radius covers the same area. Like, there's so much overlap in these records that the device is essentially anywhere within the smaller circle. Between 27 minutes and 35 seconds and 38 minutes and 15 seconds, there was approximately 50 low accuracy records. Again, the device wasn't being used to ask for location data. This is completely passive and resulting in some pretty poor location data. I've highlighted with the red arrow where the 34 Fairview Road is. And we can see, although a lot of these location data do overlap with that point, there are location information here that doesn't. At 38 minutes and 16 seconds, the accuracy improves again. Is now 18 meters accurate, but continues to show approximately the same location that we saw 10 or 15 minutes earlier, around the flagpole area. 38 minutes and 17 seconds, same general area, slightly higher accuracy information down to 14 meters. 38 minutes and 18 seconds, accuracy increased to 12 meters, shifted slightly. Now the flagpole area is essentially at the lower side of this circle. Obviously, the top side of the circle now includes a part of 34 Fairview.
If the location information is indicated by the circle and the circle has shifted, does that mean necessarily the phone has moved?
Not necessarily. Typically, you could assume it has, but when we're already talking about accuracies of 12, 13, 14 meters, it starts to become a little bit harder to determine how accurate this data is. So at this point in time, it could be anywhere within this circle, and the movement of the center point could just be the result of refinement of the device or environmental conditions that suddenly change. If the weather changes, it could cause the device to slightly miscalculate or to calculate differently.
Would a snowstorm or a blizzard potentially impact the precision of location information that's not precise like Waze?
It definitely has the potential to, yes.
How about a phone being covered? Could that affect it?
That could also affect it, yes.
If somebody was lying on a phone, could that affect it?
That could affect it.
Could being in a building affect it?
It could.
Thank you.
We've done that one at 38 minutes and 20 seconds. Again, refining information more. We've got an 8-meter accurate radius, still focusing primarily on the front yard towards the left side. And then accuracy of 7 meters at 38 minutes and 21 seconds, again showing that same general area. Between 40 minutes and 22 seconds and 59 minutes and 29 seconds, accuracy fairly drops off again, and we see some fairly wild records that don't cover the area at all. But we also see some more accurate records showing, again, where the red arrow points at Fairview Road. Those records are highlighted here, just between 40 minutes and 22 seconds and 59 minutes, 29 seconds, only showing records of 25-meter accuracy or better. And again, it's kind of focusing on that flagpole area. Between 1 a.m. and 2 a.m., only looking at location information, which is 25 meters accurate or better. Again, it kind of focuses around the front yard area, although some of these accuracies are still rather large and could put the device inside 34 on the opposite side of the street, towards 32. Between 2 a.m. and 3 a.m., fairly similar story. Again, most of these points are centered around that same location at the front yard. Similarly, between 3 and 4 a.m., between 4 and 5, between 5 and 6. And in fact, if I take all of the location data between 25 minutes after midnight until 6 a.m., only looking at the records that report 10-meter accuracy or better, then typically they all focus around that same location at the front of the yard, nearish to where the flagpole was found.
I'd like to ask you some questions about this photograph. There's a red circle with a bunch of red dots in the middle.
Yes.
Would those red dots indicate the center of some location that was captured at a particular point over that night?
Yes. So each of those center dots is the center of a 10-meter accurate or better location record. I chose to not show the accuracy radius circle on this image, just purely because it makes it hard to see when you've got all these intersecting lines. But ultimately, if you were to draw a 10-meter radius around all of these points, they would all fall within the large red circle that's shown.
So this photograph was meant to take readings from the most accurate of the data throughout the night?
Correct.
Objection, Your Honor.
Sustained. Ask it again differently, please.
Was this circle, did it include low frequency data?
No, this circle only includes 10-meter accuracy or better.
The fact that the center dots are in different spots, is that inconsistent with a phone being in the same place, not moving that entire night?
It could indicate movement. It could indicate refinement.
Is it impossible to tell?
It's impossible to tell at this level of detail anyway.
Are all of these dots, given the range, 10 meters or under, are all these dots and all these readings of the high frequency data that you compiled for that night, are they all consistent with Mr. O'Keefe's phone being near the flagpole and not moving that night?
Objection, Your Honor.
I think that's a reasonable assumption.
All right, this might be a good spot. Are you ready to move on to the next area, or you have any more questions about
Now would
this?
be a fine time, Your Honor.
All right, folks, why don't we take our morning break, 15, 20 minutes? We're going to see that there for 15.
Thank you.
Judge, please leave the notebooks for on the seat. Please rise for the jury.
Okay, well, I guess we're on a morning break, so that was fucking fascinating. Just saying. Basically, they just debunked all of the FKR nonsense that has been pushed out there for so freaking long. The up and down stairs, the Google search, all the nonsense. Oh shit, yeah, I gotta plug this in before I die. Sorry guys, my phone is
Hey
like
there,
starting to
Karen
die.
Watchers.
Oh, come on.
We cover them.
I don't want to hear you, guy.
Unfortunately, very unpredictable. And I'll tell you what, having a great lawyer matters so much. That is where a great partner and sponsor Morgan & Morgan comes in. This is a firm with over 1,000 attorneys. You know why? Because they win a lot. In the past few months, Morgan & Morgan secured a $9.3 million verdict for a car crash victim in Florida.
This is usually pretty quick, guys.
$5 million verdict for another car accident victim in Atlanta, and not to mention $1.8 million in Kentucky after insurance offered them a mere $5,000 in that case. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. That's it. It could all be done on your phone. So if you're injured, you can easily start a claim at forthepeople.com/LC Live by clicking the link below or scanning the QR code on screen.
All right, well, now that he shut the hell up, because that's the way that they're advertising now on ad-free, because we have ad-free. Like, I love that they sneak their little advertisements in there. Thank you, Lauren Crime. We very well appreciate it. But you are right, B-Tim. She's screwed. Absolutely, absolutely freaking screwed. I will be home in less than 10 minutes, so thankfully I can hop on the computer when I get there. But I think that was fascinating. They debunked all of the, and that's what I also noticed is, as we pointed out earlier, oh yeah, and for all of you who weren't reading the chat, officially SCOTUS has denied Karen's even looking at her case, as predicted, as I predicted, and as most normal people who know anything about the law or the Supreme Court noted, she was denied, done, over with. Like, there's nothing left for her to do. Sorry, not sorry. The Supreme Court said go after yourself, as they should. They're not going to look at her case, and so that's the end of that. So just that announcement, because that happened this morning. I didn't want to interrupt, obviously, testimony for that, but Brittany was kind enough to put it in chat. So that happened. So she's basically ultimately screwed now, because that situation has now been brought all the way around these appeals, and all the courts have basically said, yeah, no, we don't see an issue here. Sorry, not sorry. So that happened. But yes, B. Tim, I agree with you, my friend. She is ultimately freaking screwed. Ian Whiffen just eloquently explained and showed us exactly why Jen McCabe didn't delete anything, why it was deleted by the phone or the software, not by a user, and explained how. He also debunked the 2:27 a.m. again.
You know, people attacking her.
Again, right? Like, once again. And I think they're also going to use Jessica Hyde at some point as well to, like, double debunk it. But I find it fascinating that FKR is still believing half of this crap that has been debunked by, and harassing Jen. Like, the woman told the police what happened. It was after 6 a.m. And it's been proven over and over and over. I think we might see Jen next, B-Tim. I do think it was smart bringing him up before Jen. So if he starts the 2:27 a.m. crap, exactly, it'll fall on deaf ears. I fully believe that was a smart idea, but I do think that maybe Jen is next.
And isn't that what the opening statement said? 2:27 will be proven?
Yeah, I think he did say something about it. And it's like, bro, sorry, not sorry, but 2:27 a.m. has been debunked numerous times by numerous individuals. I don't know how many more times. Like, the jury isn't going to buy it. So I find it fascinating as well that John DePetro was, he's in the court, and he was reporting from court that the jurors were very intently listening to Ian Whiffen. And of course, what do you hear from the sewer turtle except, oh, they're not paying attention, they don't even care. Like, of course he would put out that narrative, because in his brain, he has to say that, and he has to, tell his audience that it's going badly for the Commonwealth, even when it's not. Even when the jurors aren't listening. John DePetro has no reason to lie. He has no fight in this game. He's not making money off of this case. Like, none of it. None of it. Yes, Hank is a seasoned prosecutor. Like, he's dealt with, like, federal stuff. Like, he knows what he's doing, like, Jen doesn't specialize in iOS. She's just another person. She has no idea how, the phone puts things in the background, or why it, like, deletes off of your, like, call log instead of having, like,
She'd have to be very technically savvy.
Well, that's the thing. And it's been proven over and over. She didn't delete anything. The phone or the software did, but Jen. Oh, sorry guys, my internet's. I'll be home in literally, so we won't have that interruption in a second with the with my audio going in and out. It'll be over in about 2 minutes. I'm literally heading to my house right now, and I will be there in 2 minutes, so we won't have any interruptions on that, and I'll be on screen again. My mess self from being out all morning. I'm tired. I'm not a morning person usually. I'm up
that early.
I know that's.
They can't let people out in the world at that time.
They do. They let people out in the world at that time. Unfortunately, that happens. I do think this is exactly why SW he tried this BS. it's not shocking to me that he's trying an angle and trying to also give the defense an angle to get something they're not entitled to by making shit up. It's not a shocker to me at all. It's actually like pretty easily predictable when it comes to him to try something like that. Nope, it's the yard guy. Hold on 1 second, guys. I'm pulling up at my house and I need to get inside and bring some things inside. So give me 1 second. Give me 2 minutes, guys, and I'll be upstairs. I just gotta bring all this stuff up and
Just staying up or going out?
going up, up, up. All right, give me a minute, guys.
Okay, I'm back. I am back. I am at home. And here we are. Also, I just want to say real quick, shame on Joann's. Okay, they're closing. They're going out of business. But Ash had a gift card, and they are supposed to take them until they close. Like legally speaking, they're supposed to take them until they close. And they decided that doing that. Sorry, guys, I don't know what just happened. My internet like conked out for a second. And now it's telling me I have one bar. That makes no sense. I'm sorry. We went on a field trip today, guys. It was a field trip. It was a field trip. I have the first donation of the day. Scorpio Moon sends $5. Thank you, Scorpio. I appreciate you, my friend. If anybody else wants to make a donation to the channel, that is the first one of the day today. I would really appreciate it. It's definitely how we get by. We only get by from donations from our viewers because we don't have monetization yet. So we do have an Apple Pay link for people who want to pay with Apple Pay. Free can put that in the chat. It really helps. You guys know that. I don't, paying costs and being such a small channel, like in trial days for some reason are much slower than just regular days where I stream for a few hours when it comes to donations. And I know it's because we're all paying attention, but I'm here double the time. So I couldn't predict. It's funny because like sometimes I'll make like more donations on a Sunday than I will on a Friday. Make that make sense, guys? I don't know. But it's always very well appreciated because that's the only way that we get anything from the channel. We don't get paid for views. We don't, not that would matter, but the only way we make anything and cover costs is from you guys. And we very well appreciate it very, very much, because if it wasn't for you guys, where would we be? And we're slowly growing. Like, big round of applause for that. We are slowly growing, and I'm very proud of the community we have built here. There's 282 of you here currently watching on 2 platforms. I haven't bothered really streaming from Facebook lately. Maybe I should, but I just don't. It seems to be more trolls than anything else when I stream from Facebook as well. So I've just been doing X and YouTube. But I really appreciate everybody's support and the kind words. I love when I get an email from one of you. I get emails from you guys all the time, and I love it. You guys will direct me to something I need to see, which I love. Please don't stop doing that. I love when you guys do that because I might miss something too. I'm only human. So I wore my sweatshirt out today. And by the way, let me take it off. Hold on a second, because I am sweating to death. But I wore my sweatshirt out today, and I was watching people's faces, like as they looked at me, and I could definitely tell that there was some FKR people at the Mary Lou's we went to, which is not the normal one that I go to, and that there were some out in public at the places that we stopped at along the way. So I just find it funny the way they react to it. You know, you would think that they would be like, hey, that's a good thing, justice for John, whatever, like, or just not make a face or not say anything at all. But it's amazing to me the actual like way that they look, the faces that they make, like the scoffing. I love that one when they scoff a little, when they go and scoff a little bit. I'm like, get over yourselves. Like, you don't like my sweatshirt? Too bad. It's in memory of, and hopefully it's a statement of justice is coming. And I think Hank did an amazing job this morning of showing that when it came to Ian Whiffen. Although I do think that we got a big problem coming, because we have a lessee apparently who's going to cross-examine, and he's going to go into time that possibly could be used for ARCCA, as we know, because he is long-winded and he says ridiculous stuff over and over and over without making his point. I honestly don't know why they're letting him cross-examine such an important witness for the Commonwealth, because everything he says is going to be lost on them. Nobody's going to know what to do with him. Like, the jury's gonna listen to it for about 10 seconds and then be like, what did he just say? Like, what did he just say? Also, by the way, my shirt today is brought to you by me, and it says, if you find me offensive, then I suggest you quit finding me. Like, so sorry, FKR. Don't know what to tell you. Here's an idea. Stop following me on X, you weirdos. just to hate watch or insult, because you'll just get an insta block. It's a waste of your finger push-ups. Like, come on, man. Like, I do believe we will see Jennifer McCabe possibly today, if that's a big fat if Alessi doesn't become a long-winded windbag, of course. You know, like it is very revolting. He's telling a completely different story. I'm sorry, Ash. You know what? We can always go out for lunch one day. I feel like I need to take you out for lunch for being a good friend and pay for the lunch, because you're such a good friend to me, especially when I have to get somewhere. I appreciate you as a friend, and that's what we need to do. We need to do lunch on me. So the next half day court has or weekend, me and you, we got a lunch date, my friend. We got a lunch date. It's my treat for helping. I don't have a car. It's very difficult to get places. Like, I need to do laundry desperately. I need to get to to the laundromat. I appreciate all of you guys. I appreciate all of you guys more than you guys probably know. Yeah, she was driving. They should let Jackson cross, beat him. I agree. And also, everybody knows, like, I just throw this out there, but everybody knows that, like, when I come onto YouTube and I do my show, anybody who's been on a panel with me before on my show knows that they're more than welcome. People like Bree or B Tim, Sunny, anybody who wants to is more than welcome to pop up on a panel and say what they need to say when it comes to this trial, whether it's on a break, at lunch, or whatever. Because my viewers do appreciate listening to you guys too. They appreciate listening to Sunny, you, B Tim, you, Bree, and all the other people like Voices and other people that I've streamed with on this case. And you know, I miss Erin, actually. She's very, very smart. One of the smartest people I know, especially when it comes to the law. And she's a great person to stream with. I miss doing some streams with Erin, aka Dubs. I'm hoping. That's the thing. And then you want them to do ARCCA too. So it's like, oh, come on, man. Like, yeah, I'll send it to you now. Please hold while the next Till subscriber you are trying to reach is located. Just saying. Email. Come on, phone. Email. Nope. Computer. God damn it. Gmail. Always welcome, my friend. All of you guys are. We like to hear what everybody else has to say sometimes. Not just me and my big mouth, you know. It's sent over to you, B Tim, in your email. See, did I not say this morning? I mean, even if that's a joke, like, did I not say this morning that that's something they would come up with? They missed their flight was delayed, like some excuse on why they can't be here. Guaranteed. I said this morning, and even if, I mean, we don't know if this is true or not, but still, if it happens, like, we can definitely say that I predicted that. I guess I'm pretty damn good when it comes to predicting shit, huh? Beat him!
What's up? Yeah, this is pretty devastating. Actually, I think this guy's better than last time, because he literally had like a timeline of when the car was traveling. So I don't know how they're going to come back with the Apple steps when this guy is using this detailed formula to literally track the car down as it's driving down. I don't know what they're going to do, to be honest with you. I don't know what card trick they have up their sleeve, to be honest with you. And I think the problem with Alessi,
I want to know how they're gonna do anything with that.
Yeah, I think the problem with Alessi is, like, he's good at, like, basically, you know, kind of putting motions together, whatnot. But the problem is he's not good at being a compelling attorney that tells a story to a witness and does a good cross. I just don't see him doing a good cross. I think he's going to be too long-winded, and I think that he's going to lose the jury. And I don't know what he's going to do. And he doesn't have the same
I agree.
Showmanship as Jackson. I just don't think he has it. I think it's going to be a disaster situation.
I don't think he does either. And for me, yes, I think that's exactly it. I was just about to say, I think it's just going to be a disaster for the defense, because they really they're not going to have anything to really counter this with. And like you said, Alessi's way too long-winded. So, like, the juror's going to miss the point completely because he just keeps going and going. He'll ask irrelevant questions. He'll say, we're going to get to that, but never get to it. Like, so it's like, he doesn't know when to like quit or stop to make his point. And like, that's going to be like, the jury is not going to hear a fucking word he says.
I mean, we looked at him cross his own witness, the dog bite lady that they're witness, and it took how many hours for him to get to the point for his own witness? Like, how many hours? 4 hours? Like, at that point,
it was a lot. It was a long time.
Yeah, it was just ridiculous. It's like your own witness that's going to agree upon everything you say. It should be like lickety split quick. You know what I mean? Unless they have a lot of stuff to talk about.
Exactly. If you already know, they're going to agree. Why isn't it quick? You know? Like,
no, he's going to cross
it should
unless
be
he's
really quick.
Yeah, I think they're not going to send Jackson because Jackson, I think, is an incompetent fool, and they know he's incompetent. He keeps on opening the door to the prosecution, like the last witness, where he opened the door to the relationship, like how they were the relationship with Karen Reed and John O'Keefe. You know, the friend.
That's right.
That was testifying. He opened the door. He's incompetent.
Yep.
He's like completely incompetent. They only have him on that because they need him so they can practice law in that state. That's pretty much it, and he knows it. He's probably playing fucking solitaire.
Yannetti's the one who's from here.
Yeah, Yannetti. That's
Yannetti's
what I'm saying,
from here, but I think at this point they've benched Yannetti pretty much for most of this. His questions are kind of out there anyway, even when he's crossing. Jackson does too much, where he opens the door to the point where like you're hurting your own client. Repeating how many times she said I hit him just hurt Karen. Make the point and move on. Going over it for 2 hours about whether she said it 2 or 3 times does one thing, which is allow the jury to know that she said it at all.
Well, I mean, it kind of refutes it when you have your own client admit to a fucking documentary that she said it and she wasn't sure how many times she said it. It's like she said it. It doesn't matter if she said it 1 or 3 times. She said it. The whole point is that she said it.
And they heard it. Yep.
That's pretty much it. That's pretty much it.
Yep. And he risked, I said it at the time, he risked putting it in the jury's heads that she said it at all instead of just moving on from it.
Like, yeah. And I think they're going to have more with this cell phone data because I feel like they've really got into it. And I think
they have Jessica Hyde too, right? So they're going to use her at some point.
Yeah. And I don't know what the ARCCA witnesses, I think the ARCCA witnesses have destroyed their credibility. And I don't see them. And I'm kind of shocked they're not here. What do you mean that they're on a flight? Like, what's the situation with the ARCCA witnesses?
They should already be here. They should already be. The ARCCA witnesses should already be here. They shouldn't be on.
Yeah.
I heard they should be. We don't know if they aren't, but that's a rumor, obviously. But I said this morning, I said, watch, something's going to happen. They're going to say the flight was delayed or they missed their flight or something to make some excuse on why they can't be here.
Well, they live in Pennsylvania. They live in Pennsylvania, right? Their office is
yes. Yep.
They can literally get from here to Pennsylvania. Doesn't take fucking 10 years. What are you talking?
No.
Like, are you serious?
It's like 8 hours or something like that. Yeah.
I mean, like, see, flight
insane
from
to me.
PA to Massachusetts. Let's see. It's literally an hour and 38 minutes. Like a flight, and it's
a
like
flight?
Yeah, nonstop flight.
Yeah, a drive would be, I think, like 8 hours.
Yeah, a drive, like but who's gonna fucking drive? It's 6 hours actually. 6 hours and 19 minutes.
6. All right, that makes sense. Yeah, 6 hours to go through from Pennsylvania to here.
I would rather pay the $137 for the nonstop flight than do a 6-hour drive. To be honest with you. To be completely honest with you, I'm not gonna fucking drive for 6 hours.
The sewer turtle said it, I guess, Tim. The sewer turtle said it. There's a rumor they're not gonna make it today. Well, if they don't, we can all say that I fucking called this at 8:30 this morning.
Well,
just saying.
How are they going to be allowed up if they're not going to be allowed to do the voir dire? Because there was a voir dire.
I don't think they're going to. The judge is not going to appreciate the delay thing.
Yeah, like first off, it's bad enough that you had this last minute voir dire. I thought it was too generous actually to allow these clowns up after deleting up through 100 messages of communications. I mean, are you serious? It's like, well, it has the auto delete. I'm like, bro, you're in the middle of fucking trial and you're telling me you don't save any of your stuff.
You have to. For the record.
What is it? Yeah. It's just, I think the fact is that they knew they fucked up and they rather get into trouble deleting the messages than the actual messages coming out.
I think that's exactly it. I think they'd rather say like, oh, they're all deleted than actually have them come out, or have them use a few inconsequential ones that don't really mean anything and have ARCCA bring those and then say the rest are just deleted. Which again, I think either way you do that, the judge is going to find it suspicious. You're going to tell me both sides magically deleted everything all of a sudden? Come on. She was offered 18 months in the very beginning. 18 months that she denied.
Yeah, and she probably would have gotten out.
That was her first and only plea deal that she was offered. That was the only plea deal she was ever offered, was 18 months in the very beginning.
Yeah, I mean, she was offered. She would have been out like a while ago, actually, like years ago. If she would have taken that deal, she would not have gotten sued.
Time.
She would have still had her house. She would have still had her house. She would have still had her money. But the fact is, I think she's a narcissist, and I think she likes the attention from this. I think she really likes the fact that there's a bunch of people that are really worshiping her. And that's what I think it is. I think that's why she doesn't really regret this situation. Like, she really, I don't think there's any, like, kind of redeeming factor with her at all. I think Jackson's
even when they talk about John.
Mm-hmm.
Oh, you think that too? I think that too.
Yeah, I think see the body language.
Look at the distance. Yep. Look at the distance they put in between each other, and then look at like the way that like she tries to hand him something or paperwork, and he's like, "No, I know where it is." Like, because he's the fucking lawyer, Karen. Let go. Your control issues are showing to the jury, you weirdo. I've never seen a defendant have their nose in a computer the entirety of their own trial. Ever.
Yeah.
Like, they're not even paying attention. Like, they couldn't even care about their own trial. Like, how does she think that that's going to play with a jury? Just saying.
That doesn't look good. I mean, like, you usually want to look like you're very sympathetic to the jury and not someone that doesn't give two fucks about your ex-boyfriend being killed. Like, there's no emotion that she shows. The only emotion she shows is when they embarrass her for being the alcoholic that she is. Yeah. Or embarrassment for her being an alcoholic. Or anger. Anger and embarrassment. They're two things. Not one thing.
You'll never see a sadness or anything like that, any sort of remorse. Like, she's indifferent to it, and like even will go as far as to have those very snarky like looks on her face. And it's like, you know that didn't play well with the jury in the first trial. The jury talked about your looks and how you couldn't help yourself. Like, the fact that you still don't have them under control at this point is like, she's completely oblivious. And you can see it again. Like,
what happened to her brain? Whatever happened to her brain cancer? Didn't like Jackson say she had like a tumor or some shit?
Yeah, Yannetti said that there was like she had some sort of tumor in the very beginning. Yeah.
Where is that? Did she just like magically get cured of her tumor in her brain or something? Like, they want to excuse why she's doing these facial reactions. Like
MS, right? Like, listen, Jen McCabe has MS. I have fibromyalgia. MS does not make you look like resting bitch face. I'm sorry. That's not a symptom of MS. Like,
well, she smiles for when she does the photo ops with people in dinner.
Yep. The fake smile, though. You can tell it's totally fake, and she doesn't want to be anywhere near those people. Like, she does because they give her money. Like, she's not like me. She's not a people person. She's not like, hey, the more the merrier. Like, I'm a people person. I love people. I'm like, all right, everyone's invited. Like, let's do this. Yeah.
Can you read us your shirt again? Can you read us your shirt again? Does that tell us how much of a people person you are?
It's just stop looking for me. I mean, I'm a people person until you start being like a complete asshole, and then I'll give you a fucking reason to be a goddamn asshole. But other than that, I do happen to like people in general. Like, it's just shitty people that I don't like. And there's so many shitty people that came out of the woodwork for this case that they've made it an absolute circus. Like, that affidavit that woman put on paper, lied, and handed to Turtle Boy's attorneys that he didn't even believe, okay? And then said it in a live stream like a moron, just goes to show they're willing to do anything. Her team and his team, willing to do anything to get out of responsibility for the things that they themselves have done.
Well, I mean, I think the situation with Turtle Boy is that I think he knows that lady's guilty, but he thinks that if she gets not guilty, it will save his ass, and that like somehow because she's not guilty, they can't prosecute him for witness intimidation or stuff like that.
Yeah, he's been saying that, and it's like, are you fucking stupid, bro? Like, that's not how it works. You still get charged. You still committed the crime at the time that those were witnesses.
I like, put this as the scenario.
Not guilty.
I use
His
this
will
as a
disappear.
scenario.
No.
Yeah, I use this as a scenario a lot, which is basically, let's say you get convicted and you go to jail, and then once you're in jail, you try to do a jailbreak, and they find out that you're innocent of the initial charge. You still have to serve time for breaking out of jail because that comes with an added time. So we're back. They need to like advertise Court TV on that fucking fan. Each blade of that fan should be an advertisement. Like Monster Energy drink, Starbucks.
We are back. Well, the whole fan has its own persona at this point.
See, that's a clean fan, by the way. Someone's cleaned that fan.
Right? They have to be because they know that thing's the center of attention.
Yeah, that fan gets more airtime. That fan has more personality than Karen Mead.
It does.
All right, Mr. Brennan, whenever you're ready.
It literally does.
I'm gonna jump down. I'll listen to this. I'll see you. I'll jump up when it's like on break.
Mr. Whitman, before we go into the next subject area, I'd like to ask you about the location data. Based on your review of the location data, do you have an opinion whether the location data throughout the evening is consistent with John O'Keefe's cell phone being near the flagpole the entire night?
I believe it is, yes.
I asked you whether you had an opinion whether it was consistent with. I didn't ask you if you had an opinion to a reasonable degree of scientific certainty. Are there other things that you looked at that you will consider in addition to the location data to have a more certain opinion?
There is.
And is the next thing that you considered Apple healthcare data?
It's the Apple Health data, yes.
We asked about it, or I asked you about it earlier on, but I just want to talk about it a little bit before you show us and present to us the data that you've compiled for us. Is Apple Health data different than when you have like an Apple Watch?
No, it's the same Apple Health data recording on the phone or the watch. The only difference is the sensors being used to do that monitoring. So if you're just using the phone, obviously you're only using the sensors in the phone. It's limited to steps walked and to altitude climbed. If you're wearing a watch, it can also do those things, but it can also add things like blood pressure monitoring and things like that.
Does Apple Health data require an internet connection?
It doesn't, no.
So it's all self-survives on the phone itself?
It is.
So without having an internet connection, it will still store the data?
Correct.
If I have an iPhone, is it storing health data even if I didn't ask for it to do so?
Yes. Unless you actively turn the feature off, it will by default try to track movement.
Is it something that is hidden that I wouldn't see unless I look for it?
No, there's an application for Apple Health, and then the settings are quite obvious in the settings screen.
Apple Health data tracks movement of the phone?
Correct.
When you were considering the Apple Health data in this case, did you begin looking for the Apple Health data before Mr. O'Keefe's phone began approaching Fairview Road?
Yeah, I started again at around midnight and looked at the health data up until 6:30 a.m. on the 29th.
The different points when you track Apple Health data, is that helpful even if you're only trying to isolate a certain point in time?
It can be, yes.
Does it help determine whether or not it was working properly? If it was,
it can determine whether it's working properly. It can determine an average kind of walking speed, for example, of a person, the average gait that the person may walk with, if that was important.
If a person has an iPhone and they're moving and it registers Apple Health data, and then they stop moving, and the healthcare data doesn't register because there's no movement, would the Apple Health data resume movement even if somebody else picks up the phone?
It would. The phone itself doesn't care who's carrying it. It just looks for movement.
So it doesn't identify the owner in order to register movement?
Correct.
Objection, Your Honor.
Does it identify the owner in order to register
Better
movement?
question.
It doesn't, no.
Could you turn to the next part of the data analysis that you did,
Yes.
please?
So the two sources that I got the Apple Health data from were a database called healthdb_secure.sqlite. This as I said earlier, is the typical database that's used to store long-term information about the health activity that's been recorded. So this database can have years worth of steps taken, flights climbed, and any other kind of health data that's been recorded. The downside to that is that the information is aggregated. So you see chunks of time and multiple activities can happen within those chunks of time. The cache encrypted C .SQLite database is much more temporary, but is much more granular. So we can see exact times that flights were climbed, for example, or at least you can see the exact time that the flight climb was recorded to the device. And then that information is aggregated into the larger chunk of time. So again, we might see within the cache encrypted C individual flight climb events that occurred, for example, 30 seconds apart. But by the time that information is written to the Health DB Secure, you're now looking at a 10-minute time period with 3 flight climb events, as opposed to 3 individual flight climb events with individual timestamps. Typically, that source is not used because the data is not stored there for very long. The information I found on John's phone was essentially these 5 records. So between 11 minutes and 9 seconds and 21 minutes and 5 seconds, there were 170 steps recorded by the device.
Mr. Whiffen, I'm going to stop at each one and ask you some questions. At the time period between 12/11/09, 12/21/05, you don't have any independent information where John O'Keefe or his cell phone were, do you?
The location data that I showed to begin with on Washington Street was around 12 minutes after midnight. So the presumption is that's where the location was at that time. And then 21 minutes and 5 seconds, the device had already started using Waze. It was already driving along Denham Street or had turned onto Maplecroft.
What time did you say that Waze was initiated?
It was approximately 19 minutes and 30 seconds-ish.
Thank you.
Again, we see at 21 minutes and 10 seconds until 24 minutes and 22 seconds, there are 80 steps recorded. And again, if you compare this to the location data, we know that the device was in a vehicle at this time. Between 22 minutes and 14 seconds and 24 minutes and 37 seconds, we have 3 flight climb events that are aggregated into that time period. And again, the location data shows that the device was traveling in a vehicle at that time.
Mr. Whiffen, you had showed us a slide of 2437 on January 29, 2022 in your PowerPoint presentation, noting at that time, 12/24/37, the phone in the car was still traveling at 1.4 miles per hour.
Correct. This is about a second before it came to a stop.
Can you conclude to a reasonable degree of scientific certainty that that period of 12/22/14 to 12/24/37, Mr. O'Keefe, or at least Mr. O'Keefe's cell phone, was still in that car?
Yes, the location data shows it was in the car at the time. And my next few slides will demonstrate why that was still recording a flight climb event while it was in a vehicle.
Thank you.
At 31 minutes and 56 seconds until 32 minutes and 16 seconds, there were 36 steps recorded. And then there was no further health activity recorded on the device for several hours until 4 minutes after 6 a.m. When 432 steps were recorded between the time of 6:04 and 6:11.
Let me ask you about that 12/31/56 to 12/32/16 time period. We can see larger ranges in the time period range. That is a smaller range comparatively.
Yes.
Okay. At 12/31/56, is that the beginning of the 36 steps?
Essentially, yeah, it takes the timestamps from the cache encrypted C, looks at when the first step occurred, looks at when the last step occurred, and aggregates the times based on that.
So 12/32/16 would be the last steps taken for that cell phone.
Correct.
And in between that time period, there's 36 steps. You shared earlier that it doesn't indicate the direction of the steps.
Correct.
Other than the movement that equates to steps, can it tell anything about what direction, the positioning, how the phone was moving?
It can't, no. It's just purely registered what it thinks are 36 steps.
Could it have been a straight line?
It could have been a straight
Could
line.
it have been somebody pacing?
It could have been.
Could it have been somebody moving and jumping?
Yes. Jumping, if they were jumping forward, essentially.
After 12:32:16, when this phone took its last steps, it never moved again?
Objection, Your Honor.
Form of the question sustained.
After 12:32:16, when this phone took its last steps, did it move again until 6:04:01 a.m.?
There were no more steps or flight climb or any other health activity recorded during that time.
Do you know what triggered movement at 6:04:01 a.m. of Mr. O'Keefe's cell phone?
I presume that the device was moving at that time, but I don't know the details of who.
Objection, Your Honor. Move to strike.
I'll strike it.
Please continue.
Okay. Regarding the flight climb events, looking at the cache encrypted C database, I was able to find more granular, accurate timestamps for these records. And I showed those timestamps on this map at the position that the device was, according to the location data at the time.
So you're going back to earlier in the evening now, 12:22:14.
Correct.
To 12:24:37 when the phone stopped near the flagpole.
Correct.
Okay, thank you.
So we have the first record at 22:17, a flight climb event was recorded. I've highlighted that was a red line, and that equates to the red line that shows underneath the timestamp where the location was, where the device was at that time. The second record is 22 minutes and 32 seconds, showed with the green line, which shows over here. And then finally, 24 minutes and 37 seconds after midnight, shows with an orange line down here outside 34 Fairview. I'd like to point out that health activity events are recorded upon the event completion. The device doesn't know that you're about to walk up some stairs. It doesn't know that you're halfway up some stairs. It has to wait until you've reached the top in order to detect that an altitude change has occurred. So that change only gets written to the database once the flight climb has ended. I tested approximately 8 different phones, different models, different versions of iOS, and found that on average, there was a time difference between 15 and 50 seconds between when I physically stopped walking up a flight of stairs and when the record was made. So it's just based on the time that the device takes to pull the altitude, detect that an altitude difference has occurred, and then write the data to the database. So then I took that average data between 15 and 50 seconds and plotted it onto this graph, which also plots the altitude of the device over time. So the red line here shows the time according to the cache encrypted C database where the first flight climb event was recorded at 22 minutes and 17 seconds. Working back 15 seconds from that to say that with the gap that I know exists between the flight climb ending and when the record's recorded, the flight climb event is presumed to have occurred within this red gradient area. The altitude information on the device shows that between those times, the altitude increased from around 41 meters to around 45 meters. You may recall earlier I said that it's a 3-meter incline that Apple considers a flight climb event. Therefore, the incline that occurred within this red gradient is sufficient to trip a flight climb event. When we look at the second record at 22 minutes and 32 seconds, this is shown on this chart as a green line. And again, working back 15 seconds and beyond to allow for the tolerance, we see the green gradient area. This shows an altitude change of around 45 meters to 48 meters. Again, that would be sufficient for a flight climb event to be recorded because we have 3-meter incline change. We then don't see an incline change for a while. All we see is the device going downhill until we get the record right at the end there at 24 minutes and 37 seconds. And again, working back around 15 seconds to the orange gradient, we see an increase from around 25 to 28, 29 meters. Again, that would be sufficient to cause a flight climb event to be recorded.
I'd like to ask you.
Sorry, I'll go back.
Continue, and then I'll ask you, please.
Okay. I then compared that information to a topology website from the area, according to a topology website data, and plotted that out here. We see the red circle now is related to the first flight climb, the green circle to the second flight climb, and the orange circle to the third flight climb. The gradients that we see here are the same gradients that were shown on the previous graph. So the presumption is that within this red gradient is where the flight climb event occurred. Within the green gradient here is where the second flight climb event occurred. And within the orange gradient here is where the third flight climb event occurred. The white circles show the altitude of that particular location according to the topology website. So again, we see that for the red gradient, there's an increase from 43 to 47 meters. Between the green gradient and the green number 2, again, we're going from around 47 to 50 meters.
Watch the Karen cam, everyone.
The orange gradient at the bottom, we've gone from around 26 to 28 meters. So fairly consistent with the data that was recorded on the device in terms of altitude information. And I would suggest is the reason that these flight climb events occurred.
Mr. Whiffen, there's 3 different times. The first is 12/22/17. At that time, was the Waze data app initiated?
It was.
And did that indicate whether or not Mr. O'Keefe or his phone were traveling in a car at that time?
Appeared to still be traveling in a car.
At 12/22/32, was the Waze data initiated and active?
It was, yes.
And at that time, does the data indicate that Mr. O'Keefe's phone was in a vehicle and moving?
It does.
And you showed us a slide finally from 12/24/37 that the vehicle was still moving 1.4 miles per hour.
Correct.
And was the Waze data initiated and active at that time, 12/24/37?
If I remember correctly, Waze had closed about 5 or 10 seconds earlier.
Now, based on your study of the Waze information, the location information, the topography, and the healthcare data, do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone, walking upstairs, or for some other reason?
Based on the location data, the health data, and the research that I did and the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
Thank you. You can continue, please.
Okay. So I'll address the idea of 3 clocks, which I believe was brought up previously.
Let me interrupt.
Sorry.
Why don't we just explain to the jury how clocks work in an iPhone?
That is kind of covered in the next slide anyway.
Okay.
Maybe worth just jumping ahead to that slide.
Explain the idea of 3 clocks.
Yes. Essentially, there is one clock on an iPhone. It's the clock that you see. It's shown in the top corner, and all activity is related to that particular time. So when you receive a text message, the time that's shown in the database is related to the time that you can see on the phone. When you do health activity, it's related to the time that you see in the top corner of the phone. Everything is related to that time. The difference is within the current PowerLog databases. It's a subset of files stored on iOS devices. They use what's called a monotonic clock, but it's not a clock that can actually be trusted to see when events occurred. It's the way that the device records time. It's essentially a counter that's just counting seconds since the device was reset, basically. And I'm sure most people can recall a time where you would set a clock on a digital device, come back to it 3 or 4 months later, and the clock's now not quite as accurate as it was when you left it. Time starts to drift. It might drift forward and be faster. It might drift slower and be further behind. That essentially happens with the monotonic clock as well. So you have to take the values that the monotonic clock provides and add or subtract different values, which are essentially offsets, in order to get the accurate time. And that's what I'll be displaying in this slide here. The confusion with the idea of 3 clocks, I believe, comes from the way that Magnet Axiom product displays power log data. They show a monotonic date and time, a baseband date and time, and a display date and time within the power log records. As an examiner, it's really good to see this data and understand how the tool is determining these values. As an examiner, it would be really bad to look at these values and think that they are accurate timestamps at face value, because they aren't. And I'll start to talk through how this information works. So the other thing that Axiom shows, as well as the monotonic baseband and display times, is they show the location where this information came from. In this case, we have 2 tables. One is called PL Springboard Agent Event Forward S Block. And that is what this table is here. And you can see we've got an ID number, a timestamp, and a value of locked. But we also show a second table that's involved called PL Storage Operator Event Forward Time Offset. And that's this table at the bottom here. So again, we see there's an ID, a timestamp, baseband, kernel, and system values. These values all need to be read together in order to make sense of the data. So for example, if I take the timestamp that's shown here, the 1643 33687 number, if you treat that as number of seconds since the 1st of January 1970, it's what we call a Unix epoch. That will get you the timestamp of 29th of January 2022 at midnight, 21 minutes and 27 seconds, once you account for the UTC -5 offset. And you'll see that that is the same timestamp that Axiom shows here as the monotonic time, 12/21/27. What we need to then do is take that monotonic time and add it to the baseband value that we see in the time offset table. So now we have a value of 1643 3687.14954, and we add -183 point whatever this number is here to get this value. If we treat this value as number of seconds since the 1st of January 1970, then we get a time of 18 minutes and 23 seconds past midnight on January 29th, which is also the time that we show here as the baseband time. Finally, we can take the monotonic time and add the -181 seconds shown in the system to get this value, which equates to 18 minutes and 25 seconds past midnight on the 29th of January, which is the same as the display time up here. So all this is essentially doing is saying that the counter that is built into the iPhone is registered the time of that we see in the top, the monotonic time. This is not necessarily the time that the event happened. You have to offset it with this value here in order to get the actual time that this happened. My own personal phone, when I was doing this testing, the time difference between the monotonic time and when something actually happened was over 2 weeks. There was a massive difference because my phone has been drifting so far since I originally bought and set up that phone. And again, when I was testing this, I can turn the flashlight on, turn the flashlight off. Both of those activities are recorded in the power log database. If I just look at the monotonic time, it's off by over 2 weeks. if I do this process to calculate the correct offset, it shows exactly when I turned that flashlight on and when I turned that flashlight off. The calculation is imperative. Without the calculation, these timestamps are irrelevant. And all Axiom is doing here is they're showing you the values that they use in order to calculate the final value. It doesn't mean that you can take the monotonic timestamp and read anything into it. It's completely irrelevant on its own.
Is it necessary to understand this process in order to ensure the integrity of the time that you're offering to the jury, so you understand whether it's accurate or not?
It would be if we were discussing power log data. Power log data only really encompasses things like battery level, the time and date that it's plugged in, button presses, camera usage, things like that. It doesn't count for location data. It doesn't count for Apple Health data. They both work on the system time. They both work on the same system time. So they're always going to be aligned.
Do you have an opinion to a reasonable degree of scientific certainty as to the accuracy of the location data times and the accuracy of the health data times that you shared with us?
They'd be consistent with each other. So to summarize that, there's only really one clock that's in use on an iPhone for recording. The only difference is the monotonic time, which is how power logs record information, but you need to offset the times to figure out when that activity actually happened. And that you only have to offset those times for power log data, not for health, not for location, not for messages or photographs or any other activity like that, purely power log data.
Okay. Is there another subject that you looked at, that you analyzed in order to reach a conclusion about the time and location of John O'Keefe's cell phone over the night of January 29, 2022?
Yes, the next one is battery temperature.
Can you explain a little bit of background on this before you start the slides?
So again, we have a temperature sensor built in within the phone, monitoring for if the battery temperature increases too high and becomes a danger, or if the temperature gets too low and becomes an issue. So it constantly monitors the temperature and records that information in the node seed space.
Do you look into the battery temperatures from before midnight and after midnight and do an analysis regarding the temperatures of that cell phone battery?
I did, yes. Throughout the evening of the 28th of January and then the morning of the 29th.
Mr. Whiffen, that's going to be hard to read. Is there any way you can enlarge it?
But apparently not like that. There we go.
Thank you.
So on the evening of the 28th, see an average temperature of around mid-80 degree Fahrenheit. I've got no understanding of where the device was at this time, whether it was in a pocket on a surface, whether it was in use or not. But I just wanted to get an average idea of temperatures of the device. By 13 minutes after midnight, we're still at 82 Fahrenheit. At 22 minutes after midnight, we know from the location data that the device was currently in a car, and we see the temperature has dropped to 77 Fahrenheit. By 37 minutes after, we now know the device is for approximately 12 minutes, and the temperature has continued to drop. It's now 72 Fahrenheit.
Mr. Whiffen, if I can interrupt you. At 12:37, when the temperature drops to 72 degrees, is that before or after the healthcare data stops for that evening?
That's after.
Thank you.
45 minutes past, the temperature's dropped to 66 Fahrenheit. 53 minutes past, it's dropped to 61 Fahrenheit. 7 minutes after 1, it's dropped to 55 Fahrenheit. At 1:36, it's dropped to 50. And then we have a large gap in the data, with the next record being made at 6 minutes after 6 a.m., when the temperature is 43 Fahrenheit.
Mr. Whiffen, if a phone has any protection or coverage, well, let me ask it this way. Do you know what, if anything, happened around 6:02, 6:03 to trigger that 6-degree drop in temperature?
I don't know accurately, no.
Okay. And then you're now at 6:14 and it's 37 degrees?
Yeah, you're correct. This is
the
coldest temperature recorded.
Do you know what, if anything, happened?
And then as of that point in time, from 6:35, we start to see an increase in temperature to 43 Fahrenheit. At 6:40, it's up to 50 Fahrenheit. At 6:48, up to 55 Fahrenheit. And at 6:56, up to 61 Fahrenheit. And then also plotted this out onto a graph just for visualization. Again, we can see on the evening of the 28th, the temperature is relatively consistent. It starts to drop as we know the phone is traveling in a car. And by the time it arrives at Fairview, we only see it drop until 1:36 a.m. We see a relatively modest drop over the next few hours, but no records recorded. We see the final drop at 6:14, and then we see an increase. But there are no increases occur prior to 6:14 that would suggest that the phone went from a cold environment to a warm environment or had extensive usage.
Between 1:36 a.m. and 6:06 a.m., is there any indication at any time that that battery temperature went up?
No, there's no records related to battery temperature at all for that time.
Thank you. Is there another area that you looked at for your conclusions in this case?
Yes, I was looking at device usage.
What is device usage?
Information about when the user unlocks the phone, what applications they're using, what they're using the device for, and when they lock the phone again.
Would device usage require an actual person to interact with the phone, or can it happen without user interaction?
Everything that I was looking at was related to physical interaction and manipulation of the device by a user.
Please continue.
So the three sources of data that I used for this were Knowledge C, a database I mentioned earlier that logs lots of different activity, including device unlocks, device locks, applications that are on screen. The current power log, which I mentioned, which can track button presses. So specifically when the lock button is pressed and the times that I display have been offset appropriately. And unified logs, which is essentially a list of almost everything that's happening on that phone for a short amount of time. But it would be used, for example, if you had a problem with your device, took it back to Apple because it was crashing all the time, let's say, they could look at the unified logs and figure out, well, what's causing these crashes to occur. So really granular. We see that at 12 minutes and 52 seconds after midnight, the device is unlocked using biometric Face ID. The SMS application is on screen for about 5 seconds before it's closed. And then the user presses the lock button at the side of the device to lock the phone. At 13 minutes and 54 seconds, biometric Face ID is used again, and the SMS application is opened. And at 14 minutes and 29 seconds, the lock button is pressed again, causing the device to lock. 15 minutes and 46 seconds, the device is unlocked using Face ID. The SMS application is already on screen because that's the application that was on screen when the device was locked. And the device is locked again at 16:03. At 17 minutes and 59 seconds, the device is unlocked again using Face ID. The SMS application is still on screen from before. And at 18 minutes and 12 seconds, the lock button is pressed, causing the device to lock. At 18 minutes and 25 seconds, the device is unlocked using Face ID. The SMS application is already on screen from the previous usage. And at 18:31, the SMS application is closed. At 18:34, the phone application is opened by the user actively pressing on the phone icon on the home screen. At 18:36, they're now in a call, and this causes a different screen on the phone. And at 19:23, that phone call ends. At 19:29, the Waze application is opened by the user pressing on the icon on the home screen. And that's open for approximately 5 minutes, closing at 24 minutes and 26 seconds. 2 seconds later, at 24 minutes and 28 seconds, the device is locked by the user pressing the lock button on the side of the phone. At 24 minutes and 59 seconds, the device is unlocked using Face ID. The SMS application is opened using the icon on the home screen. And at 25 minutes and 9 seconds, the lock button is pressed by the user to lock the device. At 27 minutes and 45 seconds, the device is unlocked using Face ID. The SMS application is already on screen. And at 27 minutes and 50 seconds, the device is locked using the lock button. 29 minutes and 52 seconds, device is unlocked using Face ID. SMS application is already on screen from the previous usage. And at 29 minutes and 53 seconds, the lock button is pressed to lock the device. 32 minutes and 4 seconds, the device is unlocked using Face ID. SMS application is already on screen from the previous use. And at 32 minutes and 9 seconds, the lock button is pressed by the user. And that is the final interaction with the device. It's the final unlock of the device using Face ID, and it's the final logged button press on the device as well to lock the device.
So the final interaction with John O'Keefe's cell phone that night?
Correct, up until 6:15 a.m.
In 12:32:09 was the last time before the phone moved again the next morning?
Correct.
Is there one more area that you engaged in analyzing to help reach your conclusions in this case?
There is. During my time looking at the unified logs that were mentioned, I found a record that appeared like it could be interesting that was called Doppler. This was the pocket state that I think I mentioned earlier, and it detects when the user takes the phone out of the pocket, or at least removes the item that's blocking the camera. There were hundreds of thousands of records within the unified logs that I was able to filter down to just the Doppler records and to filter and aggregate down into a more digestible number, which is what's shown here. So again, whenever the device receives a phone call, or whenever the device is picked up in a particular way, the camera activates and it actively looks for a face. If it finds that the camera's blocked, it records the fact that it's in a pocket state. And it will continue to record pocket state until either the obstruction's removed, so the device has been removed from a pocket, or until whatever is calling for the Doppler check to be completed. So for example, if I make a phone call, it will continue to check and look for a face up until the phone call ends, or the ringing ends. So in this case, at 12 minutes and 37 seconds, see a small amount of time where 4 Doppler checks were conducted. And that ended at 12 minutes 37 seconds with a pocket state cleared event. At 12 minutes and 39 seconds, there was a 7.5 second period where 108 Doppler checks were conducted. Again, that ended with a pocket state cleared event at 12 minutes and 46 seconds. At 25 minutes and 8 seconds, there was a single Doppler check that resulted in a pocket state. And at 29 minutes and 37 seconds, for 5.5 seconds roughly, there were 97 Doppler checks. The 97th check resulted in a pocket state cleared event at 29 minutes and 42 seconds. At 31 minutes and 52 seconds past midnight, there was an 11-second period where 155 Doppler checks were made. The 155th Doppler check resulted in a pocket cleared event at 32 minutes and 3 seconds. At 33 minutes and 14 seconds was the start of a 5-hour and 20-minute period where 26,500 Doppler checks were conducted. Every one of those checks came back to say that it was in a pocket state. There was never a pocket state cleared event during that time. At 2 minutes after 6 a.m. And 41 seconds, there was a 12-minute period and 20 seconds where 417 Doppler checks were conducted. The 417th Doppler check showed a pocket state cleared event at 6:15:01.
Mr. Whiffen, as a result of your analysis of John O'Keefe's cell phone, considering the location data, including Waze data, and considering the healthcare data, the pocket state information, the battery temperature, did you have an opportunity to create a timeline putting all of these different important pieces of data together so you could show them to the jury in chronological order?
I did, yes.
Would you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view. So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use. For around 11 seconds, a phone call is made from John to Jennifer McCabe. A phone call lasts 36 seconds, starting at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the Waze application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?" At 22 minutes and 14 seconds, this is the start of the 3 flight climb events as the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the Waze application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the "Here" message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the pocket state cleared event is written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device to lock again. 31 minutes and 47 seconds after midnight, a message is received again from Jennifer McCabe saying, "Pull behind me." And at 31 minutes and 52 seconds, the Doppler check records a pocket state. At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. And at 32 minutes and 3 seconds, there's a pocket state cleared event. At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears, because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message pull behind me is red. 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler pocket state being detected by Doppler. And I've also showed some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying hello. This is the first iMessage or SMS message received by the device, which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?" And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere kind of around the flagpole area. 55 minutes and 31 seconds, a message received from Karen stating, "I'm going home." 55 minutes and 50 seconds, a follow-up message saying, "See you later." Another location data, this is the location that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, "Your kids are cooking alone."
Mr. Whiffen, based on your analysis of John O'Keefe's cell phone, keeping in mind some of the data points you shared with us, that Waze was initiated around 12:19, that the car reached the flagpole around 12:24:37, that the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16, that the last interaction was at 12:32:09, followed by an overnight pocket state and an increased reduction.
Objection, Your Honor.
So I need to hear the question first.
Including a increased reduction in the battery temperature. Do you have an opinion, to a reasonable degree of scientific certainty, that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning.
Objection, Your Honor.
I'm going to allow it.
The location data that shows accurate tends to show around the flagpole area. There's no further health data other than 36 steps that were taken that suggest that it moved after 32 minutes and 16 seconds after midnight. The battery temperature data never indicates that the device went from a cold environment to a warm environment, which I would expect to see if the device went inside a building. And the Doppler state information suggests that the camera was blocked for at least the majority of the 5-hour period, with no records showing that the camera was unblocked during that time, which would typically happen if you were to pick a camera up and move it around.
Does that lead you to a conclusion to a reasonable degree of scientific certainty?
Yes.
Whether that phone remained in the flagpole area from around 12,
Objection, Your Honor.
24, 33,
So
until the next morning at 6 a.m. or after?
That's
the
my opinion.
objection's sustained. Ask the question in a different form.
Do you have an opinion where John O'Keefe's cell phone was from around 12:24:33 on the evening of January 29, 2022, through at least 6 a.m. and after that morning?
Yes, based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
I have no further questions. Thank you.
All right. Mr. Leslie?
May we approach, Your Honor, please?
Okay. Jurors, feel free to stand up.
What's happened? Why'd they cut the audio? Oh yeah, it's gonna keep evolving, Brittany, and that's how they know they're in a goddamn sidebar. That's how they know they're in a goddamn conspiracy. Is everything keeps changing. They keep changing the story when one thing is debunked to something else. That's the problem that I have with this whole thing. And the fact that some of these FKR people can't figure it out, it's amazing to me. Like, now Alessi's going to go on a 17-hour rant, and we get to listen to B. Tim. Go.
Let's go. No, I'm joking. Pretty disastrous. I mean, basically, he drew a map that phone never went into that house, never warmed up, never moved from that position.
Yep.
The timeline of events. I mean, I don't see how you can refute this, honestly. Like, this is the most detailed phone data I have ever seen. I mean, the reason why it was in pocket state was because of the fact that he had his it was in the back of him, like he was, lying on it, so for that entire time.
Your Honor, if I may have a moment, please, to set up at the podium.
Okay.
Oh, for fuck's sake. We need a moment. Or several moments.
Prepare for a 5-hour cross.
Mr. Wiffen, I should have told you, you can feel free to stand up and stretch if you want to as well.
Legit.
He's got a big binder. He's got a very big binder.
He always does. I'll get to it, he says.
God, can we have time limits on this guy?
Oh my God, please put time limits on this guy. That would be fucking amazing.
He got 3 hours. Let's go. Oh my God.
For real. We want to hear the ARCCA shit at some point. Being long-winded before he even starts being long-winded.
Yeah. No, don't eat gum. What are you doing?
I just checked it. Oh yeah, gum right before you talk. That's great. Amazing. I just checked there's no donations to read on this break, but Ashley makes a good point about 3 ways to do so. If you want to support the channel, you can also hit the like button, subscribe button. It's all helpful.
Thank you, Your Honor.
There he
May I
goes.
proceed with the
Yes.
administrative matters? May I approach?
Yes.
Thank you.
What?
The administrative
Your Honor,
matters.
pursuant
okay.
to a stipulation with the prosecution, I would like to mark and enter into evidence 3 documents. These are each portions of a March 2025 report prepared by
Portions.
Mr. Whiffen.
Portions.
The first one,
So, yes, they can come into evidence. They can come into evidence. There's a stipulation. So
and
we
so
can mark it as the next
Speed it up.
exhibit.
See her do this?
if we could, that's page 29 for the next exhibit. Separately, please.
Speed it up, bub.
Okay, so he's gonna
Jurors
cherry
aren't going to
pick this
follow a word
report.
this guy says because he's just so long-winded.
Yeah, and he's gonna
Yeah,
cherry.
that's what portions cherry pick a report he doesn't understand, by the way. So Ian Whiffen is about to just lay the smackdown on him, and it's going to be
The
hilarious.
next exhibit will be pages 77
Wait.
and 78 of the same report.
Okay.
Exhibit 41.
Speed it up, Alessi. This fucking guy.
The third and last is page 43 and page 44.
Exhibit 42.
Okay, all set.
Thank you, Your Honor.
Come on, bub.
May I, Your Honor?
Yes, please.
Good afternoon, Mr. Whiffen. I don't believe we've had the pleasure of meeting.
Good afternoon.
Cell phone data, when correct and when correctly analyzed, can help tell a story of what may have happened under various circumstances, correct?
Correct.
And in cases like this, literally seconds on cell phone data can be significant, correct?
Correct.
What I'd like to do is to go back to your PowerPoint presentation and specifically go to the timeline that you had gone through with Mr. Brennan. And rather than repeating everything, there'll be select aspects of the timeline I'm going to reference. And with the court's permission, we will put the timeline back on that's already in evidence.
Okay.
Thank you.
Tell us everything you're going to do before you do it, guys.
So what I'd like to do is to start with page 70, which we have as 78 of the deck. If you could, Mr. Wolf, go to that. And what I'd like to do, if I could please, Mr. Whiffen, is draw your attention to the very last entry, which says at the bottom, location 122438. And it indicates description, first location record showing speed of 0. Do you see that, sir?
I do.
And this is the arrival of John O'Keefe's phone at 34 Fairview, correct?
Correct.
If we could go to the next page, please. We have up at the top 12:24:59, about 21 seconds later after arrival, we have device unlock with Face ID, correct?
Correct.
Is it possible for anyone other than John to unlock that
Seriously?
device with Face ID?
If a secondary user was set up.
Do you have any indication that a second user was set up on John's mobile phone?
I never looked at that.
I'm sorry.
I never looked to see if a secondary user was set up.
In terms of the next entry, 12:25:08, it says, read message, you coming here? With 3 question marks. What I'd like to do, because You did not note who that was from, but I want to go back a few slides so we can identify who that message was from. We could go back to 76, please, Mr. Wolf.
Yes.
What? Oh God!
So in the
Alexis,
last
hungry.
line there, message reading left to right 12/20/49, it says message received from someone listed in context as Brian Higgins. Do you see that?
Correct.
So if we could go back to slide 80, excuse me, if we could go back to slide 79, that phone reading the message, you coming here is reading the message from Brian Higgins, correct?
Correct.
But you didn't note that in the timeline that was from Brian Higgins, correct?
No, I was just highlighting the fact that a message was read and that the contents of the message were you coming here.
But you didn't note in this entry when it was read by John that message was from Brian Higgins, correct?
Correct.
Now, the next entry, lock, again, I'm always going to be reading left to right unless otherwise indicated, sir, is a time of 12/25/09. And it says, device locked with lock button.
Yes.
You see that, sir?
I do.
That requires human volitional conduct. In other words, someone has to actually manipulate their phone and hit it, right?
Correct.
Now, at this particular point, isn't it correct that in your report that you mentioned in your March 2025 report, that you had more of a description of what was happening at this time with the phone, namely device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Isn't that what you had in your report?
Yes, and that's covered in the location section of this report, the PowerPoint.
So there is no statement in this timeline under any type where you had concluded that at this time the record showed that the device was moving west from the roadside towards the house, correct?
The location latitude, longitude was moving westerly, but at the same time, the accuracy was increasing. So it didn't intrinsically prove that the device was moving.
My question, Mr. Whiffen, is straightforward in this sense, that I'm just looking for an answer of whether on this timeline you included the analysis that you had in your report that the device at this time was moving west from the roadside towards the house. Did you include it in that timeline?
No, I left that out of the timeline.
Next entry, 2733. That's 12/27/33. You note that there's a message received from Jen McCabe. Here, exclamation point, question mark. You see that, sir?
Correct.
Now, at this point, you have two people in just 2.5 minutes, Brian Higgins and Jen McCabe, trying to find out if the John is coming to 34 Fairview. Is that a fair conclusion?
It appears so.
I'll allow it.
Is that a fair conclusion?
It would appear so, yes.
So just because of the colloquy that occurred, I want to repeat the question. Now you have, at this point, at 12/27/33, you have two people, Brian Higgins and Jennifer McCabe, in just 2.5 minutes, trying to find out if John or the phone is coming to, or if John is coming to 34 Fairview.
Sustained. Ask it differently, Mr.
Thank you, Your Honor. Now, At this point, you have two people trying to find out if John is coming to 34 Fairview, correct?
Objection.
Sustained.
Mr. Whiffen, in terms of the information at this stage, there are two communications with Mr. O'Keefe on this phone, and that is they're trying to find out, excuse me, I'll rephrase it. There are two communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolf. This is 122745, device unlock with Face ID, correct?
Correct.
And then right under that is 122748. It says read message, which it says here. And is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And that, the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
Sorry, repeat that question.
Yes, you did not, it does not appear in that timeline that you've drafted that that message that was read was from Jennifer McCabe, is
Correct.
it?
Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone? Because up above, there's read messages we went through on 2748. So if somebody reads the message and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular way so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state cleared.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942, when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44. And that, you state, is an incoming call from Jen McCabe. So there you do indicate the name. And you say answered 7 seconds, correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Right. So now we have at 12:29:44, the phone's out in front of 34 Fairview. There's an incoming call from Jen McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12:29:51, incoming call ends, and that's end of that 7-second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
Now let's go to 12, Mr. Wolk 81, which is starting up at the top of 12/31/47. There is, as you indicate, an iMessage received from someone with a contact named Jen McCabe. You see that, sir?
I do.
Can you just state for the jury what an iMessage is?
An iMessage is essentially a text message sent primarily from iPhone to iPhone via the Apple servers, not like an SMS message which goes through carriers.
And is it correct that the message that was received from Jen McCabe said, from a contact, Jen McCabe says, "Pull behind me"?
Correct.
And then at 12/31/52, we're back to Doppler pocket state, correct?
Correct.
Now let's go to the next entry, which is Deck 82. It's under health type. And what I want to do is see if we can clarify. The Commonwealth on direct examination, and multiple times referred to this as healthcare data. Do you remember hearing that healthcare data term?
I do.
Is that a correct term? Is it healthcare data or is it health data?
It's health data.
So it's incorrect to refer to this as healthcare data, correct?
Healthcare data is encompassed within Apple Health, but primarily if we're talking about steps being taken, it would just be health data.
Right. So the correct parlance is health data, correct? Particularly when we're getting to steps. Is that correct?
Correct.
It's important to be precise about the parlance.
Yes.
So in this entry, 12/31/56, you state that there's the start of health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about 84 feet? Are you able to make that calculation?
It's approximately that, yeah.
Right. Would you accept approximately 84 feet? So as we discussed meters, we can go to feet and
Yes.
about.
I would accept approximately 3 times 25.
Right. So, in your report of March 2025, isn't it correct that for this time, you stated that the device began moving for a period of 20 seconds, correct?
Yes.
So, again, your conclusion from your analysis is with these 36 steps, the device at this point began moving. Correct?
Correct.
Yeah.
Next entry. 12/32/03. Pocket state cleared. Correct?
Correct.
So does that mean that there's some human activity going on, interaction with the phone, or not?
It could have been a received phone call. It could have been movement of the phone to be lifted.
But something has happened.
But something's happened, yeah.
Next, 12/32/04, device unlocked with Face ID, correct?
Correct.
And then at 12/32/05, it states application focused messages.
Yes.
Can you clarify what that means in terms of what is happening with the phone for the jury?
Yep. So at 32 minutes and 5 seconds, the messages application was in focus on screen. So it was the application that was being used by the user at that time.
Now, the next entry is message 12/32/06, and it states red message, quote, pull behind me, close quote, correct?
Correct.
Now, you don't indicate who that message is from in your timeline, but that's the message that was sent by Jennifer McCabe at 12/31/47, correct?
Correct.
Next entry is application lock at 32/0 123209, and you've got here end application focus, and then you state device lock with lock button for the last time, correct?
Correct.
So that's again pressing the side button on the iPhone that locks it.
Correct.
And that requires human conduct, human interaction with the phone, correct?
Correct.
And then the next entry under health data at 123216, that is 7 seconds after the lock. It's the end of the health event of 36 steps, 25 meters, and as we agreed, approximately 84 feet, correct?
Correct.
So in terms of the steps, I want to turn to some further information with regard to your previous, the report that you mentioned on direct, which is the March 2025 report. Your Honor indicated a time for the break, and I'm going to go into a little bit of different area. Would you like me to keep
All
continuing?
right, Mr. Leslie. Folks, we'll stop. Turn lights, please. Thank you. Mr. Whitman, we need you back here. Jurors, we're going to recess for the day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And please be very careful with your social media use. All right? We'll see you tomorrow morning.
Right, right this way. You know,
I'll see counsel at sidebar.
She just said the day. Oh, you want to know why? You want to know why? Because the jury is dismissed. For the jury. The jury does not get to see the voir dire. That's why. So it's not over for the day for us. It's over for the day for them. ARCCA is a voir dire that juries don't get to see. So it must be, yeah, we must be doing ARCCA after lunch. They must be giving all rise again. Oh, he's telling him to put the camera up. Like, why? Why does he need to put the camera up? He's allowed to do the courtroom. Like, what's the problem? I don't know why the court officer was being kind of a dick there. Like, he's not showing the jury. The jury's out of the room. Like, what's the problem? Like, we have a right to hear any public things that are going on unless they're going to let us all into the courtroom. We have the right to hear it all. Like, the one thing about not allowing cameras is the thing that pisses me off. Public trials have the right to have the public see them. And clearly they would not be able to accommodate all of the public that wants to see this trial in person. So therefore, that is why they allow the cameras. But by allowing the cameras, but then also not allowing us to see things like the jury and their expressions, it's never been challenged, as far as I know, at least in this state, about not showing the jury. Because in my opinion, unless you are going to let us all in person to see this, then we have a serious problem, because I should be allowed to see the jury. I get it. It's dangerous in this scenario because of these people, and I would agree to not see the jury because of like this whole case, but I'm just talking about cases in general. Like, it's so they don't ever catch the jury on camera. But if we went there in person and there were spaces left sitting there, they would have to allow us in until all the spaces are filled up. And even then, if more people want to come in and see it, we as the public have the right to sit there and watch the trial in its entirety, including looking at the jurors. So I never understood why in every case they keep the jurors down. Like, yeah, we did, because they showed, I don't know if it's because they showed one or because of something else. I think it was because of something else. And then she was also shown. But that's the thing. If I go down to the courthouse right now in person and there's an open space, they have to let me sit there. They have to let me look at the jury. So what would be the difference? You know what I mean? Like, no, but it's not just this case. If it was just this case, I would say, yeah, sure, I get it. Like in this case, I agree. We should not be able to see the jury because they get harassed into oblivion. Sorry, I got to pull this down because it's messing with the, I pulled the thing up just because like I wanted more light, but it's messing with the lights I already have on. So I can't. But it's never been challenged in that way. And in my opinion, it should be challenged because we, as the public, have the right. That's why we have public trials to watch these things in public. And that includes everything that's happening, like with the jury. Like, so for me, it's a little frustrating because if I went there in person and sat there, I'd be able to look at the jury. But that's only, you know, say there's 10 seats left in the courtroom. We're allowed the first 10 people, first come, first serve, is allowed in there. But what if there's 40 people waiting to watch this trial? All 40 people have the right to the trial to watch it. Let's see what they say real quick, and then I'll mute it. Let's see what they say real quick, and then I'll mute it because we're not going to watch the whole thing.
Good afternoon. It's just about 1 o'clock Eastern time. I'm Annette Levy, and you are joining us for our lunch show Q&A.
I'm not a fan of
this
her.
is the Karen Reed
at all
retrial. And this morning, the jury heard from Ian Whiffen. He is an expert, a Celebrate expert, and he really talks all about John O'Keefe's cell phone and the activity on John O'Keefe's cell phone on the last day that he was alive, in that early morning hours that he was alive before he passed away. So we have a guest with us today to take all of your questions. Submit those questions to us in our live chat, and we will get to as many of them as we can during this lunch hour. Safa Robinson Ferrer is here with me. Safa, I'm wondering, what did you think of Ian Whiffen's testimony this morning? You know, it was very, very detailed. We heard a lot about John O'Keefe's cell phone, the temperature of the cell phone, where Ian Whiffen believed it was located during those early morning hours, and also his health data, his Apple Health data and his Waze map data. So there was a lot going on here. Some of it was very dry, but it's very important information.
Absolutely. And so what Mr. Whiffen is doing is establishing a timeline of events with respect to the decedent's cell phone, what time the phone was active, and you heard testimony about what the temperature of the battery was at a certain amount of time, when he was unlocking that phone via the face unlocking button. You heard testimony with respect to when he was sending text messages, when they were read by other individuals. And so all of those things essentially go to show that the decedent was alive at that time, what the activity was and what he was doing, so that it establishes in a chronological order, essentially a timeline of what he was doing at a particular time, and then when that time stops, and ultimately would likely be around the time of his death.
Safa, what I really thought was interesting was the discussion about the temperature of the cell phone battery. I think that's really key in this case, because essentially the Commonwealth is saying that phone battery, the temperature went down gradually over the hours, but then there was a sudden drop in temperature when the EMTs arrived and they picked up John O'Keefe's body. And so the Commonwealth is basically saying, well, the phone was underneath John O'Keefe's body the entire evening. And then the phone, that battery temperature dropped after the EMTs came, lift up John O'Keefe's body. And then, you know what happens if you're out in the cold. You're out in the cold and your cell phone battery just zaps. It goes from, maybe 100% to 80% in no time at all. So I think that's going to be really key this time around, is looking at how slowly and then how quickly that cell phone battery charge dropped with the temperature.
Yes, and what's going to be interesting is when we hear the testimony of the EMTs, what position was his body when he was ultimately recovered by them? Was he face down, and where specifically was the phone located at that time?
Okay,
and you heard
clearly
testimony from
Mr.
Whiffen about the pocket setting of the phone. Now, I would think and I would imagine. And of course, you know, if a phone or a battery is close to somebody's body, a body temperature would essentially make it a little bit warmer. But if he's face down, if he's in the snow and the phone is wedged between his body and the ice cold snow, you know, I would tend to think that once the EMT pick him up, then it could actually warm up instead of drop. So it's going to be interesting to see what the jury is going to believe when it comes to that and what opinion they're going to have.
Yeah, most definitely. And I want to get to some of our questions, Safa, because we always have really great questions that come in. Everybody keep those questions coming into the YouTube chat, and we'll get to as many of them as we can during this lunch hour. But this first one is very important, Safa, because it has to do with
stupid, I'm getting
what is
off
going
of
to
this.
happen after lunch. And this question comes from Hubgrass. And Jeanette, my question is, why are they taking so many half days? Do they want to drag this out as long as possible?
We know why.
The answer to that, Safa, is no. The reason they're doing the half day today for the jury is because there's going to be a voir dire.
Okay, we know what's happening. I want to pop on to John DePetro. He's live on X, and I want to see what he has to say right now about the jury. So hold on. We're going to switch to him real quick. She clearly wasn't watching. The EMTs have already testified. So clearly this lady has no idea what the hell she's talking about. That just pisses me off. Like, why have someone on that clearly isn't watching? All right, this is John.
Double check with Roger.
Also, if you guys could do me a favor, hit the like button, the share button. We're on lunch right now. Before we hear the ARCCA voir dire. Please donate to the channel if you can. It's the only way we survive over here is donations from our amazing viewers. We don't have monetization. We're still waiting on YouTube for that. I do want to read a $10 donation from Arlene. Thank you so much, Arlene.
Then we're going to go to this.
And then
where am I? There I am.
Other than B. Tim sent $50. Thank you so much, B. Tim. We appreciate you, my friend.
All right.
And that's it. So if you want to donate to the channel, you can do it these three ways. And we have a link for Apple Pay that we can put in the chat for you guys. Because every little bit helps. Trial days are actually slower for my channel for any donations than a regular day would be. A regular 3 or 4 hour live.
And right now it's 1:04.
What is he reading?
Let me check all of our links. I think everything is flowing.
He knows he's live.
What a big day in court. Folks, it's been a very busy day already.
Tell us, John, tell us.
Do this. Okay. I think this sounds fine. I'm going to double check it.
Is he going to talk, or are we just, he's going to look at his phone? Like, what's happening here? I know he knows he's live. Come on, John. We want to hear stuff.
Okay.
Come on, John.
Double check this. But I think, share that you are watching, everybody. What a morning in court. What a day this has already been. Plus, we're going to do politics this week.
That is false. That is completely and utterly false.
Here I am.
If that's what you got out of that, then you were not paying attention.
I think it should be nice and clear. And it is. Yep, we're nice and clear. Okay.
John was not on his phone for 6 to 7 minutes. As a matter of fact, they literally just told us that he wasn't.
Okay.
He was hit around 12:32 in whatever seconds.
It is 1:05.
And it doesn't take 6 to 7 minutes with no traffic in the dead of night.
Beautiful day it is.
And also, everybody's like, oh, but it was snowing. It would take longer. No.
Standing by. What has been a big
Wasn't
day
snowing like
already.
that yet.
Yep.
I know, right? I bet they are. They just listen to reason and common sense and they wouldn't be so mad. They would just admit they were duped. Come on, John, we want some information, sir. You were in there. We want to hear about the jury. People are swatting him. Well, you know what? The Holden PD, shame on them, have helped him. Why?
They need to give me the go-ahead.
And they've helped him
Just need that text
victimize their own victims. His victims.
from Roger. 106.
What is he talking about? 106 what? Yeah, we have actual hard data. That's not true. John was not on his phone for 6 to 7 minutes. He wasn't on it after 12:32 and some seconds.
We are standing by.
Why? What are we waiting for?
Normally, I'm waiting for Roger to text me to say live.
But you are live. I'm confused.
I'm not sure why we're not getting that. Because we're going to start. We are in motion. Everything's rolling. Hello.
We are live. What do you mean?
Just text. We'll have to start in a minute. Where's my text?
Does he not
Sure
know that he's live? He's live.
Who's panicked?
You're live.
We are ready to roll. We just check.
Oh my God. I love John, but in a second, I'm going to click off of this because he's not.
Sure what's happening on that end. We're going to start.
I don't know what he's
just
doing.
a moment.
Well, yeah, but don't hit the live button until you're ready, you know? Like, come on, John. A cue for what? I don't know. Understand what he's saying. What is he waiting for a cue of? He's live.
I don't know why I'm not getting it.
What does he need a cue for?
All I need.
WCBB said juror was a man in his 50s. It appears David said the juror left the courtroom. Not sure if he meant to meet up with other jurors. I don't know. Good luck.
This is good. I'm waiting
Jezebel.
for Roger to text me live.
Why is he waiting for him to text him live? I'm confused right now. Like, you are live, sir.
Okay, there we go. All right.
You can go. What do you?
That's what we're waiting for, folks. Good
Why?
afternoon. We are on right now.
We've been on.
At 108 on this beautiful Monday, April 28th. We are outside of the Karen Reed retrial. I was inside the courtroom. I'm going to tell you about that. The next
weird.
also this hour.
It's really strange.
We're going to do politics this week with Justin Katz.
Let's not.
At ARCCA.com. But a very, very significant day.
Hey, Penny.
The Karen Reed retrial. I'm going to tell you why. But let's stay on schedule, folks. This portion of the program is brought to you by PR Landscape Materials and Garden Center, 3688 Quaker Lane in North Kingstown. Pansy flats, pansy bags, hangers and bowls. Today's a beautiful day. My goodness. Today is, I'd say, the night. See, this is the lunch break right now. Stop it and see them. Tulips,
what's happening?
White and pink. They carry everything you need to make your home property the best it can look. It's Rhode Island's #1 garden center, open for the season.
You know, if anybody wants to sponsor the channel, I'll throw an ad out there and give you some PR.
Let me just adjust this. And
You email
I also
me
want to remind you
for that.
Remember the Coeaston Inn, 226 Coeaston Avenue in West Warwick. As we like to say, lunch, dinner, much better. Drinks in
Commercials.
the lounge.
It's him.
We are waiting for you at the Coeaston Inn.
Talking about the people who sponsored this video,
Now,
like paid him
windy outside.
the video.
Weather is beautiful.
Lunch.
Don't forget, folks, the Coeaston Inn, whether it's lunch, dinner, or
We just want to hear what he says about the jury.
and they
That's
can also
it.
accommodate big groups. What I love about the Coeaston Inn is they're
He's still
always
talking about this inn.
improving the
Yeah,
menu.
his
They're
sponsors.
always upgrading the menu. There's always something different. And they can accommodate a large group. Not a lot of people can. Some
Oh, boy.
places cannot accommodate large groups.
John,
At the
I love
Coeaston
you,
Inn, they
but
can.
come on,
The
guy.
Coeaston Inn, 226 Coeaston Avenue, West Warwick. Proud sponsors of DePietro.com. We have a lot of video up. We have a lot of exclusive stories and information. It's
Anybody
all
wants
right
to
there.
sponsor the channel, you can send me an email at
Before we get to
twistedtragedies3.com.
Justin Katz
That'd
and
be a good idea.
politics this week.
That'd be a cool idea.
And before I'm going to tell you, this morning was a very significant morning in the Karen Reed retrial.
Tell us
That's
why.
where we are.
Okay.
We are right outside the courthouse. I was in court. I'm going to go back into court because there's a special hearing this afternoon with these experts from ARCCA. And these were the two. And they have a lot of questions to answer. And the whole thing is very suspicious. How they insisted in the first trial that when they did accident reconstruction, that the injuries to Officer John O'Keefe were not consistent with the car strike. Where this thing, and it never made sense. It never made sense. And then we've learned since then that they had an under the radar relationship with the Karen Reed defense, and that has put the defense's hot water. And now these two experts from ARCCA are going to come slinking in here. But I want to tell you what happened this morning in the Karen Reed retrial because it's very, very significant.
Right.
But this portion of the program is brought to you by Propane Plus. Call Propane Plus today, 401-885-4499
Oh my God.
in Rhode Island and Massachusetts, 508-252.
There's a way to work sponsors in without doing all of this right in the beginning
Very
when you're
user-friendly
talking.
website. It's propaneplus.com.
All right.
Now, what happened this morning? So this morning, there was a lot of speculation of who some of the witnesses are going to be. And there were people last week that were announcing that it was going to be one of the witnesses named Judy Nagel. But that's not who testified this morning.
Julie Nagel.
So as I was sitting in that courthouse this afternoon, this morning, in the Karen Reed retrial, who took to the stand but Ian Whiffen of Celebrate.
Mm-hmm.
And he told a story that Richard Green, who was this very suspicious defense expert who misinterpreted the data,
Works next
what
to
kind of
Matthews.
expert he testified. We learned Richard Green actually contacted Ian Whiffen to ask him to explain the Celebrate data. You
We
can
already
see,
knew
I
that.
could see the defense like gulping, like how embarrassing is this? And then he never called him back.
Trial.
But the biggest takeaway, and there were a lot, but this morning in the Karen Reed retrial, Ian Whiffen of Celebrate, they looked into the data and they looked into these questions about the timestamp. And what they did this morning,
I want to know about the jury.
they buried
That's it.
once and for all this myth that there was several things he did, but one is there was no 227 Google search. That was a cornerstone of the Karen Reed defense. In the docuseries Body in the Snow, Alan Jackson says at the end of episode one of his investigators called him and said, "You're never going to believe this." Jen McCabe Googled how slow to die in the cold at 227. Today, this morning, Ian Whiffen, and done brilliantly by Special Prosecutor Hank Brennan, brilliantly laid out that technologically it is impossible that happened.
Yes, impossible. Exactly.
The Google search happened at 6:23 that morning. Now, I can't overstate how important it was that they had Ian Whiffen up today to lay out when the Google search was, that there was no data deleted, how important that was. Last spring, Jen McCabe got up on the stand and Alan Jackson was saying, "You're a liar and you deleted things." And that's when you Google it. And
That's
it was
not
like
true.
a big joke. I believe they defanged Alan Jackson. How can he say that when you just had an expert explain very easily to the jury that the Google search did not happen? So here's what I want to say. At this point, on this Monday, anyone that says that going forward, you're not dealing in reality.
Yep.
It's just,
Where do you know that?
and it was easy to understand.
They don't deal in
And
reality.
Brennan did it in a very easy to follow manner. By the way, the jury, we have to be very cautious how we describe the jury. I would just say, and I was talking about another.
This is what I want to hear.
The jury, to me, seems somewhat tech savvy, where they could understand a lot of what they were talking about, even though it wasn't that complicated. So that was very significant. But here's the big bombshell of the morning with the Karen Reed retrial. And this is last Tuesday was opening argument. So 1, 2, 3, this is day 5. They were able to not only track his phone, John O'Keefe's phone. He never left the area of the flagpole.
Correct.
He never left the area of the flagpole. It stopped moving, and he stopped moving.
That's right.
On top of that, they even have the temperature of the phone from when he was in the car, got out of the car, started was taken off the phone, how the temperature of the phone dropped even more. You can't argue with the data. You can't argue with science. Here's what this morning showed. Now, it was last time around, last spring, was this the notion, the third-party culprit, that there was a conspiracy. And Alan Jackson even did it in an interview. Hey, John, come on in the house. We want to show you something. And boom, they beat him to death for no reason and no murder weapon, no motive in the basement. That's off the table. It was wild to watch as the phone with John O'Keefe traveled all the way to 34 Fairview. They even have when Karen took the wrong turn. What else was debunked was so many people have said his phone tracked he was going up and down stairs. False. It's because the car was rolling over hills.
Yep.
Very significant. Now, when I say this,
Say anything about the
I recognize that a lot of her supporters, a lot of the Karen Reed supporters, they have no interest in hearing it. They're never going to believe it.
Nope.
It doesn't matter to them.
Nope.
Everybody's a liar. Everything's a fraud. But what I'm telling you is it was crystal clear for the jury. It was crystal clear for the jury. They understood it. It made sense to them. It was thorough. There's no way to argue. Richard Green, who was the defense expert, called Ian Whiffen of Celebrite to ask him to interpret the data for him. Folks, that portion of the case, I am telling you, the jury was alert. The jury was interested. The jury was engaged. Where the defense also made a mistake this morning was Robert Alisi was cross-examining Ian Whiffen for the defense. They're using some slides. They're using the projector. But Alisi made the mistake that he kept the lights off. And he wasn't showing anything on the screen. He was just droning on. Folks, when you're starting to warm up outside, and now you're starting at the lunchtime hour, and the lights are out, I saw at least a couple jurors starting to doze off. That was a mistake by Alisi. On top of that, Alisi has a little bit of a droning on voice. So again, I want to be very clear. If to her supporters, they're going to just wash this out. It doesn't matter a lot, but I am telling you, as I hear right now, 119 on this Monday, that's wildly impressive, way better than the first jury. They took so much off the table as far as the Google search. They took off the table that John even ever entered the house. By the way, the defense has given up on that. They've taken away that he was going up and down stairs. The temperature on the phone, he never went inside. He never went inside. You can't argue that.
Nope.
Now they're trying to say, well, he was in the garage. Well, he was in the backyard. I guess you could just keep trying to change the story, but it's not going to work. All right, we're going to talk to Justin Katz, managing editor of AnchorRising.com.
I'm going to get off of this.
For our segment Politics this week. But folks, this portion of the program brought to you by Kids Club on the Pike.
We don't want to see politics. We love you, John DePetro, but politics is not something that we want to watch. We are sorry. And I want to do my own commentary. So yeah, Alessi putting people to sleep. Oh my God, is that a shock to anyone? Is that an actual shock to anyone that Alessi put the jurors to start dozing off? I don't think any of them heard an effing word out of his mouth. Also, Jack, since you are here today, I want to thank you for your $10 donation last night while you were doing Replay Crew. I appreciate it more than you know. Trial days are extremely slow for donations for the channel for whatever reason, even though I'm here twice as long. So I don't get that many. I don't make a ton of money on trial days, and it's going to be a very long 6 to 8 weeks. So I appreciate you being on my Replay Crew and also supporting me during watching the replay. So thank you, Jack, for your donation yesterday. Yes, we are going to watch the voir dire. Yeah, he crossed, but only for a few minutes, Alba. It was only a few minutes. And it took DePetro a minute to sort of get started. So we kind of just, we hung around a little. Oh, I wish I could nap with you. Oh, you're back where he's still going, Joy? Oh, boy. Oh, boy. So she said, Joy said, Alessi on this witness is good. I think the jury was given the key evidence on direct. He's dry and overly verbose in his delivery. He will bore the jury instead of making clean hits on evidence. I don't know why they let him cross such an important witness, to be honest with you, because again, like I said, he's way too long-winded. He tries to use, like, for instance, he used the word colloquy. Most people have no idea what colloquy means. Okay. Let's just throw that out there. Okay. I do. Most of you probably do, but you're talking about layman's terms. Make it easy for the jury to understand. He uses very big words so that he sounds more, important or more educated or smarter. One of the big red flags is if someone constantly speaks in large words or very complex words, that they're trying to make themselves sound smarter than they actually are. That's like, they've done studies on stuff like this. Like, so, yeah, like he does not get the point across quickly. He does not get, it takes him like 5 minutes just to do the next thing. Your Honor, I'm going to do this, this, and this. We don't need to hear about what you're doing before you do it, unless it's something that you have to tell us. Like, I want this in, in marked as evidence and the Commonwealth has agreed to it, or the Commonwealth is not agreeing to it, whatever. Like that, yes. But it took him like 5 minutes just to have 3 things marked as evidence and needed to tell the jury all about, and the judge all about what he was doing next. And it's like, there's no need for that. Then he started pointing out, like, did you put in your report that this message came from Jen McCabe and this message came from this person and that message came? No, that's not his job. His job is what is the data? Where is the data? Could it be deleted by the user? Could it not be deleted by the user? What timestamp is what, and when, where, why, right? So here comes Alessi like, well, did you mark on your report that this was Jen McCabe that asked him where he was and if he was coming? No, also irrelevant. It was before they arrived outside of Fairview with Waze, right? So for me, it's like you're boring the jury, number one. Number two, like they're not going to retain the information you're even trying to pull out of the expert because you're so long-winded and use so many large words that their brains are going to start doing what mine does with him, which is tune out. And it's really hard to get me to tune out on someone. Like I want to hear everything, every little bit from every little witness. I want to hear it all. So when I am literally sitting there listening to him and my brain is automatically tuning him out and I'm like, whoa, what did he just say? Like tune back in, tune back. I have to literally like tune my own brain back into him. Like that's how bad it is. Like people complained about Lally being monotone and he was extremely monotone, but at least I could still follow what he was saying. Like Alessi, you can follow, but he does the same thing over and over, like last 5 questions about the same exact thing. So you lose your point completely because you've asked it 5 different ways. You know what I'm saying? Like, and he's asking questions about things that don't matter. You're not hitting in on things that you're trying to like debunk or go towards your own story. You're literally asking things about things that don't matter, whether the message was from Jen McCabe or not even mentioning the time of it when it happened or like, so it's like, what is that to the jury? That's not really much. You know what I'm saying? Like, I love that you said this, by the way, Joy. She said, I'm sure Alessi's still going. Also, Penny, can I get a nap too? That would be wonderful. Naps are great. Naps are so awesome. Yeah, I thought maybe, running out the clock is definitely strategic. But you also risk boring the jury to death. And that's sort of what he's doing. And I find it funny, of course. You're welcome, Allie, that DePetro was like, well, a couple of the jurors started dozing off. He forgot to like turn the lights back on. And like, you could see them starting to doze off, which is so funny to me. It just stamps the things that we already know about this trial. And that the people who want her to be innocent or who want this to be a giant cover up are not watching the same trial as the rest of the world because they're watching it with rose colored glasses where everything. So if they just proved that John never went in the house, which is exactly what Ian Whiffen just proved, that phone was on him and he never went in the house. That is what was just proven. Also proven that 2:27 a.m. never happened, couldn't have happened until after 6 in the morning, just like Jen McCabe said. Also proven that she did not delete anything in her phone like they claimed. And that Richard Green called Ian Whiffen, but never called him back after Ian Whiffen tried to connect with him because he needed help reading the Celebrate stuff. So it's like, Where do you think you're going with this, right? Celebrate is going to be wrong. And the guy that works next to McNasty's, Richard Green, who apologized the last trial, is right. Come on. You don't expect a jury to actually believe that, do you? Because no jury is actually going to believe that. And they also still have Jessica Hyde. And I wonder when they're going to use her, you know? If they let Alessi cross all the experts, that would be a very large mistake. A very large mistake. If they make that mistake, I honestly have to feel like they were doing it on purpose as like a way for her to claim ineffective counsel later because they know that she's not winning this. Like that's, I mean, they have already proven she was driving drunk. So that's just like the first prong of like one of her things. She doesn't even say she didn't leave the scene. So leaving the scene of the accident, like she's the one driving the car. She never says she wasn't the one driving the car. So like there's no, you can't argue she wasn't the one driving the car. The car data doesn't lie. So it's going to show that she backed up 60 feet, 24 miles per hour backwards. She's not arguing she wasn't the one driving the car. So that's going to screw her. It's going to show she left the scene of the accident. And they pretty much already showed that. They showed that she was drunk to the point where she knew she shouldn't be driving and said it. And that her drinks were so weak, she had to pour a shot in too, because it wasn't as, strong as she wanted it. Change the number of drinks how many times. So like now the jury knows like she was drunk and shouldn't have been driving, like from her own words. So really all at this point they really need to prove is murder 2. And remember, murder 2 in Massachusetts does not require intent. In my opinion, they have pretty much proved that. And we're only going on week 2 of trial. Just wait until the rest comes out. Like, oh, I can't wait either, Alba. That's like, I've been waiting for it all day, but it was a good surprise to get Ian Whiffen this morning. Although I'm going to have to go back and watch a little bit of it from when I was in the doctor's office. Like I saw most of it, obviously. I was only in there for like 10 or 15 minutes, but like it was a very good surprise to get Ian Whiffen this morning. But now that we've done Ian Whiffen, when do they give us Jen McCabe? When do they give us Jessica Hyde? When? And also, once the defense gets rolling with their case, which is going to take less than a week, obviously, I can't wait to see Dr. Russell. I cannot wait to see Green be crossed. It's going to be amazing. Like, yeah, and Hank has no love lost for the ARCCA guys because they lied to the court, and so did the defense, Like, oh, yeah, that's another thing. Did he even mean to use colloquy, or he just wanted to sound smarter to use the word colloquy? You know what I'm saying? Like, what was it? Like, that's the thing. If they're muting or skipping the prosecution parts, then they purposefully are doing like what's called willful ignorance. There is no excuse. You cannot be willfully ignorant and then argue that she's factually innocent. There are no facts that show she's innocent, by the way. 0 facts. So the fact that they claim that she's factually innocent is probably the funniest thing I've ever heard. There are 0 facts to prove anything about her being innocent in any way, shape, or friggin' form. All right? Like... Well, he hates the games. And if they're purposely skipping through or muting the prosecution parts, then they don't get the entire case. And they're doing it on purpose because if evidence comes out from the prosecution that proves that they've been lied to this entire time, they're going to have a big thing to cope with. And I do feel bad for some of them. I honestly, as a person, feel bad for some of these people because I know that they're going to realize at some point that they have been misled, they have been lied to, and like they've probably spent money. A lot of these people throw money to a lot of these creators, like, and a lot. It's not a little. Some of these people are throwing $150 at a time every single stream to these people, like, and then they have to come to the realization that a lot of these people were lying on purpose for that money. That has got to be tough, dude. That's got to be tough. I mean, we went almost 2 hours and some change without getting a single donation this morning. And then we got our first one, which was $5. So it's like, if I was here for just the money, I would have given up long ago. It's nice. It's my income, of course, but I have to cover costs first. So if I had stayed up thinking she was innocent when the evidence came out and just said, F it, I'm just going to say she's innocent even when I don't think she is anymore. Because now I know with the proof, with the evidence that she isn't. If I just keep saying it though, I'll keep making the FKR money. I could have done that. I didn't because it's the wrong fucking thing to do. And I don't want to build a channel where you're lying to your audience for money. Like no, you should be honest with your audience about what you think is the truth. Whether it's your opinion, make it clear it's your opinion and make clear what are facts and what's an opinion. Like usually when I give an opinion, I'll say something like, That's my opinion, right? Like from what I know, that is my opinion. And most of my viewers who have been here a long time can tell you when it comes to me predicting things, I got a pretty damn good batting average. When FKR predicts things, they have a very low batting average on their guesses of things. And as we know, as of this morning, SCOTUS denied even looking at Karen's case. They're not going to touch that with a 10-foot pole, just like I said they weren't going to touch it with a 10-foot pole. So, I mean, once again, our predictions over here on this channel came true. Why? Because it was really easy legally to look at what it was and know that SCOTUS is not going to, there's no legal questions that need to be answered there. Therefore, there's no reason for SCOTUS to ever look at it. There's no big legal questions that need to be answered. There's very clear, very, very clear legal precedent about what constitutes a verdict and what does not. No double jeopardy applies or exists in this case. Period. Like, I know it's like 2 hours. You think that Alessi isn't going to go? Like, you're going to have to bring them back tomorrow and what? Tell the jury that, like, I'm sorry, but I think they should have taken the entire morning part or said, we're going till 5 because you got an hour for lunch, which they're only supposed to be 40 minutes. They usually take an hour. Speaking of lunch, I am so hungry. I'm going to have to get a snack when they come back for ARCCA because I forgot to plan lunch because I was focused on our field trip to the doctor and making sure you guys had the trial and that nothing would go wrong and you guys would be able to hear it while I was moving. So that took a lot of prep work and anxiety to make sure it was all going right for you guys. Hubby's home for his day off, but I'm not confident he would know how to fix this if something went wrong while I wasn't home and it was running. He's not a tech person. I'm the tech person in this house, so I wanted to make sure everything was easily, you know, there for him to use if he needed to like fix anything. He's going to take 2 hours. Like the Commonwealth's never going to ask any goddamn questions, but I think the judge was very clear with him that like he needs to be like speeded up. Like, you know what I'm saying? He can't be that long-winded that it's going to take an entire day to do, you know? It's very ineffective. Like, and I think if you know that you're losing, like it's a very real possibility that they do a few things on purpose, especially things that are not arguable. Like you can't defend the indefensible. You can't defend hard evidence in front of the jury's face. Like, so do you on purpose sort of throw it a little so that on appeal, maybe she can try for ineffective counsel? I don't think it'll work, not by a long shot. But do you do that as a defense attorney? Like, I don't know. They've done a lot of slimy things when it comes to this case. I would not be surprised, not in the least bit. Hi, Red Racer. I knew you were over there in the bushes. I got lots of you who are in the bushes. I bet Potluck's in the bushes. I mean, I wouldn't let him cross every expert, Alba. I think that is a huge mistake to allow him to cross all the experts. A huge mistake on the defense's part. I just don't understand why you would let him do that. I think Jackson's more effective, or maybe even Yannetti. If you're going to cross the experts, I think nobody's going to hear a word that Alessi says, to be honest. Yep, a comprehensive timeline. Exactly. And that's exactly what they needed to see, was a timeline with dates and times and how impossible it would have been for this conspiracy theory to have existed, you know? That's what I'm saying. Like, I believe that they've proved it, and it's only day 5. We're on day 5, guys. You know what I'm saying? Like, I heard him call Wolf 2 times. Oh, well, Wolf is also the guy behind him. The tech guy. His name's also Wolf, Mr. Wolf. So that might be where the confusion is that the guy that plays the defense's clips and does their like tech, his name is Mr. Wolf as well. I can't wait to hear Jessica Hyde. I thought she was fascinating last time. She was easy to follow, and she did it great in layman's terms for people to be able to understand. And that's how I feel about like law, is being able to break it down in layman's terms so that people don't have to like guess on the legalese of it all, that I can sort of explain it in a layman way where everybody can understand and it's easily understandable. And I think Jessica Hyde does a great job of that when it comes to the digital forensics in this case. Yeah, we think sometimes that Mr. Burns needs a neck pillow. I just bought my daughter one at Five Below that has Stitch on it. It's one of those little neck things. I mean, I could totally get one for Mr. Burns. Just saying. Maybe I can even get one with Mr. Burns on it because he's always this like a baby neck. He's got baby neck. He's just all over the place. Like, you think Hyde would be after Green? That would probably be smart. Either that or right before. Jimbo gets me with his one-liners. They're quite funny. A lot of you guys are quite funny. Where's the sunken grave with his one-liners? You watching from the Bush's grave or are you somewhere else? I feel kind of sorry for Alessi. He's so pathetic and desperate to cross on something, anything. I just don't even know why they're using him. That's what I'm saying. Wait until the car data. It's going to get so much worse for them. So much worse for them with the car data, guys. Like, I think I watched those 3 more than I listened today. It's hard to listen to stuff you don't understand, you know? Yeah. Ronnie the Juror has also changed his like story a couple times already. And I don't believe a word out of Ronnie the Juror's mouth. I think he was FKR long before he ever got on this jury. That's my opinion. But he wants his 15 minutes of fame because he's the only juror besides Victoria George, who's absent, by the way, again, running around to all the news stations telling his story, but also changing his story. So that is why after a jury is released, you can't take anything that they say seriously because they could be influenced the second they're released. And I believe that if he wasn't FKR ahead of time before he was put in the jury, then at the very least, when he was released from the jury, and he did dig into this, he was like, oh shit, if I don't say she's not guilty, then if they find out who I am, I can be harassed. Also, the jury foreman was doxxed last night quite a few times. And we know one of the only people that knew his identity was the Suet Turtle. So make no mistake when I say his play is usually to tell someone else with a different sock account and have them release the information so he can say, oh, it was me. It wasn't me. He just gives it to someone else to release. He's done it over and over and over, and it's easily predictable at this point. By the way, guys, I do have the trial on this screen so that when it comes back from lunch, we can get it back up here. I just figured you guys would want to see me instead of like them talking about it on the break over at Law and Crime because I'm not a huge fan of Anjanette Levy. I feel like she doesn't really do a great job, and her guest clearly has not watched the trial, maybe not even the first one, by the way she's saying certain things. So, yeah, I'm not a fan. I did watch Julie Grant this morning, friend of the show, Julie Grant. I watched her from 8 to 8:30 right before I came to you guys, or like 8:20 something until I hit the button here. And she covered this morning. It was a great job, of course, as always, Julie. Thank you, Julie Grant. You are awesome. Yeah, I think the car data is really going to be explosive. Oh my God. I absolutely love the prosecutors pod and their tweets. Like if you have a chance, you should go follow them on X if you have X. Their tweets trolling FKR are pretty freaking funny because they have common sense legal takes. Common sense. A lot of the times I'll be here telling you guys stuff. And then after I'm not live anymore for the day, I'll go and I'll look and see what they said for the day. And the other day, it was him and someone else that were like, if there's any people giving you their legal expert opinions saying that Kerry Roberts committed perjury, you can from now on stop listening to them. And so oftentimes I'll go back and I'll look at their stuff after I'm not live anymore and be like, hallelujah, I am not the only one that thinks that, right? So they give a lot of common sense legal takes on stuff that people just don't understand. Oh, there you are, Potluck. There you are, my friend. I mean, it's pretty bad over there, Allie. I mean, I'm not, again, I've made this statement before and I'll make it again. All channels should be like bringing in some sort of income. It is not easy work. I promise you that. You don't just, at least most people don't just press the button and go. I guess there are some people who do that. And to that, I say shame on you. But most people don't just press the button and go. You have a lot of work that you're doing outside of being live. So when I'm doing these trial days and it's, we're 5 hours in right now. We're doing 7-8 hours of live streaming. Then after that, I have to go check all my emails, all my DMs, return phone calls, return text messages, talk to sources, get court documents. Like the list goes on and on and on and on and on. And then on top of that, I got to get my regular, house chores done and homework with my baby and do all, because they're always going to be my babies, even if they're not babies anymore. And then you got to do dinner, bath, all those normal things while still checking emails, returning emails, trying to get information. Like it's not just a press the button and go and then shut it off thing. So every channel should be bringing in some sort of income for that work. It's a full-time job. It literally is a full-time job. But when you lie to your audience to do so, that's when I have a problem with it. That's where the line crosses for me, is when you start lying to them to say whatever will bring in money or whatever is popular at the time, even if you know that that's not even a legal thing. Like someone, for instance, like Nan Gallagher, who just says stuff knowing if you're a lawyer, then you either are really bad at your job, okay, and should go back to law school, or you damn well know what you're saying isn't true. A couple weeks ago, she was making a claim that SCOTUS had taken Karen's case, and no, they had not. And I had to make it clear to people, no, they have not. That's not a thing. That's not what happened. Like, you're a lawyer. Shame on you. You should know that. So, like, when they make these claims like this and they just think it's okay to do that, you are literally telling an audience of people that you're a lawyer and therefore what you're saying has to be true. Most people know I am not a lawyer, but I'm very good when it comes to the laws. I've worked in the system and I know what the hell I'm talking about. I wanted to be a lawyer. My life did not go that way with my daughter's medical. A lot of people tell me to just go back. I would love to. The time and the money is really where it's becomes an issue. But I think when you're out there as an attorney on LawTube or YouTube telling people legally this is your take and you know it's untrue, or you stopped practicing law a long time ago, like EDB or Melanie Little, like they don't practice really anymore. Or you're Larry the DUI guy who literally only cares, or better, who only cares about the spotlight. Like you do things to like, rile people up and get the spotlight. Like those are over the line for me. Like over the line. That is when you become a grifter, is when you will say anything if you think it'll bring in an audience who will bring you money. And you don't just go based on your own instincts and knowledge. Go on your own instincts and knowledge. You can have an opinion. People don't have to agree with it. It doesn't have to be the popular opinion either. But the truth is the truth, and it doesn't change. My opinion is not the popular opinion. But this is easy. Just as M. William Phelps said this morning on Julie Grant's show, it's a pretty straightforward case, cut and dry, of a DUI murder, and it got turned into a circus by conspiracy theorists like the blogger and Karen herself to try to not take accountability. And make no mistake, from that, the sewer turtle realized that like the conspiracy angle kind of worked. And what did he do? Now he's claiming everybody set him up. Leah, Kate, Morrissey, everyone set him up. What's so funny about that is nobody set him up. That's such a ridiculous assertion. Nobody made him go to these people's houses and harass them. Nobody made him do a rolling rally. Nobody made him go to his ex-girlfriend's house. You can't set someone up to make them do this stuff. No one made him do any of that. He did it himself, and to avoid the accountability of his own actions, nobody made him go outside of Chris's pizza shop. No one made him do any of that, yet he still claims it's a conspiracy and a setup and everybody set him up, and people believe it. The fact that anybody believes that he was set up is like the most laughable thing on planet Earth. Like, how? Please show me how that could happen. Wishing you're in jail because you are a piece of human garbage. Yeah, SCOTUS is in on it too. We're all in on it. Like, us having text conversations about how he should already be in jail, or why they're not moving fast enough, or why they haven't charged him with X, Y, and Z if they're crimes that he has done, it's not a conspiracy to set him up. It's wondering out loud why he's not being held accountable for the crimes he's already committed, and why is it taking them so long to do something. Passing along information of those crimes that we have from victims that come to us, also not a crime. I pass along information all the time. I will call them if I have to, email if I have to. It goes to like a regular person, and what they do with it from there, I have no friggin' idea. I have never spoke to Hank Brennan ever in my life. I've never spoke to Lally ever in my life. But they love being like, well, you're just paid by the Commonwealth. Okay, well, if I'm paid by the Commonwealth, please show me where that money is. I would like to know, because I want it. I need it. I also need a car. So like, if I'm being paid, please direct me to where. Direct me to where that's happening. Like, oh yes, I have. But I also knew everything in that affidavit that she signed was a bold-faced lie. So they're going to be in a lot of trouble for that. Make no mistake, we will hear something about that sooner than later. No, it's not back yet. I have it right here. It's not back in session yet. Yeah, that the health data was really quite interesting. Court's not back in session. Right? You missed people saying that earlier, Joy. They were like, yeah, he makes people want to smoke. The hearing is not on. I have it on my screen right here. It's not. They're still going over things on law and crime. No, as far as I can see, it's still, they're still going over stuff on law and crime. Maybe you're seeing a replay. You must be seeing like a replay of earlier, because I don't see any, not at least on law and crime. Oh, here. Yeah, no, this is, maybe it is now. Maybe this is it now. Hold on. Hold on. Let me unmute this real quick. No, they're still showing. No. No, they're still showing recaps. They're showing recaps. Nope. Recap. All recaps right now. It's not, Holly. I'm literally looking at it. You must be watching recaps because it is not in session right now, honey. Check 3 channels. It's not, somebody's playing a recap if that's what you're seeing, because it is not in session. They're on lunch right now. I got the link that you sent me last night. I did get that email. I checked it a little while ago. I didn't. I'm going to, though. When we go back, I'm going to find myself a snack. He is hilarious. He absolutely is freaking hilarious. I concur, Alba. He is quite funny. Was it? Was it really? See, I knew something was wrong when you said they sent you that message. I'm like, that doesn't sound like something that PayPal would send. And I didn't get anything on my end, so I knew something was wrong when you said that. I hope PayPal figured it out for you, though, because that's not acceptable. Not cool either. Like, right? American idiot. Lots of stupid shit. Lots of stupid shit. Yeah, sorry, but she's not going to fit in here in Massachusetts. She might want to pick a different state, you know? She's trying to get those nurses with the brain tumors as clients. Well, that stinks. Sir, you don't ever have to be in the bushes. You can always pop out. Yeah, well, that's part of like the cult mentality is you didn't see what you saw and you didn't hear what you heard. Yeah, and that should be like a red flag to everybody when he starts talking about Jesus wanting him to do X, Y, or Z. Like, that's called delusions, my friends. Delusions. The man's been delusional for quite some time. The fact that they're still still haven't picked up on it is insane to me. Like, yeah, exactly. It is, and it's extremely dangerous. And I think the frustration is that the Commonwealth doesn't seem to understand how dangerous. Just because he didn't go to someone's house and stab them with a knife does not make him not dangerous. The lies and the misinformation are extremely dangerous. The manipulation is extremely dangerous. Like, yeah, I saw the thing that Kate wrote. Right? Don't we all, Lisa? Because that's what we all want. Somebody actually commented on something. I commented on Pat, the profiler's thing, like a while ago on something she did on this. And somebody yesterday was like, okay, Jen. And I'm like, if you think I'm Jen McCabe, then you are really, don't ever be a detective. You are really bad at this. Like, my name is the same. Everyone knows who I am. Like, so if you're suggesting that I'm Jen McCabe, you're an actual idiot. Just FYI. Like, facts. Yeah. Court's not in session until 2. Like, not only is it not in session, I have it on my screen right here. I have it on a screen over here on another tab. Like, I can literally see it right here. This is, see the screen? I'm watching Law and Crime right here to make sure that when I need to pop it up here that I can. Yeah, and DePetro is still outside. So, well, that's the thing, right? That's all you're going to see is actually insane. Like when you have to listen to the sewer turtle about legal takes, you probably should stop and rethink what you're doing. Okay. The man has no idea what he's talking about. None. Like, I did see that. I saw it this morning around like 7:30. It's hilarious. Yeah, no, yeah, I mean, stay in New York with Vetero, please, for the love of God. She popped up out of nowhere and started following me right away. And I was like, who is this lady? And then I looked and I was like, yeah, no. No. Right? On vacation in Italy all the time? Like, is that a thing? Like, hilarious. It was pretty funny. The Robert Stack thing was pretty funny. Not gonna lie. It was hilarious. I am dying to see what ARCCA says for themselves. That's for sure. Well, usually Insider Man takes over some silliness. Ashley always has some silliness. Monarch's got some super silliness. We usually have Sunken Grave. He does some good silliness sometimes. I don't know where he's at. He's probably checking out some other channels right now while it's lunchtime. I don't know who stays on and who doesn't. I'm not really privy to that information, but I heard not most people don't stay on during lunch, but I feel like we don't really give a lot of commentary when it's not lunch. So what is this? What is happening? Got an email and I was like, okay, I just want to make sure I'm not missing any donations. I am not. I don't see anything. If you do want to donate to the channel, it'd be very helpful. It's all we get is our donations from our viewers, and that's how my channel survives because we're still trying to grow. We're still small. Car trouble is the worst. And so you can do it one of three ways, these ways, or we have an Apple Pay link that Free can put in the chat. If you have Apple Pay and you want to do that, we very much appreciate it. I've read all the few that we got today already. The last one I think was the $50 from B Tim, which was super nice. Thank you, B Tim. We appreciate you, my friend. And we thanked Jack. I don't know if he heard us, but he probably popped out. But for his from yesterday, he sent $10 while he was watching a replay. And I love getting those because they're surprises and I'm not live anymore. So like when I'm not live anymore and one comes through, I'm just like, ooh, what a nice surprise. I mean, it's always nice to have a surprise, right? So I always appreciate, everyone that does their fair share, and replay crew is just as important as you guys here in live chat, because when people are watching the replays of it and they like it then and they comment on the video, it lets the YouTube algorithm know that people are interested in the video, and that's when it sort of pushes it out to other people who didn't know we existed. It puts it in their recommended, if you will. So I appreciate everybody's help, whether it's you hitting the like button or you sharing, or you sending a donation or a gift card or buying off the wish list. Whatever you do, it is all helpful, no matter what it is that you do, watching it on replay. All of those things are super important. I appreciate all of you guys. I honestly can't say enough how much I appreciate you, because without my viewers and my community, where would I be, right? Like, ugh, the only other options I have now that your PayPal is fucked up is I guess, you can't do Cash App and Venmo, right? Because you're not in the States. So we have the Apple Pay link that links, like you can pay with Apple Pay and it still goes to my PayPal, but you can pay with Apple Pay on it. So I have that. And I don't know, the only other option I think is like sending e-gift cards or buying off the wish list. I think that, I've been updating it. I have to do a couple updates on it myself, but there are some like common sense things on there that I use for my house, like water, juice boxes, that kind of stuff. And there are other pretty random things, couple of things for my kids, couple of random things for me. I really don't ever put much on my own wish list for things that I want, but I'm going to start doing it just because like, at least I can remember in my head what I want to try to save for, like I want to save for some like outdoor furniture for my yard. Like I definitely want to get like at least a small set with like an umbrella because there's like no shade in my yard because it's like all yard. There's like one tree and it doesn't give a lot of shade. So I want something that has like a little bit of shade and a place to sit and for the summertime. That would be nice. So I can sit outside and grill some food. Oh my gosh. Mother's Day is coming. Everybody remember that Mother's Day is coming. So even if you don't have a mom, you know, and your mom has passed, there's so many other people who are moms that are probably in your life that would really appreciate even a handwritten card to say like Happy Mother's Day. Like your neighbor, your friends, your sister, anybody who's a mom, and even single dads, because they do the job of both. So, you know, even on Father's Day, for instance, me and my husband would take out my friend that we would take out for Mother's Day. We would take her out for Father's Day for lunch as well, because she does the role of both. And so it's vice versa with single dads, you know, they're doing both roles. They deserve to be celebrated in both ways. You're doing double the job, you know? So, I mean, think about fun ways to sort of do that, but Mother's Day is coming up and then Father's Day is the month after. So, you know, there are nice, cool ways to like show people that they're appreciated and they're loved. And surprises are always nice, even if you're just leaving like a handwritten card on your neighbor's windshield or your sister's windshield as a surprise. Like, it's nice to know that you're appreciated no matter who you are. And those are like little good things you can do to like put good karma in the world, you know? Like I usually do my neighbors is what I usually do. You know, leave a card with a gift card on their door, like Happy Mother's Day, Happy Father's Day, stuff like that. It's just little cute ways of like letting people know that they're not alone, and not everybody has family left to celebrate them, you know? Some people don't have family left alive or didn't have family to begin with. So you saw the umbrella. Yeah. I got to find furniture to go. I want to find furniture to go with the umbrella. Like I got to find something to go with the umbrella so that it's like a set or something, you know? I couldn't find a pink one though. I was very upset about it. I'm not gonna lie. You guys know pink's my favorite color. I will not let her ruin pink for me. And I could not find a pink set. Okay. And then I thought about it and I could get like a black wicker set and then get pink. Like the pads could be pink, but I wanted something that already had that, but it didn't. I couldn't find anything on Amazon that was like that. So I was like, this is silly. A pink sectional. That would be my dream. Unfortunately, it's so narrow in my stairway. It would have to be like a modular. It has to be a modular sectional to fit into my house right now. The 2 couches that I've already tried to get up here and fit did not fit. So the chair fit. I have a chair, but the couches themselves did not. So I got a futon and a chair right now. He has like this link. He has this link, I think, that either goes to his bank account or his PayPal or whatever, that some person from like Bangladesh, he told me, set up Turtle Chat for him. That's what he said. He paid somebody from Fiverr to set up Turtle Chat for him. So I don't know. It probably goes through like maybe they have like these things that go through readers for like not just Chime, but like the company that owns PayPal. What's that company called? So they have a thing that like you can pay with a debit card or whatever on certain things, and you can make like a link out of that so that people can pay you that way no matter what card they pay with. I have to figure out how to do that. I have no idea. I'd have to maybe Freak knows how to do something like that. We'll have to figure it out, because I know the only option I do have for you guys in the UK is really like PayPal. Like, you know, it was good, Lou. It was good. It was good. It was good. Like Ian Whiffen was the expert, and now we're getting ready for ARCCA. If I were you, I'd wait, watch the ARCCA stuff, and then go back later on and watch the Ian Whiffen stuff from Celebrate. Because he just proved that John's phone never moved and that John had his phone on him, which was beautiful. I wish it was Potluck. I'll figure it out. For now, the only option I really have is that Apple Pay link for you because your PayPal's all fucked up. I hope that answers your question. They need to fix that for you, though. That's not cool. Like, I knew when you told me that was sent to you that it was maybe a phishing link or something. That's why I was like, be careful. That's weird. Like, oh, very damning. It is, right? Because he lurks in the sewer. Actually, when I see people write it on X now or you Facebook, like when they are writing about it and they're like, "I'm the sewer turtle," I literally just am beaming with pride. I'm like, oh, like I love it, like because that's what he is at this point. He is a turtle who is literally lurking in the sewer of shit to hide his own dirty deeds and blame innocent people because he can't take responsibility and Karen can't take responsibility because if Karen takes responsibility, then I mean, that's bad for him. It's bad for him. Like, she takes responsibility, people know he's a goddamn liar. So that would never be good for him. So, he still thinks that if Karen is found not guilty, that magically, all of a sudden, his charges will magically disappear. Magically malicious. He literally is malicious. He just doesn't care who he hurts as long as it's not himself. He'll say or do anything to not take responsibility. And if people go back to before this trial, which obviously I did not know about him until after, but if you go back and look at the things that he has done before this trial ever existed, it's a pattern of behavior. It is a pattern of behavior. This guy mowing the lawn is really like killing my vibe over here. He's extremely loud. ARCCA will bring anything today. Oof. If they say it's all deleted, I think that they know that the judge is going to be extremely suspicious that it's deleted. So, I don't know. It's a toss-up. Does she... I don't know. You got to think about it. Does she buy their theory of, it was all deleted as well? I don't think so. I mean, she's going to know right away. Like, if they say it's all deleted and they don't have any of it, why are you deleting records that you have? And the defense is deleting records. Like, that's going to be suspicious. If they only bring certain records that don't say much, she's also going to be suspicious. So I'd really like to see what she's going to do. Okay? Because I would have already, as a judge, they would have been out already. There's too much shady shit going on. They can't be trusted. Okay? And they're clearly biased. There's nothing independent about them. So I would not be allowing them in. But I wouldn't have allowed them in a long time ago knowing they were lying. You know what I'm saying? Like this, now we're in a voir dire, Oh, sorry, my bad. I moved it closer to me. I just moved it over. It's only on like 26 or 20, funny enough. It's like really low. The mic volume's super low. You have a theory about Turtle Club chats. You don't get to see them so he can make up his own. Oh, well, he does. Like when he wasn't getting a lot, he would just make them up and be like, well, so-and-so sends $50 and says, and he's told people that he thinks that by doing that, it makes other people want to donate. And maybe it does, but it's sketchy and it's fucking shady. Like, no, thank you. Like, people are going to donate if they donate. They don't if they don't. Like, I mean, like I said, my days that I stream, the longest trial days, I actually make less money than if I just did a regular 3-hour stream. Don't ask me why. I have no idea. I think it's mostly because people are focused on this. You know what I mean? We want to hear everything. So they're not thinking about like the channel. They're thinking about this, which is what we want. We want you to be focused on this. But I think that was one of the reasons why he started making it up, because at times it would be slow. And so he thought that that was a way to like, get people to donate more. And apparently it worked. I mean, whatever. Like, I wouldn't do it. I think it's sketchy. I think it's shady. I only read what's actually sent to me. I just don't read people's names if it's their like regular name and it's not their screen name. And if I don't know their screen name and their regular name pops up, like yesterday I had someone pop up that I hadn't had before. And so I didn't know their screen name. So I just didn't read their name. I just read it as anonymous because I never want someone's name out there for these people to harass. I'll only read the screen name, or if the person is okay with it, their first name. That's it. That's as far as I go. But if someone asks to be anonymous, I'm always going to read it as anonymous, but I only read when I actually get. Like, that's, you know what I mean? Like, when I was told and then showed like that he admitted to this, I was like, this is like beyond belief. Like, some of this stuff is so crazy, you could never believe it's actually happening. Like, that someone would actually do stuff like this. But he does. unfortunately. Like, oh, yes, you guys, I should give you guys exchanging information because you're both on X. So that'd be a good way to start a conversation. And yeah, Discord too, right? Yeah. I mean, you guys should talk. You guys are both very, very smart. And you guys live in the same country. You guys have to figure out a time to come out here and visit. I think maybe after the verdict is read, you guys should visit. We should have one big meetup party. And then for the people who can't come, we'll put them on Zoom, and it's like they're there anyway. You know, we'll put them on Zoom on the big screen and bring them out with us. Bring them outside with us. Yeah, I have it turned down. It's on like 26. I didn't want to turn it lower because I didn't know how it would sound, but I guess when I'm raising my voice higher is probably when it's blowing out. Joy said, Kim, Dr. Wolf outright lied about his relationship to the defense. Dude, these allergies, it's because I was out today. Like, my eyes and my nose are so itchy today. Like, I can't. My eyes too, like, and I don't want to keep sticking my fingers in my eyes, but they're like so itchy from like the pollen, and it's starting to get. I only got allergies the last couple days. We do need a good cookout. Yeah, I agree. They should have been booted before as well, Joy. Like, there's no reason why they shouldn't have been, in my opinion. I think any other judge at this point would have. But Joy also said that Dr. Wolf outright lied about his relationship to the defense and having a $24,000 retainer agreement with Alan Jackson to testify for the defense. How does he explain this? He can't. Their only explanation is, that, they were paid after the trial ended. That's not an explanation. As we know, it wasn't for the second trial. It was literally for the first one. So, I see some movement. Something's happening.
You are unmuted.
Ooh, here we go, y'all. Make sure you like, subscribe, donate to the channel if you can. It's very helpful. Let's go, ARCCA. Let's go. Let's see what you guys are gonna say.
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present.
All right, thank you. All right, so we know that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the ARCCA witnesses. Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCCA witnesses or to exclude their testimonies. Upon that, I believe, I issued an order last week for certain discovery to be provided and to be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So Mr. Brennan, who are we going with first? Dr. Wolf?
Please.
Okay.
Do it. Let's do it. No, she is clearly not happy. That's right, Jane. She is, look at her. She's clearly not happy. That's for sure. Oh, here he comes. The liar in chief.
Once you're set, you're going to face the clerk and raise your right hand, please.
Exactly.
I swear that the testimony you shall give to the
What are the
court in the matter
consequences?
now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
All right, go right ahead, Mr.
Thank you. Good afternoon, doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So we
order?
need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolf, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When
Wow.
you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Ms. Little, last year I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first
I
contacted
definitely
by
called
the
it.
defense?
Yes, sir.
You provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
Yeah.
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Ms. Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please. Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on the
Yes.
defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You have a Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with
So
Mr.
now he
Jackson.
knows dates.
Was
He didn't
that more
remember,
than about logistics?
but now he knows
Well,
the
I
date.
think we were trying to figure out what should we do.
Not believable.
I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the
That's being
trial as
hired.
expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you on March 20th, 2022, not the 22nd, not the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in
It looks
April
like-
of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for
Right?
the defense?
That's the defense
Do you
talking
feel like
points.
you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call, letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission, they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
What is he
I remember that
objecting
there were conversations, yes. Specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that was the first call. There were more than one call. There was
He's definitely
then 2
scared
calls
because
to
he
the
doesn't
main
know
line.
what Hank knows
What did you
and
do?
what he
Discuss
doesn't.
with him during those calls?
Well, to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April
Yeah,
still?
I'm still talking at April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall
You
from
don't
a year
guess.
ago.
When I asked you to guess, I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024. Do you remember that one?
I don't remember that call, sir.
Do you remember the call on May 1st, 2024?
Yes, you don't remember.
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
Stop it.
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you,
Bullshit.
did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCCA, but never, ever talked about this case.
Not buying it.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So
yes,
that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out.
Not the question.
That invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolf.
Okay.
Oh,
so in
please.
order to get paid for that, you would have had to submit that time through ARCCA to then forward it,
It's a
wouldn't
very
you?
bad liar.
Going to allow it. Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
To get paid.
Who asked me that? Yes. Come on over.
No. Unless he's bitching and whining because the truth is coming out and he doesn't like it. The judge is going to allow it. It's a voir dire, sir. You can object as many freaking times as you want. He works as a salary. You expect me to believe that? You expect me to believe clear, like he is literally dancing around the questions as if not to answer them. He's making himself look like a fool in front of the judge. You think the judge is going to believe that, oh yeah, I'm a salaried employee and I just keep track of my time so my boss knows what I'm doing. Not so that the company can get paid and I can get paid for going and traveling as an expert witness, but just so my boss knows what I'm doing. Like 40 minutes and you didn't talk about this case? Get the f out of here, bro. And the judge is going to know he's lying. That's the problem. Like they clearly, like I predicted, A, as I predicted, no records. Isn't that about a bitch, huh? B, as I predicted, the defense clearly had a conversation with him about how they could work their way through these effing lies. And I knew that Wolf was going to be worse than Rentschler. I don't think Rentschler really wants a part in lying, but what choice does he have at this point? So Wolf's not a great liar. Let's throw it out there. He's just not. Like, get the hell out of here, bro. It's not even believable because he's dancing around the questions to not answer really like straightforward questions. Did you get paid for that time? That time that you marked down as a phone call to bill on, did you get paid for that? Did you put that in the system to then have the money given to your company?
The problem is,
go for it.
Just 1 second. 1 second. The problem is with him. I had you play in the background. I forgot to mute it. The issue is that you have 100 texts and you don't keep any of them for billing issues. So you're going to bill people and you're not going to keep any of them for billing. That's wild to me.
Yeah, not buying it. Yeah, because
that
they
would be billable.
Clearly had them.
Yeah, that would be billable.
Yeah.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Now, when you billed, did you bill for the entire
You
conversation?
knew then.
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families.
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay.
Objection, Your Honor.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
No.
You're friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
So,
Yeah.
do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
So next question, no comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was it 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those.
Bullshit. To hung
Do you
jury.
remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial. So.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you were?
I just said I delete text routinely. You're asking me to specifically give you a location and a time when I deleted those. I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like Signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use
Oh my God.
an application like Signal to talk to an attorney on a case?
Sure.
You get the
No.
benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, encrypted app, isn't it?
Come on.
What was that?
Encrypted?
I don't know, sir.
It keeps no record
Yes, you do.
of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you use
Lie.
Is that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted app when you're talking to
This is so bad.
attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations do you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
This is so
Okay, you're
bad.
saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know.
This is so bad.
How many times did you use Signal with the defense to talk about this case?
Objection, Your Honor.
Going to allow it.
From what I recall, was probably a handful of times.
When you say if what you recall,
Look at Jackson.
are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Oh, you know that it
You
doesn't keep a
cannot-
log now.
You don't have to rely on a log. You can rely on your actual memory.
Right. I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means. I don't know
Probably
what that
around,
means.
probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal? The 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were you
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Objection, Your Honor.
Can you answer that? How confident are you, Dr. Wolf?
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to Your Honor, you knew that one of the important things you need to respond to were communications between you and the defense for Her Honor to consider,
I
right?
love this for Karen
Yes.
Reed.
And Signal is a communication, isn't it?
Certainly.
You looked at all your records and you knew it listed the text messages and the phone calls. You knew that, right?
Yes.
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
Yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that there were phone calls through Signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries.
So you were hoping nobody knew.
I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
That's right, Joey.
I'm sorry. Can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Shocker.
Yes.
Oh.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire
Karen's
in the last
laughing like
trial,
this is funny.
did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me,
On your
did you
dime?
think that the defense was going to compensate you for the costs of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again,
No.
I don't know who was going to pay the bill. I'm not.
That's not
No
what
one.
I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Yes.
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again,
Have
I
to.
enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty
No.
particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without the qualification, the simple question is, you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? Well, how was the introduction? How
Exactly.
did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked
How,
me back
though?
to the lot.
You had to have a
Did you
conversation.
conversations with anybody from the defense about how you'd get here and and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
Okay. And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and a couple other members of the defense team.
Remarkable event coming to this trial, wasn't it?
Objection, Your Honor. Going to allow it.
Pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face, right?
Yes.
Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so,
You
had a conversation about the case.
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
Yep.
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where Andy Gallen would reach out to me. He would give me some information about the scheduling and kind of when we would need it. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there's kind of that channel of communication to try to figure out when we were to arrive and where we were supposed to go.
Funny.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there. We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
Right, Joy?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
Okay.
Why?
You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with the person on June 16th?
Yes, no.
No.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
Okay. So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with the client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
Your email, do you recognize that?
Wolf Direct.
And that's before you testified on trials 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Everything's routinely. Yeah, got it.
There's an email.
Go and find it, bud.
A document I'd like to attach as an exhibit.
Okay. Exhibit 1. 1.
So you assisted the defense before your testimony.
Hold on.
Karen with her arms crossed. Jackson trying to look like he's not ready to fucking lose it when clearly he
Thank you.
is. He's
So
clenching
you
his jaw.
assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustained.
Do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor. All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
It's not their
You don't
job.
want to answer my question?
Objection, Your Honor. Sustained.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document, and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
Objection, Your Honor. I'm going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense.
Yes, it is.
wasn't to help anyone but the jury understand things. As I just
Stop.
mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense.
Different perspective.
If you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect.
It does matter, though.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Sir, there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
Yep.
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury.
Yeah.
That's what I was trying to make sure that that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you wanted to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
Nope.
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19.
That's
Would it
fine.
be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then, do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes.
So for
Remember
the
that?
jury
Yes.
to decide that, not
And then
you.
You made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to.
Okay. Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not, correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
No, these are important. You can't move along unless you're going to do the same thing to Mr. Lucky. No.
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one?
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls incoming and outgoing as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCCA did send an invoice afterwards, yes.
Did you talk to ARCCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
ARCCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than scheduling, doesn't it?
We.
I would
You said
describe it as
we.
logistics, sir.
Logistics.
We decided.
You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it, yes.
It doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easy to understand if you could just tell us what the conversation was. That's what I'm asking you about.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And sir, is there any other communications that you've had with the defense that you didn't tell us about?
Ouch.
Outside the texts and the phone calls?
Yeah,
and the
pictures.
signal calls? Or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
I have pictures
Mr. Lessie, do you have anything?
of him.
Are we going to get to Dr.
At lunch.
Rentschler today or not?
Well, you know how much time Mr. Brennan's.
I'm just asking you.
I hope so.
Okay.
He's asking you to not be fucking long-winded. No reason. He very clearly was lying and couldn't even answer basic questions without trying to
Your Honor, may
talk around
I
it.
approach
Red flag.
the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to
This is pointless
recent
questioning,
matters with
by the way.
regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yeah, they already did one.
Yes.
Could you
You
please
did.
read
Rentschler.
the,
Dr. Rentschler.
excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing
Sure,
record.
we can mark it.
That is exactly, thank you.
Oh my God, it took all that time for him to just say, could you mark it as an exhibit? Like, what the?
Thank you.
Come on, man. You are a terrible attorney. Go back to environmental shit.
I offered it into evidence, Your Honor.
Okay.
We know what you did. Don't tell us.
I allow the witness to have that.
Yes.
Thank you. Take it.
Oh, fuck's sake, dude. He is like a little child. Your Honor, I'm going to put my right foot in front of my right foot now. The fuck? Yeah, exactly. Can we move it along, Mr. Alessi? We're taking 17 hours to do goddamn anything. Also, those questions are pointless. We know that he was sent an order. So what was the purpose of re-asking that same question? Like, stupidity. Oh my God. What is happening? He's a terrible attorney. I don't know why they would hire him, honestly. He's an idiot.
You're with me, Your Honor?
I would have fired him. Sorry. They live in such a skewed view of reality that they let this idiot continue to be an attorney when he's clearly doesn't know what he's doing.
Dr. Wolf,
Jack,
I
love
realize
you.
that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Spit it out, bud.
All records within ARCCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did
oh my God.
You
Here we go.
and to the best of your knowledge,
Trying to talk around it.
everyone associated with ARCCA complied completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCCA had in our possession, we produced.
He's going to try to play word games. That's what he's going to do. Arker.
Go back in time with regard to
oh my God,
your interactions with the United States Department of Justice in February of 2024. Was ARCCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCCA?
Well, let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have from any time in 2024 any understanding that any of your time that you were entering was to be billed to the defense team in this case?
Also, remember the judge found all this to be lies already, so I don't even know why he's reharping on it.
Now
already
go
found that to be a lie.
to your
It's
first
representation.
interactions with the defense.
He's
As
still
I
arguing
understand it, well, why don't you tell me what was the first date of your understanding of interactions with the defense?
Well, first, he knows dates now.
I believe it was sometime in mid to end of March of 2024.
Oh, now he knows dates. Interesting. He remembers now.
Again, that would have been over a month from when we issued our report to the Department of Justice.
He's arguing the same thing
Your
the
Honor,
judge already
may
found
I,
that they misled about.
Approach the witness. Thank you.
Stupid. This isn't helping them at all. The defense are a bunch of idiots. This is all stuff the judge
Your
already
Honor,
found. He
may,
was
what
misleading
I
and lying
have
about.
is the entire production that ARCCA made. I think it would ease
Oh my God.
in terms of
She's seen them.
Sure, he can have it.
Thank you. Use that pursuant to the subject to the Honor's permission to answer any of my questions if you need to.
Okay.
Now, in March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit here today, has there been any change whatsoever to that report?
No.
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice in February of 2024?
Yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony in the first trial,
Even Jackson's not impressed with
before you
Leslie.
took the stand, did you have any discussions with any member of the defense about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCCA was working for the United States Department of Justice, do you know whether ARCCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
In 2024, did the federal government prevent ARCCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to
the emails that were discussed with you, starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
Okay.
Are you there, sir?
Yes, I think so.
Okay. Well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolf. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCCA would be compensated by the defense for any aspect of current or future work?
No.
Was there any understanding or discussion that ARCCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that ARCCA would be compensated for any work associated with this case?
No, sir.
What was, briefly, the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to when I'm looking back at this phone record log, there was an incoming call to the ARCCA main line on March 20th, 2024 at 7 a.m. And that's Pacific Standard Time, so that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from ARCCA to Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Look at Karen running through paperwork as if she doesn't already fucking know what's there. Like, come on, man. Ridiculous.
I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense team about that invoice before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at ARCCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries,
any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time and what your thought process is as you're entering each of those time entries? Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got, an 8-9 hour day, right, I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet so that ultimately, again, my boss and the accounting department knows what was Dr. Wolf doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
right,
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
And for any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to the emails we were talking about. Specifically, we left off with the March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email. What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for that, the email that you're looking at? Sorry.
Tab 1, please.
Tab, okay. Right, so the first email that we were talking about on March 20th, 2024 from Mr. Jackson to myself, it looks like the next email was from me to Mr. Jackson 2 days later, March 22nd, 2024 at 6 a.m. I sent an email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, I remember part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversation you had as of you sat for the voir dire in April of 2024?
Again, they were all scheduling, logistics. And when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea. Hey, can you come this day, right? And then I would relay that to Dr. Rensselaer and say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Now let's go to the next tab with regard to the outlines that were asked.
They're never going to get to Dr. Rentschler.
Direct examination by
Not today,
attorney.
because he won't shut up.
You've described this situation. Well, you described how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government? There's rules of the road, so to speak, as what you can do, what you can't do. And then you've got a private defense team. Have you ever been in that situation?
He knows the
before?
fucking rules. Come on, stop.
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not?
Cause anything.
Sure, yes.
Sure,
in
yes,
terms
what?
of your
That wasn't the question. There was no question on sure,
outlines
yes
that
answer.
you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
Was there any other motivation that you had in sending that outline and that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis,
the
what I
defense.
did, what I reviewed.
Stop it.
Did the defense ever,
Judge doesn't even believe that.
ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours in your mind to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations, and I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
Yeah, because you were asked it by the Commonwealth.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever?
I'm not going to get to Dr.
with the
Rentschler
defense team?
because unless he's going to ask
No,
the same
he
17
didn't. Mr.
questions.
Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation
You've
with
asked the
Mr.
same
Jackson
question.
or any other member
5
of the
fucking
defense
questions.
team
5
about
times.
the
Same
substance of
question.
your upcoming testimony?
No, sir.
So you went and sat during that trial
Ugh.
and gave testimony to the jury without ever having talked to a member of the defense team
Bullshit.
about the substance of your February 2024 report?
Correct.
Bullshit. Bullshit. And the judge knows it. She's already found that it was deliberate and a lie.
Do you recall any member of the Commonwealth
Oh my God.
asking any questions at all during your trial testimony about whether you had been compensated by the defense?
Please.
No.
Do you recall the Commonwealth
They did.
ever asking any questions at all whether you had communicated with any member of the defense
They
with
did.
regard to your testimony while during your trial testimony?
They did.
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time
They did
you had
ask.
been promised
You idiot.
or induced by the defense?
They did
Do you
ask.
remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
Unless he wasn't in trial
At
one.
the end of the
Clearly,
trial,
he didn't read the transcripts.
did you have any understanding whatsoever that ARCCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No. And the records certainly reflect that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between
What
us.
records?
Well, let's go beyond Mr.
You hid
Jackson.
them.
Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses,
Go ahead and say no.
disbursements
Say no.
that you had or
I dare
incurred
you.
up to and through your trial testimony?
I dare you.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed to December.
You asking the same
of
questions
2024.
75 more times?
Were there any conversations from the end of the trial
Your Honor.
until December of
Asking us-
2024,
Beat it up.
other than logistics? Well, was there any conversations of any kind? And please summarize briefly what they were. Or texts.
The only communication that I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder
That's
of
definitely what was
2024.
said. Sure thing. He's going to keep
Now
asking the
let's
same
go
question until the
to
judge stops him.
recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
No.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
He's very uncomfortable
Now
lying.
let's go to
Then
this
don't
year.
lie, sir.
Did the defense approach ARCCA to see if they might be able to testify in this trial that's currently?
Well, let me guess. Hey,
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was
January.
in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
Now he knows all the calls and how long they were.
Substance of that call?
Well, I think back to that time frame, I became aware that I think that there were
Now
was
he
a motion or
remembers?
two regarding ARCCA and potentially excluding our testimony for the upcoming trial.
Now he remembers.
I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the
Your
internet.
wife's
So
fault, sir.
it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet?
You don't get to
why
say the
are they
difficult
talking about me?
time,
Why am
sir.
I getting
I've
all
been
these hate
harassed since
emails?
2023. Go fuck
So it was,
yourself.
I think, a conversation to figure out, hey, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children?
Probably.
What did you conclude was the reason why you were receiving
Yes,
that?
tell us the reason.
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCCA or myself.
So just so I'm clear on
You
that,
lied.
it was, you believe, regarding comments about ARCCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Yes.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate it out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at. Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
Please.
My understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, et cetera, do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, et cetera, did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Rentschler and myself are particularly interested in are extremely vague in that report and PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCCA's business to evaluate that information and prepare your own report, analysis, and finding? In the ordinary ordinary course, how much time would it take ARCCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward. He immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, at the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative terms, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So we immediately started to review that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right?
No, you don't.
In a case like this, I mean, ideally we would be talking months.
Can we stop them from asking the same questions and getting the same answers over and over and over?
Be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Rentschler, to review that material, and certainly in parallel, try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at ARCCA to work on this matter?
Absolutely. Work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary.
Good
so,
for you.
So
Objection
it
has nothing to do with
affects his
anything.
personal life, I understand.
Okay, I'll move on, Your Honor.
Nobody gives a
With
shit.
regard to the work,
It's your choice to do that, you fucking idiot.
you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that
Elizabeth
correct?
Little's ready to fall asleep.
Correct.
Same questions
You said
multiple
you would
times.
like to have had more time, correct?
Correct. But I understood Your Honor's order, and I wanted to meet that deadline. So I worked as quickly as I could over the last week to ensure
plenty
that,
of time.
again, we could respect that deadline, and we completed our testing.
And with regard to the testing now that you
Oh, fuck
worked on,
them.
that you just described,
They have no idea what being harassed is like, and neither does he. So
does
you can
that
go fuck
testing
all the way off. Take
relate
several seats.
to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from Aperture that came in iterations through the month of February?
Yeah, she needs to tell him to move
It
the
would
fuck
be
along.
in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report in PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month?
Nobody
or so?
cares.
Could you done any of that work without receiving the Aperture report
Yeah,
and slides
You could
and
have.
scans?
Absolutely.
No, I don't even know what we would be responding to then.
So you needed
Is he
the
serious?
Aperture information before you could even start working,
They knew
correct?
what they were responding
Correct.
to. Somebody disagreeing with them. That's what the fuck they knew. Let's get real here.
Do you have in mind, or does ARCCA have in mind, any further testing that
No.
you need to do?
You're not
or
doing
have
any.
You completed
Nope.
what ARCCA needs to do
Judge
with
said no.
regard to fairly and properly responded to the new work of Aperture?
No.
I think we're satisfied that we've completed that testing, yes.
Yeah,
And
so
what, if
fuck off.
any, more work do you contemplate that needs to be done from, as you sit here
None, you
today,
just
going
said.
forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note obviously, as the court is aware, we've produced all of that raw test data, photographs, video. So it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully to my next question, which is there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order. Yes.
How long on an expedited basis? Well, let me ask you. In the ordinary course, how
Just
long
ask
would
the
it
same
take
question
you to
3
do this
fucking
last
times.
part of your work in the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping if it pleases the court, hopefully May 7th will work.
No.
And so you believe everything would be completed by
No.
May 7th?
Correct.
That's all I have at this point, Your Honor.
Right.
Oh, good. So now you remember all your phone conversations, sir, correct? You don't remember having lunch with them? No? Oh, great. Wonderful. You have such a great memory when it comes to them.
Doctor, you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
You said if you were notified or received information, you could have your testing and opinions done
Nick rolled his
within
eyes
a month.
because he doesn't even
Correct.
understand what he's listening to.
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
The report?
Yes.
I didn't know that.
And
No.
the file in its entirety by February 5th? Did you know that? Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had justice as well as ARCCA, yes.
Putting aside the authorization, I'm going to ask you about the time you received the information by February 5th. You could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now. So wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True?
Again, I don't know the timeline in terms of
You can't
what
even
exactly
answer a
was produced
simple
when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to
Can't
deal
answer
with
a simple
information
question.
You said you could have done in around.
You just want to agree with anything.
I think a month or more, yes.
So your contract with the federal government ended, ARCCA's did, in June of 2024, didn't it?
I believe it was sometime last year,
Do
yes.
you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by ARCCA or the defense to try to facilitate an agreement that the defense could use ARCCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March that the defense wanted to use ARCCA, or specifically you and Dr. Renchelier, in late March of 2025?
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Renchelier so you could review the materials?
Objection, Your Honor.
Do you know? Do you happen to know that?
I don't know, no.
Next question.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
One that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No, it was just verbal communication.
And they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Said in trial,
the Department of
that's the first
Justice?
you heard of it.
Yes.
Did you know there was a sequestration order in this case that you
Yep.
were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. You recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
So as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read, if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month, to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new, and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided the report, how many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstrate, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one. So
Okay.
no, I want you to focus on.
Okay, no, that
trial
was
one.
not produced, no.
Never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided in
So-
response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round.
I don't think I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We
asking
have
you.
provided everything that he would need to evaluate the testing that we
Not what he's asking
If he
you.
wants to evaluate the testing you did the first time, are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
Yep.
I don't know what the defense's plan is for us. My
You
understanding
don't
is
know
that
what your
is to
plan is?
evaluate
Not that
and
plan,
respond to Dr.
your
Welcher.
plan.
All right, with that, I need to see counsel with that.
That answer just screwed them royally. He just said, I don't know what the defense's plan is for us. It's not about what the defense's plan is. It's about what your opinion is. So it shouldn't matter what the defense's plan is for you. Your opinion is your opinion is your opinion. That's it. The defense's plan does not matter. That is why she asked him to go to sidebar. Because with that answer, it just shows that he's going to do what the defense wants him to do. Period. Just screwed himself. Good job, Dr. Wolf. You absolute fucking liar. Good job, sir. You can't even answer a straight up goddamn question. Not a single one. And that is half the problem here. I don't even think they're going to do Rentschler. They don't need to. I don't know what the defense's plan is for us, was his answer. Said the quiet part out loud, my dude. Said the quiet part out loud. Good job, Hank. Good job. Yeah, that's the thing. Hank is many things, but never confused. That's for sure. He's talking about trial 1. How can you purposely give an opinion? How can you give any opinion? How can an expert for the Commonwealth give any opinion without actual pieces of things to go over that ARCCA did? You can't without the raw data. You can't. It was unfair to the Commonwealth for the judge to allow them in to begin with. They needed to find their own expert, not use the federal government that was clearly very shady to begin with. You know, if she does, she's an absolute fucking idiot. Because Karen is the one that's accused. The family can't just go to a sidebar. But Paul has he's got a real good hearing, and he's real close to where they are. You know, I never think that she will do what she probably is supposed to do, which is exclude them completely at this point. It's very clear that they're biased. It's very clear that what they're doing is, I would shut this down as fast as humanly possible.
You're all set. And let's bring Dr. Rentschler in here, please.
Thank you, Your Honor.
Okay.
Follow me, sir.
We're going to try to get it done today.
Thank you.
Follow me, sir. Step line up, turn around, take the clerk, and raise your right hand, please.
Do you solemnly swear that the testimony you shall give to the court and the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I know I'm muted. I'm just yelling at the thing. Hit the like button,
All
subscribe
right,
button.
Dr. Rentschler, this is going to be very quick.
If you can.
Go ahead, Mr.
donate
Brennan.
to
We
the-
just need his name.
To the channel.
Good afternoon, Doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
At a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
Okay. How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than texts or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I...
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
I don't believe that ARC has any specific policy for that, no, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean?
Yeah.
Well, certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order? That there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an opinion.
You make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done?
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite it, yeah.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right. I'm going to see counsel at sidebar for 1 minute.
Why sidebar? We should be able to hear what's going on. We should be able to hear what's going on. Yeah, there's no reason she should even be asking. In
That's
my
it.
opinion.
Thank you.
That's it. So we're not gonna
All rise to the court, please.
get an answer. Oh, that's wonderful.
Goodbye.
Shocker. She just wants to get out of there.
Yeah.
Go
what
for it.
a fucking insane situation where, Neutral Crash Daddy was fucking on Signal app, which is mostly used by drug dealers and other people that want to keep their communications not, recorded. And I'm supposed to believe this guy is not going to bill, he's going to go on Signal app and have recorded not billable hours when his entire business is billable hours. Oh my God.
Come on, man.
And then he's like,
Right.
we'll get the stuff. Do you know what today is? Today
I'm
is-
sorry, but
What were you guys saying?
Yeah, the 28th.
28th.
Yeah.
So they said
the
they're going to
28th,
be
but I think
they're going to be done by
Oh,
May
oh,
7th.
hold on, let me
trial
mute.
watchers, you know what a lot of the trials we cover.
No
They're
way.
gonna be-
no fucking
they're
way.
gonna-
That's the thing. And then it's done by May 7th, but then the Commonwealth's expert has to go over that as well. It's not fair.
I think she's not going to let them testify to the new stuff. I don't think they're going to let her.
I don't think she's going to let Dr. Wolf testify to anything at all.
Right. I think there's a
At
possibility that
all.
she'll
I
let
don't think
them.
she does that.
I think there's a possibility to testify about what they previously did, but I can't imagine it being fair because you have to realize, yeah, you have to look through this stuff, and one day is not enough. Like, I'm sorry, like we're literally almost in the second. We're in the second week of this trial. So 3 weeks into the trial, you want to, submit reports that are 800 gigabytes of data to the other side and say, oh, you have 6 hours to go through this.
A week? Yeah, no, absolutely not.
Didn't ARCCA party with Cameron? Yeah, that's what he talked about. See, what happened was is
Yeah,
that the other guy that was on the stand, he had lunch with the father. There was a picture that came out.
Yep.
He was hanging out with the family, having lunch.
Yep.
And that's why he couldn't
That's all I
lie
do.
about
Come
that.
on.
Yeah. So
I mean, let's get real. I predicted what happened here. I knew Dr. Wolf was not going to bring in anything because it was all going to be damning. So I knew he would say, oh, nope, it's all gone. It's deleted. You don't think the judge knows what the fuck that is? Signal? You don't think that raises some serious issues? Jackson magically all of a sudden wanted to talk on Signal where it couldn't be recorded. Come on, man.
I guess they're done for the day or something. Or what's with the...
Yeah, they're done. She just
They're
got up
done.
and said, okay, bye. Like, no, we need to know what's like, why?
Like,
I'm not
Can
understanding.
we
Like, she was saying, what the fuck?
Can we actually work a little overtime with this? Like, this is why this trial is taking fucking forever. Like, there are so many other trials where they literally work to 7 o'clock at fucking night to get shit done. This lady's like, well, we're done 4:30.
She didn't
Let's
even wait
go.
till 4:30. She's just like, yeah, bro, it's close to 4:30. We gotta get the fuck out of here. Bye. Like, lady, did you not just hear Dr. Wolf say, I don't know what the defense has in store for us. So you just admitted to only doing what you want the defense to do right then and there. And that is why I believe she stopped it right there. Was she said, with that, I'm going to see counsel at sidebar.
Yeah, I think there's two options. I don't think they're going to allow the new stuff to come in because that would be such an unfair situation for the prosecution. And I don't think that I don't think they're going to kick them out, but there's a possibility because there's some major problems with these people. There's Signal apps being talked to. There's 100 text messages being deleted. I don't believe that shit with I got a new cell phone and all that shit was deleted. Are you fucking kidding me? Like, you're telling me that you got a new cell phone and you didn't
I had a new cell phone though, but then it was, yes, I did delete all the messages. So first he was trying to pass it off as if he just got a new cell phone. But then when Brennan was like, well, did you delete them all? He doesn't know what Brennan knows or doesn't know. So then he has to admit to deleting them. So he tried to pass it off as if only just got a new cell phone. Dude couldn't even answer a very simple, straightforward question that you would have had to answer yes or no. Or he couldn't even do that. He wanted to dance around and not give the Commonwealth anything, even if it was mundane. And that is exactly why I found him not credible in the first trial.
Yeah, there's a problem with this guy. The first guy is definitely there. I don't think this group should be even used, to be honest with you. If I had my opinion.
Nope. If I was
Something's
a judge, I'd be out.
There is a possibility that you could be right, and there's a possibility they just let them just testify to what they previously testified and don't let any of the new reports in, because it's kind of outrageous to be in the middle of trial and then be like, yeah, we need a week longer while we're in the middle of the trial so we can submit reports that you're going to have to rush through
to what they did before. They're going to have to give the raw data on that. They're going to have to give the videos. They're going to have to give all the raw data on it that they were under the quote federal protective order the first trial.
I don't like Hoffendorfer. She's a fucking idiot. I don't trust anything that woman says. To be completely honest with you,
I watch a lot of shows, but hers isn't actually one of them.
Yeah, I don't like Hoffendorfer. Look at the Sebastian Rogers case. She's a bumbling moron who's friends with Nick the Hat and Dog the Bounty Hunter, who lost their anti-SLAPP lawsuit against two Pennsylvania YouTubers who they were trying to harass and silence. So fuck her. I don't like Hoffendorfer, and I don't take any of her opinions actually legitimately seriously.
I mean, she's an ex-FBI agent. She's not an ex-attorney. She doesn't really know much about the law. She knows much about what she did for the FBI. That's really pretty much it, you know?
Yeah, I don't like Hoffendorfer. Don't ever listen to
Oh,
that woman.
last opinions, B. Tim. I'm gonna wrap this bad Larry up. I'm tired.
I think I think she's gonna let them testify, but I don't think they're gonna let them testify to the new stuff because it's really unfair to the prosecution to add this new stuff literally 3 weeks into the trial. So
Yeah.
and I think it's pretty shocking. I think that if Jen McCabe was talking to people on Signal app and had 100 deleted text messages, the whole internet would blow up.
Oh, absolutely. 100%. 100%.
Oh, I get it. I'm not mad. I'm sorry, I sound a little mad at you. I just don't like that woman. That woman.
He's not mad at you, believe me.
I'm mad at. I don't like that woman. I swear to God, one day if I ever see her on a panel, it's going to be a very explosive panel. Believe me. Like I'm just telling you now, it will. If I ever go on a panel with her, it's going to be one for the ages because I do not like. There's a lot of questions.
goddamn ages.
There's a lot of questions this woman better answer.
Right.
Anyway, but that's my last point on that one.
Love it. Thank you, B. Tim. Always appreciated, my friend.
All right. You have a good one. Bye.
You too. So last thing I have to give to you guys is this. This was an explosive day. We had a lot of information, a lot of jaw-dropping information, Signal apps, deleted 100 text message, which, by the way, I called, once again, predicted it. Yep, that'd be me. Pretty good on these predictions, just saying. The SCOTUS completely denied looking at Karen's case, like I predicted as well. And I think at this point, she stopped the testimony with Dr. Wolf right after he answered that question. That is very suspicious to me, extremely suspicious to me. And I think he sealed his own fate with that. So if he is allowed to testify, he will only be allowed to testify to a very small scope of things at this point. I think what she wants to do is have Dr. Rentschler testify to his part of the report and his part of the testing. Dr. Wolf has basically sealed his fate with not even answering straightforward questions and sort of trying to dodge those. That was very intense. Crazy. But we'll be on always 8:30 in the morning. So we will go over some of this in the morning, and we have a Discord, so y'all can join that and talk about it, of course. We have some great conversations over there in Discord. Even as we're live, there are people talking in Discord. So do me a favor on you guys' way out. Make sure that you hit the like button, you hit the subscribe button, donate to the channel if you can. It's very slow on trial days. We don't get a lot during trial days, unfortunately, even though they're longer days. And so we very much appreciate the support. We need it. We're only a small channel, so we only survive when we get the support of our lovely people. Even if you're on the replay crew like Jack was yesterday, if you make one, we will read it in the morning, as I did Jack's today, to say thank you, of course. Also, I take serious offense to Dr. Wolf talking about harassment. He has no friggin' idea what harassment is like. I've been dealing with it since 2023. His wife went on a Free Karen Reed page, and then he wants to whine that people wrote him emails that he committed perjury. Well, you did commit perjury, so cry me a river. I don't know what to tell you. I love your stinking faces. Hit those buttons on the way out, and I will see you all in the morning. Bye.